Is that the last thing we have is a split? I see it. Okay, we'll take care of that and do the plea. Shift these other things. All right. Okay. All right, folks. We're going to go to the add-on count at this point in time. State of Georgia versus Jesse Medrano. Is Mr. Medrano in the? He's in the tank. Can we bring him out, please?
Judge, a lot of my notes are on my computer. It's outside right now.
Say again?
My notes for this case are on my computer, and they made me turn it.
Oh, you can have it. You can bring it in. He can have his computer. Is it outside the courtroom? Do you need to go get it?
Do you mind?
What's your first name? You know?
This one is the re-indictment. This one needs to be more. Alright, so you'll submit me right now. In this case, it has a phone, so I don't know these.
He's been quiet.
How you doing there? So I spoke with the DA today, and we're supposed to get the case resolved. Okay, we're talking about maybe like a 10-3 or something like that. So she just needs to speak with the victims. She's new to the case. Right. Yeah. There's another neighbor who's like apparently.
She told them they want to the neighbor.
Yeah. So let me just get everything geared up here.
Mr. Melvin, let me know when you're ready.
I'm ready, Judge. What's her name again? Dearica? Your girlfriend. Sheree.
All right. Good morning, council's interested parties. We're here on the record of the matter of the state of Georgia versus Jesse Medrano in 3 matters. First one being 20 SC 175993. Second matter being 21 SC 179680. Third matter being 21 SC 179871. Good morning, Mr. Melnick. Good morning, Ms. Hunter. And good morning, Mr. Medrano. All right. So at this point in time, Mr. Melnick, what brings you before the court at this point in time? As I understand your, is it the bond hearing
Bond motion.
on 21 SC 179871?
That's correct, Judge.
Okay.
That's the arson case, correct?
Okay, all right. And is that a re-indictment of
It is. It's
21 SC 179680?
Yes, Your Honor. 88 Hunter, it is a reindictment for the case in 993 or 8680. The state intends to submit an all-cause order to the court today.
Okay, if you'll submit that to Mr. Chamberlain. Do you have any objection, Mr.
No, of course not, Your Honor.
Mr. Melnick? Okay, all right. Then that case, that case will be null prost as it was re-indicted. Okay, all right. So Mr. Medrano has bond on the matter ending in 5993.
That's correct.
The drug case, as I understand. Okay, all right. So we're here to discuss the issue as to bond on the matter ending in 9871. So floor is yours, Mr. Melnick. You want to tell me what factors? I mean, tell me no factors. Tell me the IALA factors and other things you wish me to consider for bond. Okay.
Thank you, Your Honor. Good morning. He has been in continuous custody since December the 20th of 2020. Mr. Medrano is 36 years of age. He has lived in the Atlanta area his entire life, Your Honor. His mother lives here. His brother lives here. He has children who are dependent upon him for support that all live in Atlanta, in Fulton County. So he has very, very strong ties to the Atlanta area. Obviously, he has been gainfully employed all of his adult life. He was working in the music industry at the time of his arrest and working with his brother, Corey Medrano, and he will have employment waiting for him upon his release from custody. I have not received discovery in this case, Judge, and this case has been through the hands of at least 5 different assistant district attorneys in the DA's office since I've been representing Mr. Medrano. It obviously got caught up in the COVID delay and was indicted fairly recently, despite Mr. Medrano's lengthy stay in jail. So I don't have his entire criminal history, but he certainly has nothing similar to what he's being charged with today on his criminal history. I know that for a fact. Your Honor, I've spoken with the victim in this case. They have had a relationship with one another for a long period of time. She does not wish for Mr. Medrano to remain in custody. She has told me on more than one occasion, she's actually been in continuous contact with me, that she would like for Mr. Medrano to get out to help her support their children. And he's always been there for his family and for his children. He's waited in jail for a very long time, waiting for some sort of resolution in this case. And through no fault of his own, this case has just been delayed for a very, very long period of time. We had one bond hearing on this case pre-indictment where bond was denied. But Your Honor, I think given his ties to the community and the length of time that he has stayed in jail with no bond, I'm just asking you to grant a reasonable bond, $25,000 with him on an ankle monitor, and to have no contact with any alleged victim or any other witness in this case.
Good morning again, Your
Okay,
Honor.
go. I apologize, Ms. Hunter. I'm just kind of reflecting at this point in time. Go right ahead.
So the state has been in contact with a few of the victims, particularly the main victim, Ms. McMillan, who does have children with the defendant. There are at least 11 victims in this case, and Your Honor has probably already heard the facts. But Ms. McMillan's home was burned down to the ground. It was a townhome. But there are several other neighbors who live close by, including 10 other victims. They either had total property damage due to the smoke-induced water damage. And there are several victims who are also witnesses in the case who saw the defendant in this case running away from the scene. The state has been in contact with at least 3 of those victims and also 2 witnesses in the case. But as far as the IALA factors, the defendant in this case is a risk of flight. He has 4 prior FTAs, 2 out of Fulton County, 1 from 2006 and 1 from 2017, 2 out of Cobb County, from 2017 and 2018. The day of the incident, and that's November the 20th of 2020, the defendant also fled the scene of the incident after causing the fire that damaged at least 11 residences. He was witnessed getting into a vehicle after running through several backyards with a red gas can in his hand. He's also a risk or a threat to persons and property in the community based off the nature of his criminal history. He does have 2 prior felony convictions, 2 out of Fulton County, that's 06 SC 51025. He was convicted in 2008 of aggravated assault and a robbery. Also 07 SC 61156. He was convicted of an aggravated assault out of Fulton in 2008. And that sentence ran concurrent with the 06 case. Also, he is a risk to persons and property in the community based off the nature of these charges. Again, there were 11 victims who lost either their entire homes or had significant property damage. He's a threat as far as committing felonies pending trial. As you stated earlier, he has the open pending drug case, 20 SC 175993. He also has an unindicted case, 20 CP 195853. That's also a drug case, Your Honor. And he is a risk to intimidate witnesses. Your Honor, the state did speak with the victim, Ms. Cherie McMillan. She does have 2 children, at least 2 children by the defendant. The defendant does speak with the children. However, Ms. McMillan has stated that the defendant does not know where she resides. She does not want him to know where she resides. The state also spoke with at least 1 other witness in the case who was very familiar with the conduct of the defendant going back and forth to the victim's residence prior to this incident, causing damage to the home. She has stated that, speaking with the victim initially, that the defendant was making calls to her home from the jail when he was initially arrested. And also that if he were to get out, that he would probably be a threat to the victim in this case. And again, the victim has expressed that she does not want him to have any contact with her. They do have children together, so that if he were to communicate with the children, it would be via her mother or her mother. So at this time, the state is requesting that the defendant receive no bond.
All right. Councils, Mr. Melnick and Ms. Hunter, based on what Panya proffers this morning and what I've heard thus far, in particular, the risk of flight with 4 FTAs, Mr. Melnick doesn't give me pause in this case. For that reason, I'm going to go ahead and deny bond at this point in time. I find specifically is a risk of flight in particular. But what I will do is I will set it for trial immediately. Mr. Chamberlain, what's our next available trial calendar that we can place these 2 matters on for trial? He's on the October 10th calendar? Okay.
Judge, Ms. Hunter and I had discussed this this morning. Do you have any dates available in August, maybe? We may be fairly close to getting these cases resolved.
Yeah, if you all should resolve the matter or you're in a posture to do that, reach out to Mr. Chamberlain and I will go ahead and we'll make arrangements for him to resolve this case. We can either take a plea via Zoom or if I'm able, more than likely I can probably take a resolution via Zoom. That would work out just fine.
Okay, thank you, Judge. I'll let you know when we get it ready. Thank you.
Okay, unless there's anything else, y'all may be excused, okay?
Okay.
Okay, thank you. All right, can we bring out Ms. Tigner, please? Okay. Oh, it was withdrawn? Thank you. Okay, all right. That was position number 5 on the calendar. All right. Okay, Charles Hollis. Yeah. Mr. Geary, Mr. Steele, after this plea, I'm going to take just a brief comfort break, and then I think we've cleared all the freight. I can kind of go ahead and begin with y'all's matter, okay? Thank you for your patience. All right, good morning, council's interested parties. We're here on the record in the matter of the state of Georgia versus Charles Hollis in 19 SC 170388. Good morning, Mr. Simonoff, and good morning, Ms. Willingham.
Good morning, Judge.
All right, as I understand it, this is going to be a negotiated plea, is that correct?
Yes, Your Honor.
Yes, Your Honor.
All right. Ms. Willingham, what I'm going to do is I'm going to swear in Mr. Hollis, and you can take care of the plea colloquy and the factual basis, okay?
Yes, Your Honor.
All right, you just need to speak up a whole bunch, all right? All right, thank you, madam. All right, Mr. Hollis, can you get your raise your right hand for me, please? Do you solemnly swear or affirm the evidence you'll give in the case now and hearing should be the truth, the whole truth, and nothing but the truth, so help you God so affirm?
Yes, sir.
Okay, all right, thank you, sir. You can put your hand down. All right, Mr. Hollis, over the next several minutes, you're going to be asked a series of questions by my prosecutor, Ms. Willingham, as well as the court. Those questions are not designed to embarrass you in any way. The court, as me, I have to determine a couple things. One, that your plea is freely and voluntarily entered. Sir, I'm over here, sir. Over here. All right. Plea is freely and voluntarily entered, and that there's a factual basis for your plea, because in our American system of jurisprudence, we don't make people plead guilty. All right. So I have to make sure you understand those rights, and you voluntarily waive those rights or give those rights so I can enter a plea against, I can enter sentence. Okay.
Yes,
All right.
sir.
So if we ask some things about how old you are, how far you went to school, that's the purpose of those questions. Okay.
Yes,
All right,
sir.
you need to answer oddly. I'm not trying to be difficult with you, but we need to be able to make a record. So if you could speak up as well. But
Yes, sir.
okay, all right, wonderful. All right, Ms. Willingham, go ahead now.
State your name, your age, and your date of birth.
Charles Hollis. I'm 22, 7799.
Are you now under the influence of any medicine, drug, or alcohol?
No, ma'am.
How far did you go in school?
9th grade.
Can you read and write in the English language?
Yes, ma'am.
Have you had the opportunity to review the document that charges you in this case?
Yes, ma'am.
Do you fully understand the nature of the charges pending against you?
Yes, ma'am.
By pleading guilty today, you are giving up certain rights. The right to a trial by jury, right to be presumed innocent, right to confront any witnesses that may testify against you, the right to subpoena any witnesses for your defense, the right to testify yourself and to offer any other evidence in your defense, the right to have an attorney to assist you throughout the trial proceedings, and the right to not incriminate yourself. Do you understand that if you were to plead not guilty or remain silent and enter no plea at all, the state would be required to have a trial on these charges by jury?
Yes, ma'am.
You are pleading guilty today to hijacking a motor vehicle in the second degree with a minimum sentence of 1 year and a maximum of 20 years. Armed robbery with a minimum sentence of 10 years and a maximum of 20 years. Aggravated assault with a minimum sentence of 1 year and a maximum of 20. Possession of a firearm during the commission of a felony to serve 5 years consecutive, and possession of a firearm by first offender probationer with a minimum sentence of 1 year and a maximum of 10 years. Do you understand you are not required to plead guilty to the charges unless the grand jury has heard sworn testimony and then charged you in an indictment?
Yes, ma'am.
Are you now serving any other sentence in confinement, or are you on probation or parole for anything, anywhere?
No, ma'am.
You heard me tell the court what the negotiation in this case is, which is 15 years to serve 7 with a balance probated. Do you understand the maximum sentence on each charge and can run those sentences consecutively or one after the other?
Yes, ma'am.
Do you understand, however, that if the court does not accept this negotiation, you have a right to withdraw your guilty plea today?
Yes, ma'am.
Should the court sentence include a period of probation, you will be required to obey both general conditions of probation and special conditions of probation. You will be required to follow the general conditions of probation that probation will give to you when you meet with them, including but not limited to that you are not to violate the criminal laws of any governmental unit. For special conditions, you are to have no contact with the victim, in this case, Lauren Dollar. Do you understand that a violation of any of these conditions could lead to a revocation of your probation?
Yes, ma'am.
Are you entering your plea of guilty with the understanding of everything we just talked about?
Yes, ma'am.
Has anyone used any force, threats, or promises which caused you to plead guilty against your will?
No, ma'am.
Are you satisfied with what your lawyer has done for you in your case?
Yes, ma'am.
Do you have any more questions for your lawyer before we go on?
No, ma'am.
Have you understood everything I have asked you so far?
Yes, ma'am.
Understanding all of your rights, do you wish to enter a plea to these charges today?
Yes, ma'am.
Is your decision to plead guilty made freely and voluntarily?
Yes, ma'am.
Did you in fact commit the offenses to which you are pleading guilty?
Yes.
Are the facts in this case, as I previously told the court, generally true and accurate?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
If you wish to challenge this plea for legal error, you have one of two ways to do it. Your lawyer can explain what these ways are and how they work, but I must advise you of some time limits. The first way is a direct appeal. You have 30 days from the date of the sentence, from the date the sentence is entered to file this appeal. The second way is a habeas corpus petition. For felony offenses, you have 4 years from the date the sentence is entered. Do you understand these time limits?
Yes, ma'am.
Do you understand that you are not allowed to possess firearms during the course of your probation?
Yes, ma'am.
Do you understand if you are found in possession of a firearm, you could be charged with another felony which carries up to 10 years in confinement?
Yes, ma'am.
Your Honor, if the state were to go to trial in this matter, we would prove beyond a reasonable doubt that Mr. Hollis and an unknown male cut in front of the victim, Lauren Grace Dollar, as she was in her 2014 Chevrolet Camaro vehicle in the parking lot at the above stated location, which was in Atlanta, Georgia. The accused exited the rear of the Ford vehicle that the males had arrived in and pointed a handgun at the victim and demanded that she exit her vehicle.
Is this addressed in Fulton County, madam?
Yes, Your Honor.
Okay, all right. You go ahead
My
and continue.
apologies.
Go ahead and continue. Because Atlanta's in 2 counties, so just want to make sure,
Correct.
right?
Sorry.
That's okay. All right, go ahead.
The victim complied, and the accused and the other male drove away with the victim's vehicle, purse, wallet, and cell phone. The victim's vehicle was recovered the next day at Spring Valley Apartments in DeKalb County. The vehicle was processed, and a key fob to a Ford vehicle was found in it. A latent print was found in the victim's vehicle. On May 22nd of 2019, DeKalb County Police advised they arrested the accused in their jurisdiction. Some of the victim's property was found near a fence line at the apartment complex where the accused was arrested. After the officer interviewed the accused, the latent print that had been found in the victim's vehicle was determined to belong to the defendant's girlfriend. The accused then stated that his girlfriend steals cars, but denied that he had anything to do with the victim's vehicle. A photo lineup was created and shown to the victim in this case, and she positively identified the defendant, who was also a first offender probationer.
Okay, anything else, madam?
Nothing further, Your Honor.
Okay, all right. Mr. Siminoff, good morning, sir. Anything on behalf of your client?
Your Honor, we are asking for credit for time served back to May 22nd, 2019. He has been continuously in custody between here and DeKalb County for this case since that date. And other than that, Your Honor, we stipulate to a factual basis and ask that the court follow the recommendation as stated by the state.
I'll go ahead and give him credit from May 22nd of 2019 off any adjudicated sentence, okay?
Thank you, Your Honor.
All right, Mr. Hollis, good morning, sir.
Good morning.
Sir, do you have the opportunity to fully discuss the facts and circumstances of this case with your attorney, Mr. Siminoff, to your satisfaction?
Yes, sir.
Did he explain to you the various constitutional rights you give up by pleading guilty to your satisfaction? Those are the same rights that my prosecutor, Ms. Willingham, just set forth on the record a few minutes ago. Do you have any questions about those rights you wish to ask me?
No, sir.
All right. I'm holding up a copy of the indictment in this case. On page 2, is this your signature above the word defendant?
Yes, sir.
All right. Did you have the opportunity to fully discuss the facts and circumstances and the counts of this indictment to your satisfaction?
Yes, sir.
Did Mr. Siminoff explain to you the various counts therein to your sasatisfaction?
Yes, sir.
Do you have any questions about this indictment?
No, sir.
Anything you want to ask the court as to?
No, sir.
All right, I'll note that the indictment's been signed, the plea has been entered. Mr. Hollis, based upon the responses you've given to the court's inquiry and colloquy, I find that your guilty plea is freely and voluntarily entered. I find a factual basis for your plea, and I'm going to accept your plea as tendered and as negotiated. To count 1, hijacking a motor vehicle, you are entering a plea to the lesser included offense of hijacking a motor vehicle 2nd degree. The court will sentence you to 10 years to serve 7 years. On count 2, and with a balanced probate, I should say, on count 1, let me complete my thought. As to count 2, armed robbery, this court will sentence you to 10 years to serve 7 years with a balanced probated, and that is a deviation from the mandatory minimum under 17-10-6.1E, and I'll run that concurrently with count 1. As it pertains to count 3, aggravated assault with a deadly weapon, this court will sentence you to 10 years to serve 7 concurrent with count 1. And as it pertains to count 4, possession of a firearm during a conditional felony, this court will send you to 5 years probation consecutive to count 1. And then on count 5, the possession of a firearm by a first offender probationer, this court will sentence you to 5 years concurrent with count 1, and the special conditions of your probation would be that you have no contact with the victim, in this case, Lauren Dollar. Can you do that?
Yes, sir.
You can do that. I'll make that the sentence of the court. So your total sentence in aggregate is 15 years to serve 7. I'll give you credit from May the 22nd of 2019 toward the adjudicated amounts that the court has already announced in the sentence, and the balance will be on probation. Then that'll be your sentence. Counsel, that is Mr. Siminoff and Ms. Willingham, any clarifications on the court's entry for your sentence or defendant's entry of plea?
No, Your Honor.
I have a question. Mr. Siminoff,
Yes, sir.
so that's May 22nd, 2019. When did he hit the Fulton County Jail?
He was in Fulton.
Well, it says August 15th, so did
Yes.
he come, was he?
He came from DeKalb directly to Fulton. He had a hold in DeKalb the whole time.
I'm going to give him credit for all his incarceration from that
I
time.
just want to make sure I put that right in time or that date. Coincide right into August, April 15th through the present.
I'm going to give him credit for from the time he's been in custody, regardless from May the 22nd of 19. Yeah, that'll be included. That'll be
So
included.
that's what I'm saying.
But he'll get credit from, so he's been was he in DeKalb or where was he from?
He was arrested in DeKalb and spent some time in that jail and then got transferred here.
So his arrest date was May 22nd
Yes.
of
And he's been-
2019.
Yes, and he's been continuously incarcerated since then
And then he came over to us
to Fulton.
on what date?
4/15/2021.
Okay, then he'll get credit for both those periods of time toward his adjudicated sentence. All right, anything else, Mr. Chamberlain?
No, that's it.
Okay,
Your Honor, probation question.
madam,
Could the defender remain up until I come speak with him? Your Honor?
are you coming to up to the courtroom?
Yes, I am.
Okay, that's fine. I'll tell the folks here to hold them up for just a little bit, okay?
Thank you.
All right, thank you. All right, unless there's anything else, that will be the sentence of the court. Good luck to you, Mr. Hollis, okay?
Thank you, Judge.
All right, thank you.
Your Honor, that concludes my business with the court. May I?
Yes, you may be excused, madam.
Same announcement, Judge.
Mine as well, Judge, may I be excused?
Yes, Mr. Peoples, why were you here?
Observing, I've just joined the office, Judge.
Okay, well, welcome aboard, and yes, you can be excused as well, okay?
Thank you, Judge. Have a good one.
Thank you, sir. All right, I think we've cleared the other freight and other matters, so folks, we're gonna be in recess for probably about 10 minutes, and then I'll go ahead and I'll come out and we'll deal with the other remaining matters, okay? All right.
What's up, everybody? Good morning. We in recess right now. So it sounds like we're gonna be in recess for 10 minutes, and we're gonna come back to the Young Thug bond hearing. Thank you, everybody, for hanging out with us this morning. Yeah, man, Mr. Blackwell, I normally would be on the Roger Report live right now, but I wanted to show this. Live. So we in the building this morning unexpectedly, because I didn't know that this would be on live right now. So we in the building unexpectedly. So, in case you guys are not familiar with the Young Thug case, Young Thug's real name is Jeffrey. He is the owner and operator of YSL, Young Slime Life Records, a multi-million-dollar record company of over 30 employees. He was recently indicted on a RICO. Him and his artist, Young Gunna. Young Gunna is from the Pushing P fame, #1 song of the year. When I say #1 song, I mean this song went everywhere. I mean, your grandmother may have heard this song, white, black, foreign, domestic. Everyone heard Pushing P. Pushing P featured Future, who is also a global artist. So there's a brand new district attorney in Atlanta, a young black woman. Now this is important because you should have gotten your ballot in the box. We all should have our ballots in the box. If you're wondering why you see so many distractions on the news, it's because we have a vote coming up, and we have what will be most definitely a lame duck president. Biden has not passed the signature legislation, and the majority that he has in the Senate and the Congress, he will lose in this upcoming election. So you have a lot of distractions. So you have this young man who's actually an owner of a record label, right? And you have him being indicted on a RICO on the state level. Now, most people hear RICO and think federal charges like FBI, like with the R. Kelly case. Well, this is not a federal RICO case. This RICO case is brought to bear by this district attorney, which is why I'm bringing up the ballot, because this district attorney was recently voted into office, right? So now you have a brand new district attorney in Atlanta, and if you're listening to the court cases this morning, there is an ideology and a methodology to how they deal with young black men and criminals in Atlanta. And this is why they continue. Mr. Blackwell is correct. Atlanta has become the Baltimore of the South. And it's because of the way they're dealing with crime. I remember an interview with Judge Joe Brown. Judge Joe Brown talked about when he was a judge and recidivism rates, and how most judges had an 80% recidivism rate when he came into being a judge in Los Angeles. Him and his black colleague said that they wanted to bring that down because it was part of their job as a judge. And I've never heard this before. I've never heard this before. Part of your job as a judge, what you get judged on is your recidivism rate. How often do people you sentence come back and reoffend? Because your job as a judge is to protect the community, right? Your sentences are supposed to make people better and make the community safer. You can't just throw everyone away, right? You can't just give time to everybody. They will eventually come out and society will get worse. Well, Judge Joe Brown understood this, and he understood that prison time would not help his recidivism rate. Judge Joe Brown said that if you give all this prison time, they come back, they reoffend. So I didn't know, but judges have a lot of other options they can employ besides prison time. District attorneys want prison time. The judge doesn't get paid off of prison time. The district attorney gets promoted off of prison time. The district attorney doesn't want you out of jail. The district attorney wants you to get the most time as possible so the district attorney could run on how much time you get. The judge is supposed to protect society. So Judge Joe Brown would give out probation, programs, job training, education, school. You know, the schools are owned by the state. You know, in California, you got the UC schools. You got state-operated colleges, state-operated schools. You got mandatory rehab. So Judge Joe Brown used all of these. You're going to have to go to rehab and get clean. You're going to have to go get your truck license or you're going to go back to jail. Right? You got to go get a truck license or go back to jail. You got to get rehab or go back to jail. You got to finish probation or go back to jail. But it was a combination of things, but not only prison time. To reform the person, to give them a new mind state. And this is how you keep society safe. Well, in Atlanta, if you listen to what we just heard in Atlanta, and I've been saying this from the beginning, Young Thug Jeffrey is a multi-millionaire, owner of a multi-million-dollar record company. Jack Harlow, who she did not charge, is a brand new Caucasian #1 artist. He was the #1 song, Jack Harlow, First Class. He was not indicted. Young Gunna, #1 song. So this is not a fake record label. This is not your cousin's record label. This is not your drug dealing cousin. We all got a cousin who sells drugs who claims to be a rapper. It's 2022. Okay? We all have a cousin who sells drugs who claims to be a rapper. This is not your cousin's rapper. This is not your cousin's rap label. This is a multi-million-dollar record label fronted by Lyra Cohen of 300, right? A famous person who owned Def Jam, right? With two of the #1 artists and two of the #1. I challenge you that Gunna and Pushin P, I think Gunna already won an American Music Award for the song, and Gunna probably would have won a Grammy for the best rap artist and the best rap song for Pushin P. I'm going to say that again. Gunna, just so people thinking about this is not, because this district attorney who you voted for in Atlanta has said that YSL is a gang and not a rap label. I just want you to know that Gunna possibly would have been nominated for a Grammy for Pushin P. Can anybody challenge me on that in the comments? Challenge me on a more influential song in 2022 from hip hop, not country, not Latin. Challenge me on a more influential song in 2022 than Gunna and Pushin P. It had the biggest impact. He had the biggest first week sales. He had the biggest influence to this day on late night talk shows, on daytime talk shows. You will hear commentators say Pushing P. Gunna in that song made Pushing P a household word, right? So I say that to say this. This is not your cousin's drug dealer's record label. This is a real record company, a real corporation worth millions of dollars with a multi-million-dollar record artist with the Grammy-nominated #1 song. This is a real record company. This is why the feds have not come in. Remember BMF? Remember BMF was posing as a record company, but they didn't have any records. They didn't have any #1 artists. They didn't have any record sales. Young Gunna is the most popular rapper. He signed the most popular rapper. Jack Harlow Caucasian rapper has the #1 song on the radio. This is not a fake record label. This is not a cover-up for drug sales. This record label is not a cover-up for gang activity. This is one of the most viable hip-hop record entities in the country right now. And this district attorney who you voted for is saying that YSL is a gang of criminal activity. And she has no proof. I'm just giving you proof that this is not your cousin's record label. This is a real corporation. And she arrested the CEO. Think about what happened with when they stole all that money on Wall Street. Not one CEO went to prison. Remember when they lied about my mama's house, your grandmother's house, the predatory loans, and they stole all the money from the American people? Not one CEO got arrested, and those employees still got their bonus. This district attorney in Atlanta arrested a CEO of a multi-million-dollar corporation in America without proof, and they have not given him bail. They refuse to give him bail. In Atlanta, this is all black DA, all black district attorney, black governor, black mayor. This is the CEO of a multi-million-dollar corporation in America with right. He is innocent until proven guilty, and they have refused to give him bail. I'm sorry, I've been going. Let me check the chat, Mr. Blackwell. Mr. Blackwell said, I remember hearing him speak on this. Judge Joe Brown, recidivism rate. My father says the same thing. He was in prison. He was a prison warden. I agree. Thank you, brother. He could be saved. That's right. This should be made to be a wake-up call and a swing for charge for both of them. Is this a BW? Yes. The district attorney, and I'm going to show the video of the district attorney because we got a couple minutes. This is a black woman. It's a black woman, this light-skinned black woman. I don't even know if she's native to Atlanta. But this is why, just the other day I heard a black man say, I'm flipping through YouTube. Just yesterday, I heard an ignorant black man say, I don't vote. He was talking to a young black man. He said, I don't vote, and I don't believe in voting. This is a black man on YouTube talking to another young. This is why you got to be careful who you listen to, who you follow. Let me say a prayer. I want everybody to know who watching me. I pray. I'm spiritual. So I'm going to say a prayer right now because I got to say a prayer for that 15-year-old. I got to say a prayer over that young man who heard that stupid shit yesterday. I want to pray for Young Thug and all the black people in Atlanta. Because this is real talk that I'm saying. This was a black man on YouTube who said, I don't vote. I don't think our vote count. And he was talking to a young black man. But this district attorney in Atlanta got voted in. See, black men, we so small-minded. When you talk about voting, it's not about the president. Yo, you know how your son gets suspended all the time? Well, guess what? The school board is a vote. The superintendent, you need to vote, brother. You need to vote. And not just for the president. You need to vote in your union at work. You need to vote. You need to vote for your superintendent. You need to vote. You need to vote for your supervisor. You need to vote for your local sheriff. You need to vote for the district attorney. Judges are voted in. Why would a black man tell another young black man that your vote don't count? Because he doesn't understand America and the vote. District attorneys are voted in. Judges are voted in. School board presidents are voted in. If you don't like your school, if you don't like your principal, you should be going to the school board meeting and voting and getting that motherfucker out of there. Vote, vote, vote. God, thank you for this opportunity this morning to come to you. I feel extremely blessed to have this platform, to be free, to have this voice. Thank you for the talents that you've blessed me with. I pray a covering over everyone in the audience. I pray a covering up to all those listening. Father God, I come to you this morning humbly, eyes closed, head bowed. I am so blessed. So it is very humbly that I ask, I request that you continually, divinely inspire this podcast and the message. Give safe passage to those who listen. I know some people listen while they drive. May this message be a blessing unto them. Bless the young men who are incarcerated. Touch their families, their mothers. People may forget that these individuals have mothers and sons and extended family. Our prayers go out to them. Wrap your arms around them, Father. Let them know that they are loved. We ask all these blessings in your name. Amen, amen. We love you. Thank you. So I had to get that out, man, because this ain't no joke. 15-year-old boy. 15-year-old boy just got sentenced to 10 years and 7 years and 7 years consecutive with 5 years probation. His life is gone. His life, no, it wasn't a violent crime. He didn't hurt nobody. I know he was just having fun. Now look, listen, that's not fun. That's not fun. That's something he should have never done. But a 15-year-old boy, I don't see no father. I don't see no mother. I don't see no pastor. I don't see no principal. I don't see no coach. He was in a car. He carjacked somebody. We don't know if the gun was loaded. He didn't hurt nobody, but he going to be gone for 20 years. When he gets out of prison, he's not going to be a high school graduate. He's not going to have a college education. He's not going to have any skill set to be able to feed him or any kids. He won't get out of prison till he's 25, 30 years old. Then what will happen to him at 25, 30 years old? In America, where the black man is on the bottom, you can't get a job, you don't got an education, what will happen? This is what Judge Joe Brown talked about with recidivism rate. You got a 15-year-old boy. He's already in hell. He don't have a mama. He don't have a dad. He don't have a community. He don't have anything. You know what they're going to do in Atlanta? The ideology in Atlanta is the crime bill. See, this is why I don't like the South. This is why I don't like blacks from the South, because no one is honest about the blacks from the South and the racism that they practice, the prejudice that black people in the South practice. This is crime bill ideology. Throw them away. Throw everybody away. We don't value ourselves. The ideology in that courtroom is throw black men away. A 15-year-old boy, he's a child. He's 7 years from 21. You don't stop growing till you're 25. You know who should be in jail? His mama, his dad, the community, the principal, because everybody failed him. Everybody failed. He's a baby, 15. Everybody failed him. And he gonna get 25 years in prison. What does he come home to? Already black men are the most incarcerated men globally. There are more black men incarcerated in America than there are people incarcerated in the entire globe. We still live in modern slavery. So a 15-year-old boy whose mother failed him, whose father was disenfranchised, the school failed him, the church failed him, the community failed him. I know, let's throw him in prison for 20 years. Tracy said her son is 15. Tracy, how stupid is that 15-year-old? How much of an idiot is that 15-year-old? That 15-year-old don't know his ass from a motherfucking doorway. You don't know your ass from a doorknob. My mama used to say that. You don't know your asshole from a doorknob. You 15, you are a fucking idiot. At 15, you don't even know how to wipe your ass. At 15, my uncle had to teach me how to wipe my ass. At 15, you don't even know how to wash your ass. A man in prison is going to teach him how to be a man. And let's pray he don't end up raping him and molesting. I'm going to say that again. I said a man in prison is going to teach him how to be a man, how to wipe his ass, how to wash his ass, how to brush his teeth, because he doesn't know yet, because he hasn't had parents. This is what you don't want to hear. So this district attorney has arrested 30 black men, including Young Thug, the CEO of a multi-million-dollar corporation. This district attorney has arrested 30 black men, including the CEO of a multi-million-dollar corporation. Goldman Sachs CEO ever get come into court arrested? Lehman Brothers CEO ever get brought into court and arrested? Any of those corporate raiders, any of those carpet baggers, anybody on Wall Street responsible for TARP or anything, did anybody get charged? They stole money. They broke the law. They broke the country. Not what they got bonuses. CEOs of multi-million-dollar corporations in America don't get arrested. Not only is this CEO arrested, but they're refusing to give him bail. Why? Because he's black? He has a Please, somebody in the chat explain to me why you wouldn't give him bail. He needs to run his corporation. Where is he going? He has a #1 artist with a record being released. He's a CEO of a multi-million. How does he not get bail? Can somebody explain that to me? Because, see, I'm not 20. I'm not 30. I'm 40. So the 20-year-olds and the 30-year-olds who do the show, they are in gangs. I'm not in the gang. I don't sell drugs. I'm coming at this from a grown man and an American citizen. This gentleman, Jeffrey, is the CEO of a multi-million-dollar corporation, and he has not committed a violent crime. Jeffrey has not committed a crime. All they have Jeffrey on is hearsay and illegal wiretaps. That is not enough to keep a CEO of a multi-million-dollar corporation incarcerated. The feds have not come in yet. Is this thing on? Am I on mute? The feds have not come in yet. The feds have, it's been over a month. The feds is not touching this case because you would get into corporate law. Why do you think the feds are not touching this case? Liar Cohen backs YSL. Y'all forgot who gave Young Thug YSL, right? Hey, Seti Nash, everybody doing this story. Who gave Young Thug YSL? If the feds come in, then you have to go back to 300, right? Then you go back to Lyle Cohen. They're not bringing Lyle Cohen in the court. They're not bringing 300 in the court because 300 is probably really doing some shit. You hear what I'm saying? 300 probably is really doing some shit. Lyle Cohen probably is really doing some shit. But see, they got the pass. That's why the feds haven't come in yet. Who forgot? Y'all forgot? I remember when Lyle Cohen gave Young Thug his own record label. He had an office in the 300 building. It said YSL. It was gorgeous. Everybody said Lyle Cohen is Young Thug daddy. Lyle Cohen loves Young Thug. Lyle Cohen gave Young Thug YSL as part of a record deal to keep him on 300. That was almost 10 years ago. Some of y'all might not remember that. I remember when Lyle Cohen gave Young Thug his first office space. YSL is a subsidiary of 300. 300, you remember 300 with the Migos? So the feds have not come in because of 300 and Lyle Cohen. What do we recall from the Amber Heard case? James Franco got brought into court. Elon Musk got subpoenaed, and Kate Moss. These are superstars and a billionaire. Kate Moss, do y'all remember Kate Moss from Calvin Klein? Superstars. These are not regular stars. Kate Moss, James Franco, superstar. Elon Musk, the owner of Tesla, billionaire, just bought Twitter, got brought into court. So if the feds come in, it is a high probability that Lyle Cohen, and now you got to look at 300's financial records. Woo! Let me get my coffin nail. Let me get my coffin nail, because I don't think y'all heard me. I don't think y'all heard me. You didn't hear me? I said you got to bring in Lyle Cohen, and you got to look at 300's. You got to look at 300's financial records. Do you think they're going to look at 300's financial records? Hello? Is this thing on? Liar Cohen, Tommy Mottola, Sony, Epic, the people who killed Michael Jackson, the people who killed Prince. Do you think that Lyle Cohen will allow his financial records to come into court? Is this motherfucking microphone on? Is anybody listening? Hey, this woman in Atlanta, she doesn't know what she got herself into. She's fucking with the wrong people. Liar Cohen, You motherfucking right. Sirism said liar Cohen. We could call him that, but the fact that Sirism said that is saying that he understands the power and position that this motherfucker got. Shout out to Sirism. Y'all make sure y'all tap in with my brother, man. This Bay Area shit, man. This real ism, man. I came to YouTube floating on a glass sandwich bag, man. That's all I had, man, with GAME and this wisdom, man. I've been spitting it to the ism to the highest, man. Check this out. Liar Cohen is influential. 300. Now, imagine Liar Cohen and what we know about him. What we know about him. If he is Liar Cohen, do you think he wants his financials in court? Do you think he can't have his finances in court? Tommy Mottola, are you kidding me? Tommy Mottola got armed guard. Ask Mariah Carey about these guys. These guys is the real gangsters. These guys are the real gangsters. Tommy Mottola, Liar Cohen. These are the real Donald Trump. These is the real gangsters. 300 was a gift to YSL was a gift from Liar Cohen. It's a subsidiary of 300. That's why the feds have not come in, because the feds would pull in Liar Cohen and 300. Come on, y'all. Come on, y'all. So now what you have is this district attorney playing a game because black men believe our vote don't count. Well, I got my ballot, bro. If what we should be doing instead of complaining, we should be voting, and we should be getting together. See, instead of buying gold chains, Young Thug, you know what the Italians do? They get politicians. Instead of buying a $1 million watch or $1 million ring, you know what the Jews do? They buy politicians. Your ass is sitting in jail because you bought jewelry. You bought cars. You could have bought a politician. You could have put some money behind the district attorney who was running for office. You could have put some money behind the superintendent. You could have put some money behind the mayor. You could have. That's what T.I. had. Y'all notice how T.I. don't go to jail? T.I. start buying real estate and politicians. Did you see T.I. standing with the mayor of Atlanta? That's because T.I. helped get her elected. Because T.I. learned as he got older and he went to jail, I'm not buying no more jewelry. Now, you seen T.I. with a big old chain? When the last time you seen T.I. with a big old chain? But T.I. owns half of South Atlanta. And T.I. was standing in COVID with the mayor of Atlanta. Do you know why? Because T.I. started playing the game the way Liar Cohen and those people play the game. Instead of buying a big old chain, I'm going to buy some politicians. Do you know George Soros has gotten, do you know how many people George Soros has gotten elected in the past 2 years as we've been changing as a country? And when the laws changed with Barack Obama and you can input corporate money, I think it's Citizens United, right? George Soros has gotten over 20 people elected across the country. Has anybody been paying attention to what's been happening in the country? Do you hear what I'm saying? George Soros has been buying politicians for the past 2 years. So when I say that rich white gangsters buy politicians instead of gold chains, Young Thug, you are learning a lesson today. Because you are a CEO of a multi-million-dollar corporation in Atlanta, you should have been in politics. But black men believe our vote don't count. Instead of Young Thug, instead of creating a gang, you should have been in politics, brother. You should have been buying real estate. You should have owned land, in just like Nipsey Hussle, that would have given you political sway. T.I., he's owned real estate, so much real estate, it gives him a voice in politics. They have to talk, the district, the DA, the mayor, the governor have to talk to T.I. because he owns so much property. He becomes a governor. Do you know a landowner, what was called a governor? You govern because you own so much land. If we're talking about European times, and we're talking about the landlord, when you own so much land in a state, you become a governor. I am now interjected into political conversation because I own so much land and resources in Georgia. I own waterways. I own oil. I own power companies. I don't have to run for office. But the politicians must speak to me before they make certain policy, because I'm the true governor of the state, because I own the land. T.I. bought land. T.I. bought politicians. Now T.I. has political influence. Everybody talking about his son. Oh, King going to jail. King, watch. I haven't seen King get in trouble. Have you seen King get in trouble? T.I. owns politicians now. T.I. owns land. He is a governor. It's a different conversation about his son. It's a different conversation about T.I.'s son. Do y'all is y'all listening? This is what real power in America looks like. This is what real power is. There's a different conversation about his son. Because he owns land. Because he got the mayor elected. Huh? So have the Koch brothers. Huh? Huh? The Rockefellers. Huh? Huh? Next time, Young Thug. Anybody love Young Thug? Play this for him. Play this for him. When you get out, brother, don't buy a chain. Don't buy any more diamonds. Buy some land. Own a piece of America. You know what I'm saying? Like Kanye West, like Rick Ross. Buy a significant amount of land to give you political sway in the state that you live in. And start investing in politics because it's legal. Citizens United. Research Citizens United. Research the Rockefellers. Research the Koch brothers, and you will never be in this situation again. As a CEO and an American citizen, as a CEO of a multi-million-dollar corporation and an American citizen, right now, Young Thug, they are treating you like you're black. You're not black anymore. Is anybody listening to me? Is anybody listening to me? Young Thug, right now, they're treating you like you're black, but you're not black anymore. You're not black anymore. You're not. You escaped blackness. You are a multi-million-dollar CEO. You are an American citizen, and they should be treating you as such. You should not be incarcerated. The only reason you're incarcerated is because you're being seen as a black man, and that's why she's calling what you own. She's calling your corporation a gang. And honestly, she should be embarrassed. She should be embarrassed. She should be embarrassed. All right, everybody. Thank y'all for hanging out. We're going to be coming back in a second. Thank y'all for hanging out. We're coming back in a second. Share the show.
All right, good morning, councils, interested parties. We're here on the record in a couple of matters. The first one being the state of Georgia versus Shannon Stillwell in indictment 22 SC 182273. Here for state's notice of conflict with defense counsel and arraignment and bond. Mr. Sharp, good morning, sir.
Good morning, Judge.
Okay, all right. I see you've been relegated to the cheap seats, and the fact that Mr. Steele and his entourage have taken up their seats. Would you like for us to provide you a seat?
I'm
Or are you
fine.
good right there?
I'm fine here. Nothing.
Okay, all right, okay, no problem. All right, just wanted to don't want you to feel you were left out. All right, and then the other position is the state of Georgia versus Jeffrey Williams, 22 SC 182273. Good morning, Mr. Steele, and good morning, Mr. Adams. And
Good morning, Judge.
all right, sir. And we are here on the state's motion to disqualify defense counsel and for arraignment and bond. Is that correct? All right.
Yes, sir.
Okay, all right. All right, let me first make sure that I have the aforementioned. Is there anybody else I was missing? So I just want to make sure I have. Mr. Williams, can you, all right, I'm going to mute you at this point in time, but we got you. All right, and then Mr. Stillwell? All right, sir, I see you on the platform. Thank you, sir. Okay, who is in S214? Violetta, can you unmute S214, please?
Sure.
All right, sir, in S214, what's your name?
Scott,
I'm sorry, one more time.
Michael Scott.
Maybe Mr. Rapoff, client, judge. I think that's not made for resolve.
Mr. Scott, we resolved your matter. You're free to go.
Sit back to get an understanding of what's going on.
Say again?
I was sitting back to get an understanding of what's going on.
He can't do that today. He said he's gonna come out and see you, okay?
Who?
Mr. Rapoff. Okay, he's gonna come out and see you, but at this point, I'm gonna excuse you for the day, okay? Thank you, sir.
Mr. Clevy, I think mine got muted again.
I'm gonna keep you on mute because I can't compete with the background noise from your location. So I'm gonna unmute you, okay? If we need to talk with you, we'll go ahead and unmute you, all right?
Yes.
All right, no problem. All right, before we go ahead and get started, folks, I've had the opportunity to read both the state's motions as it pertains to Mr. Shart and Mr. Steele. And I've also had a chance to take a look at the responses that were filed on behalf of Mr. Steele as well as Mr. Shart. And stated you can take it any way you want, but I think that the court, if I can frame just generally your issue in this particular circumstance for the state and maybe the defendant's position on it. For as it pertains to Mr. Steele, you're saying that there's a violation or there's a potential violation of 3.7, which is lawyer as witness.
Your Honor, we're withdrawing the 3.7 claim today.
Okay.
And Mr. Geary is going to explain
Judge,
that.
I'd like to explain that to the court.
Okay. All right. Well, go ahead.
Quickly. We have notified Mr. Steele that I personally interviewed the officer previous to us making the claim, and the claim seemed solid. As we further investigated concerning the hearing today, it became evident that the officer truly believed the statement that Mr. Steele, quote unquote, confessed. However, the rendition of what the officer went through, we don't think that legally qualifies, and we're not going to support that in this motion, and we're withdrawing that in this motion.
Okay.
The officer did speak with Mr. Steele, but the interpretation of what occurred is different, and we're coming in on the side that there was no confession given the completion of our investigation of that matter.
All right. So you're satisfied you will not otherwise
He's off our witness list, Judge.
require Mr. Steele to be to testify or be part of any foundation that.
Correct, sir.
Okay. All right. Mr. Steele, any objection to that? They're going to withdraw that particular issue as it pertains to as it pertains to lawyer's witness 3.7.
No, Your Honor.
Okay. All right. Madam, I apologize. Your name? I apologize.
Lizzie Rosenwasser.
Miss Rosenwasser, I can't see you without your mask, so
Here we go.
okay, now I see. Okay, all right, thank you, ma'am. All right. All right, and Mr. Smith, again, good morning. But I have all three of you now. Okay. Okay. All right. So that having been settled, that issue, at least as it pertains to Mr. Steele, the 3.7 issue has been withdrawn. You still have 1.7 and 1.9, and I guess you're going to make argument on that particular issue. To that effect, is that correct, madam?
Yes, Your Honor.
As well as, is that the same basis that you're moving to disqualify Mr. Sharp?
Your Honor, to clarify for the record, we are only moving to disqualify Mr. Steele. What we filed for Mr. Sharp was a notice of conflict. We believe that all of Mr. Sharp's conflicts could be waived. We are asking today, and I do plan to go into this further in my motions for both motions, we are going to be asking today to have all the affected parties, if they wish to, come in and waive those conflicts on the record. While we do appreciate the written waivers that Mr. Steele has submitted, we believe that to ensure that the record in this trial is perfect and has no grounds for appeal, and I will go into this further in the motions because we do still believe that Mr. Steele is conflicted. However, we believe that although Mr. Sharp currently has a conflict, that conflict could be waivable. So at this point, we would ask the court to inquire into that conflict because we do believe that Mr. Sharp's conflict, as it only affects a former client, may be a waivable conflict. At this point, a conflict exists, but that conflict could be waived under 1.7b, whereas we do not believe that Mr. Steele's conflicts are all waivable.
Okay, all right. All right, well, given that, then, Madam, I'll go ahead and let you proceed, and then I'll let Mr. Steele respond if he should so desire, because it appears that looking at 1.7, and that reads as follows: a lawyer shall not represent or continue to represent a client if there's significant risk of the lawyer's own interest or the lawyer's duties to another client, former client, or third person will materially and adversely affect the representation of the client, except as permitted in Rule 1.7B. And one second. And also, the court's had an opportunity to kind of take a look at the case law that the state as well as the defense has raised in this particular situation. And I've had a chance to take a look at particular Benucci Height, that's HEIDT versus the state, Wheat versus US. And it appears that what brings us here is that Mr. Steele under 1.7 is already kind of, because he's the lawyer that's representing his current client, has already made that determination that he can represent his client. But it appears that the case law then shifts to a couple of things and says that that either the court can inquire about a conflict, given that this is a criminal case with multiple clients, multiple defendants, and with multiple counts on its own motion. But if you are, the state is moving, or the other party is moving to disqualify him, that there has to be a violation of one of the violations under the rules of professional responsibility, and there should be some proof to that, or at least some particular Bernocchi, and that is BRNOCCHI versus Fortucci, and that's FORCUCCI 279 Georgia 460. It appears that in looking at Bernucci, that comment 15 to Rule 15, Rule 1.7 placed the primary responsibility for resolving conflicts of interest on the lawyer undertaking representation. That would be Mr. Steele. A court may raise the question when in litigation there is reason to infer the lawyer has either neglected responsibility, and imposing counsel may raise the issue where the conflict is such as to clearly call into question the fair or efficient administration of justice. And then, of course, the case law directs that to advise an objection from opposing counsel should be viewed with caution, and it can be used as a technique as harassment. So in order for you to have standing, which is one of the things Mr. Steele is raised, is that the lawyer having a conflict of interest simultaneously representing multiple defendants, which would in this case be formal representation. There must be a violation of the rules which is sufficient to serve to call into question the fair and efficient administration of justice. And then it goes on to say there's some, the Supreme Court, our Supreme Court has adopted or kind of mentioned what Texas does in Henry Robinson, where opposing counsel must provide substantiation. So I'm going to need to probably hear something on that. So from looking at Bernucci, I can raise the issue on my own, which I would have given what you said already. But what Mr. Steele is saying is that the burden is upon you, since he's already made this decision. He can potentially represent Mr. Williams in particular. So we'll start out with him to begin with, and then you can move on to Mr. Sharp, okay?
Okay, yes.
Okay, all right.
Your Honor, so our purpose today in raising this motion, first of all, and I do recognize the court's notice of the law saying that these motions can be used for harassment. That's not our purpose today. Our purpose today is to ensure that each of the defendants named in this indictment, and that includes Mr. Williams, but also Mr. Blaylock, Mr. Stillwell, Mr. Kendrick, Mr. Greer, and Mr. Arnold, all present or former clients of Mr. Steele, also have their rights properly preserved. So one of our main concerns here is that none of these waivers are on the record. We would ask, even if this court were to deny our motion to disqualify Mr. Steele, that each of these waivers be made on the record. Right now, they're written, but we believe that in order to ensure that everything is proper on the record and that we're able to create a perfect record in this case, that those defendants be brought here and their waivers be placed on the record. That's out of Taylor versus State. That's 320 Georgia Court of Appeals, 595. That's a 2013 case. In that case, defendants alleged on appeal that there had been a conflict in the lawyer, and as a result, they should get a new trial. However, because the waivers were actually made on the record by the affected defendants, as opposed they were taken in court, made on the record, the Court of Appeals found that any error was induced by the defendant's statements, and that as a result, the case was not reversible. So first of all, more than anything, we would ask that any waivers be made on the record, as opposed to simply the written waivers, which again, while we do appreciate, we believe are not sufficient to waive the conflicts, especially in light of our allegation that Mr. Williams operates a position of leadership in the gang. That's in count 56 of our indictment. We do allege that. Our concern is that as a leader of the gang, perhaps some of these individuals may feel influenced. So we would like them to be advised by this court on the record, and if they still wish to waive their rights, we believe that would at least cure some of these potential conflicts. However, Your Honor, our main concern, and I did hear the court cite to Bernici, but our main concern is not with Mr. Steele's former representation of various clients. While we do have concerns about that, our main concern lies with Mr. Steele's current representation of co-defendant Blaylock. Mr. Steele is currently representing co-defendant Blaylock in Mr. Blaylock's direct appeal of his murder convictions. Mr. Blaylock was previously convicted of murder, a murder that occurred in 2019. That murder has then been alleged as one of the predicate RICO acts. So in this particular indictment, the murder for which Mr. Steele is presently representing Mr. Blaylock on appeal, that murder is also one of the counts alleged in this indictment.
That apparently, that case has that been returned from the court, from the appellate court already?
No, Your Honor.
That's
So
right.
the posture of that case right now is that Mr. Steele has filed an entry of appearance. We are awaiting, and I'll be handling that appeal as well. We are awaiting transcripts and a motion for new trial. There is a scheduling order on that case. I believe the hearing is set for either late this year or next year. But that is at the motion for new trial stage in the Superior Court stage. So he's currently representing Mr. Blaylock. And I'll notice that in his motion, Mr. Steele alleged that he has not spoken to Mr. Blaylock. However, I would like to advise the court that although Mr. Steele perhaps alleges that he has not received any information about this, the federal courts, so the 11th Circuit, employ an irrebuttable presumption of the disclosure of relevant confidential information when an attorney represents someone on a related proceeding. And that is out of United States versus Cordoba. That's a 2013 district court case.
Can you spell Cordoba for us, please?
C as in cow, O, R, D as in dog, O, B as in boy, A. That's a 2013 district court case out of the Southern District of Florida. but it is citing to United States versus Henry, which is 307 Fed APPX 331, and that's out of the 11th Circuit, and that's 2009. And specifically, the rule is that there is an irrebuttable presumption of disclosure of confidential information whenever there is an attorney-client relationship. Further, that court found once it is shown that the prior representation was substantially related to the current representation, then it is irrefutably presumed that that relevant confidential information was disclosed. And further, an attorney's representations that he cannot recall any confidential information that would be useful in the cross-examination of a potential client does not alleviate the potential conflict because the situation might change. So I think that's particularly pertinent in regards to Mr. Steele's representation of Mr. Blaylock. And I would also like to point the court to Georgia case law, specifically the Height case that the court mentioned, the 2013 case out of Georgia. And particularly the showing required, and this is also reflected in 11th Circuit precedent for pretrial matters, there is no requirement of an actual conflict, but instead, and this is from Height at 346, accordingly, the courts must recognize a presumption in favor of an accused counsel of choice, but that presumption may be overcome not only by a demonstration of actual conflict of interest, but by a showing of a serious potential conflict. So the key language in this case, and in a lot of the cases out of the 11th Circuit and out of Georgia, is the existence of the serious potential for a conflict.
What's the potential conflict?
So the potential conflict here is similar to that which is articulated in Height, which is if we would like to come to Mr. Blaylock, and we anticipate, and I'm putting this on the record now, if defendants in this indictment wish to cooperate with the prosecution and provide testimony against other defendants in that indictment, we are willing to offer deals depending on the information and depending on the defendant. We, at this point, would be unable to offer Mr. Blaylock any such deal because the representation of Mr. Williams would be a conflict. So I would like to point the court to Height at 347. Specifically in that case, the court found that because the prospects of the conflicted attorney advising the co-defendant about any deal that might be proposed by the state to secure her testimony against Height or cross-examining her on behalf of Height were rife with serious ethical problems. The trial court did not abuse its discretion when it determined that the conflicted attorney's representation of both the co-defendant who had previously been indicted with the defendant would materially and adversely affect his representation of the main defendant. Additionally, Mr. Steele actually cites to Lewis versus State as well in his brief. And this case is very different from Lewis, but Lewis, which actually found that disqualification was improper because there was not basically the conflicted firm did not actually possess information about the witness. But Lewis even recognized the serious potential of conflict rule. In Lewis, the court recognized that there was a risk, but in Lewis, there was not a significant risk. Here, however, there is a significant risk, and federal court has similar laws like this. So in another case that's out of the Southern District of Florida, which again is 11th Circuit, and I just point to it because it's pretty analogous to our case, it's called United States versus Gutierrez, Gutierrez, and that's 2010 out of the Southern District of Florida.
Do you have another citation or feds?
Yes, Your Honor. The one I have is Lexus, so I hope that's sufficient. It's 2010 United States District Court, Lexus 99424. But it does cite to law that will hopefully be, that is out of the 5th Circuit, which of course became the 11th Circuit. And specifically, the court found that an attorney cannot advise. So in Gutierrez, there was.
Spell Gutierrez for us again for
yes, Your Honor.
myself and for Ms. Weaver.
Yes, Your Honor. G-U-T as in tie, I-E-R-R-E-Z.
Thank you, ma'am.
Now, in Gutierrez, there was an attorney and he previously represented the cousin of a defendant. But the cousin of the defendant and the defendant were targeted in the same federal investigation. Although the attorney never officially represented the cousin did hold that attorney out to be his attorney. For instance, he gave business cards of that attorney to federal investigators. But essentially, that's actually less representation than what we have here with Mr. Steele and Mr. Blaylock. Mr. Williams and Mr. Blaylock by Mr. Steele. And specifically, the court in Gutierrez found that there was a conflict here. And first of all, the court noted that citing to Wheat, for a court to find a potential conflict of interest, both clients do not need to be charged in the same indictment or subject to trial in the same proceeding. Further, and this was citing to the Wheat case that the court mentioned earlier in this hearing. So further, the court in Gutierrez again mentioned that irrebuttable presumption of disclosure of confidential information wherever there is an attorney-client relationship, and that once it is shown that the prior representation was substantially related to the current representation, then it is irrebuttably presumed that relevant confidential information was disclosed. Now, specifically, the court found that there was a serious potential for conflict here, finding that this attorney should be conflicted because, and this is quoting the court at page 14 of that opinion, moreover, Mr. Mitchell, the conflicted attorney, cannot adequately advise either of the defendant or his cousin about their option to cooperate against the other. And that's citing to Beatty, B-A-T-Y, versus Balcom, B-A-L-K-C-O-M, 661 F3D 391. That's a Fifth Circuit case, 1981. Of course, that later became 11th Circuit precedent. And specifically taking the quote from the Beatty versus Balcom case is the conflict of interest before trial alone would be sufficient to grant that motion, because had the attorney not been facing a conflict of interest, the attorney might have been able to negotiate a plea agreement on one defendant's behalf in return for becoming a prosecution witness against the other defendant. And I also want to point to another quote out of that case, which I think is relevant for this hearing. And this quote is, "The court may refuse to accept the waiver," such as what we have here between, there is, of course, a written waiver on the record for Mr. Blaylock. "The court may refuse to accept the waiver where necessary to ensure the adequacy of the defendant's representation, to protect the integrity of the court, and to preserve the trial court's interest to be free from future attacks over the adequacy of the waiver and the fairness of the trial." And that's citing to U.S. versus Almeida, A-L-M-E-I-D-A, 341 F3D 1318, and that's 11th Circuit Court of Appeals, 2003. So here we would argue that it's very similar. In this case, we believe that especially Mr. Steele's, and to some extent his representation of his former clients, however, we believe a waiver on the record may be able to cure those conflicts. However, we would of course have concerns that even with those former clients on related proceedings, should they choose to testify against Mr. Williams or anyone else, Mr. Steele might be conflicted in his ability to cross-examine those former clients. But particularly,
in terms of, like, several of these clients, Arnold, Greer, and Blaylock all have predicate offenses. Like Arnold is Act 11, Count 1. Greer is Act 108 of Count 11, and Blaylock is Acts 74 to 76 of Count 1. Wouldn't that be a potential issue if I'm looking at potentially a resolution or some other issue related to this case? Wouldn't that pose a potential or an actual conflict?
Yes, Your Honor, it absolutely does. And that's the next part of my argument, because I just wanted to start with Blaylock because our biggest concern is that he is currently representing Mr. Blaylock. He is Mr. Blaylock's attorney of record. Mr. Blaylock although he signed a waiver through another attorney, Mr. Blaylock is actually unrepresented in this case. And the only representation that Mr. Blaylock even has right now is Mr. Steele on his appeal. And as the court, I'm sure, is aware, sometimes with these appeals, we can work things out, especially if there is a pending case. I'm not saying we definitely will. It would have to be if Mr. Blaylock were to say, hey, we'd like to cooperate, but he can't even do that because of this conflict. And so that's why we started with Mr. Blaylock. I would also like to advise the court in terms of these present conflicts that we're discussing. Mr. Steele is also currently the counsel of record for Mr. Quantavious Greer in case number 10 SC 92020. And we certainly appreciate Mr. Steele bringing this to the court and the state's attention. As I noted in our original motion, we were trying to file that as soon as we could to make sure that, save Mr. Steele from any if disqualification is warranted, which we believe it is, we wanted to get that out there as soon as possible to avoid any kind of gamesmanship. But as soon as we learned about that representation of Mr. Greer, we did look into that. And we noted that Mr. Greer is actually, he was convicted of murder. That case was reversed. The state will be trying that case again. That case is presently before this court in a separate case. That case is not related to the present indictment, but Mr. Steele is still Mr. Greer's counsel of record. Should Mr. Greer wish to cooperate, perhaps negotiate some sort of resolution to both of his cases, that would certainly create what is very obviously the serious potential for conflict that I've described. So that's another one. Also, as the court just raised to me moments ago, we do think that there are serious problems with the former clients based on especially the federal case law that I've discussed, where there is this irrebuttable presumption of disclosure of confidential information whenever there is an attorney-client relationship. And when that issue is substantially related to the current representation, which obviously it is, these counts are the predicate acts for the present case. We think that there is an irrebuttable presumption that relevant confidential information was disclosed. So, again, also I'd like to point the court's attention to another case out of Georgia, the Georgia Court of Appeals case, Edwards versus State, 336, Georgia Court of Appeals 595, parallel site 784 SE 2D 924. That's a 2016 case. And in that case, the defendant's attorney had formerly represented the victim's mother in a previous proceeding. It was a child molestation case that was on trial. The court found that there was a serious potential for conflict there. And although the defendant in that case waived the conflict, the court found that the Court of Appeals found that the trial court properly declined to accept that waiver because the defendant's waiver of his attorney's conflict of interest does not always cure the problem, because courts have an independent interest in ensuring that criminal trials are conducted within the ethical standards of the profession and that legal proceedings appear fair to all who observe them. And that waiver does not work. And this goes to one of the non-waivable conflicts in 1.7c. Waiver doesn't work because his defense counsel's loyalties would have been divided by the above stated ethical duties. And again, the reason that the state is bringing these motions today and why we are so concerned is because, as the court found in Edwards, in the absence of an effective waiver of the right to conflict-free representation, and so that would include cases where conflicts cannot be waived, allowing the trial court to proceed to verdict would have created a serious potential for error sufficient to allow Edwards to obtain reversal of any guilty verdict by claiming on appeal that he was prejudiced by the conflict. So essentially here, Your Honor, to sum up my argument, basically, first of all, while we appreciate the written waivers, we believe that if the court is even willing to consider waivers to cure any of these conflicts, those waivers would need to be here in person on the record, where the defendant could confirm to this court, and this court could observe that defendant, everything around him, his demeanor. He couldn't come back and say, that's not my signature, I didn't authorize this, anything like that. We'd ask that these be on the record where the defendant advises that he has had the consultation, he has received in writing reasonable and adequate information about the material risk and available alternatives, and he's had the opportunity to consult with independent counsel, and those rules are out of Taylor, which I cited earlier. But again, our position today is that some of these conflicts, particularly the conflict with Mr. Blaylock, and to a lesser extent, the other former client conflicts, including Mr. Stillwell, Mr. Kendrick, Mr. Greer, and Mr. Arnold, are not waivable conflicts. And I also do want to point the court's attention to our concern with Mr. Stillwell is that we believe his counsel is also facing a conflict, and his counsel is who got the waiver on this case. So there's sort of a double conflict here. But again, Your Honor, basically because we truly think that there is a serious potential for conflict, because basically should we wish to convey those plea offers, the attorney would not be able to negotiate that in return for becoming a prosecution witness against someone else, against, for instance, Mr. Williams, who we've of course alleged is in a leadership position in this gang, which is why these are particularly concerning allegations. And one moment, Your Honor. That's all I have for the court at this time on why we believe that this court should, first of all, request any waivers be on the record. And additionally, we would ask that this court grant our motion to disqualify Mr. Steele on the grounds of the 1.7 and 1.9 conflicts. Thank you, Your Honor.
Okay, all right. Mr. Steele, I'll let you respond, and then Ms. Rosenwasser, I'll let you, if you have any other argument as it pertains to Mr. Sharp, and then I'll let him respond, okay? All right, Mr. Bullard, good morning, sir, or good afternoon at this point in time.
Oh, yeah, we have been here a while, Your Honor.
Yes.
So first, Your Honor, I'd like to thank Mr. Geary and Ms. Rosenwasser for their professionalism and candor in foregoing the Rule 3.7 issue. We always felt that that wasn't going to bear out, that there was no way Mr. Steele could be a necessary witness in this case. Glad on investigation, they see things our way. As for the Rules 1.7 and 1.9 issues, however, I know that Ms. Rosenwasser didn't quite give the court the full picture of the case, or the full picture of the law. As Your Honor noted, to require disqualification, the state has to allege and substantiate a claim of an actual conflict of interest. Now, we are in a criminal case, and we're talking about the Sixth Amendment context, where the one's right to chosen counsel, Mr. Williams' right to chosen counsel.
It's not absolute.
It is not absolute, Your Honor.
So I think that the case law kind of walks us through that. So let's just kind of go through that.
Sure.
I understand he has a Sixth Amendment right to choice of counsel, but in this particular circumstance, the court has to be, you all have sought waivers, got waivers. That's step one. And then there are issues of whether or not there's been an ethical violation, and then the issue of whether or not there is, some type of substantiation. So let's address that.
All right. So first, I'll turn this around then. As for the waivers, Your Honor.
Do you believe that I should go ahead and hear those, have those in, given what Ms. Rosenwasser has cited, I believe it's Taylor, that would probably be the better practice for me to go ahead and have a actual on the record hearing, or actually waiver. Are you in disagreement with that?
In general, no, Your Honor. There is no harm in bringing the individual defendants in, having the court inquire whether they fully understood the rights they were advised of, and whether they have actually waived the issues. There's no real problem there. I would note, however, that the rules of professional conduct describe written waivers as appropriate on consultation with independent counsel. And that's what we have here, Your Honor. We have several lawyers each of whom have independently consulted with Mr. Steele's current and former clients who have represented to those clients in the court and who are presumptively ethical.
I'm not in any way saying that Mr. Steele is unethical or in any way he has the highest of ethical conduct and the highest of advocacy, having watched him for the better part of 25 years. So that's not the issue. The issue is the system and its ability to be fair and transparent. So part of the challenge is unlike the civil cases that a lot of these have been quoted in a lot of your briefings, criminal cases are unique in the sense that when you have multiple accused, you have divergent interests. And as the longer the case goes, or at any point in time in the proceeding, you can get, opportunity, meaning that, and I mean opportunity in this case, I'm not either on either side, but where a deal can be struck or conversations can be had. And the court wants to ensure that all the parties are in the best position, should they choose to do so, to participate in that. And I think that, in fact, in Haidt, one of the things that the Supreme Court was most troubled by is that divergent interest and likelihood. And in criminal cases, especially where you got 28 folks, you're going to have that particular issue. And you've got three of these particular people, Arnold, Greer, and Blaylock, who are specifically referenced in predicate offenses as part of the RICO count. So, I mean, in terms of substantiation, I mean, I'm not kind of commenting on whether or not the state's going to be fruitful in this, but that would be part of the reason or what they proffered. So I'm going to take judicial notice of the indictment. I'm going to have it admitted as court one, because it does go ahead and, Mr. Reaver, it does go ahead and give the predicate offenses that we're talking about that form some of the concern under 1.7. But I hijacked you, so I apologize. Go right ahead.
It's your courtroom, Your Honor. All right. If I can address that.
Yeah.
Sure. In a multi-co-defendant case, there is always the possibility that there may be interest, because we don't know that at some point one defendant may want to turn on another, that one defendant may want to turn state's evidence, that someone might be able to negotiate their way out for one reason or another. The point at this point, Your Honor, that is speculative, because we don't know that's going to happen.
Ms. Rosenwasser indicated on the state, and that as not officer of the court, that is a likely I mean, that's more than a likely probability that once the representation issue is resolved, that they're going to go ahead and, as part of their prosecutors' tools, do that.
Sure. But, Your Honor, it is nonetheless still speculative. Ms. Rosenwasser speaking in the subjunctive, in the conditional. We don't know whether those defendants would be interested. We don't know what the offers would be, and we don't know whom the offers are coming to.
But doesn't that potentially pose a significant issue to Mr. Blaylock, and I mean, in particular, who is still in
whose motion for new trial is still pending, Your Honor.
I know, but that's part of the conflict is, can he be offered some type of, can they have two conversations? Can he have two conversations with client Williams and then client Blaylock on their relative equities and what they should do if given the opportunity? I don't think he can.
If that were to come up, Your Honor, if the state were to make an offer to resolve the matter that Mr. Blaylock is on, or that he has Mr. Blaylock on in that matter with respect to this one, it might well be a problem. And again, we don't know that that's going to happen and whether that is even an issue or even will be an issue in this case, because the state already has a judgment for murder against Mr. Blaylock. And so I'm not sure how much more of his life it intends to take. Nevertheless, Your Honor, but when Ms. Rosenwasser also brought up the concern about the state's concern about ensuring that there's a perfect record and that that any judgment against Mr. Williams in this case would be insulated against reversal on these grounds. Well, let's talk for a second about what would actually have to be shown were that happened. Assume, for sake of argument, that Mr. Williams were convicted. The law from the Supreme Court of the United States is that he would have to show an actual conflict, which is not just a violation of ethical rules and is not a theoretical division of loyalties, the Supreme Court says in Mickens versus Taylor. It is that Mr. Steele's representation would actually have been affected. And if Mr. Williams is going to raise that claim, he would have to show that, and all indications are that Mr. Williams is going to trial, he would have to show that Mr. Steele's representation was compromised. And Your Honor noted that there is no question about the quality of Mr. Steele's advocacy and whether it would be compromised and what kind of advocate he is. So it is hard to imagine that it would be compromised here. Now, if the state were to make an offer against Mr. Blaylock, one, there is a waiver already, and two, that could well be resolved by Mr. Steele getting out of that case and Mr. Blaylock having other counsel. Then that counsel can consult with Mr. Blaylock, and then Mr. Steele could consult with Mr. Williams.
How do you address the issues of the 11th Circuit and serious potential for conflict or irrebuttable presumption of disclosure of confidential information?
Your Honor, that one, I know that presumption has not been adopted by a Georgia court. That is a presumption that's been adopted by the 11th Circuit, but Georgia courts haven't adopted it. And two, even if we were to presume the transmission of confidential information, that alone does not create the actual conflict of interest or the serious possibility of one. I turn the court to, let's say, Lewis versus the state. Actually, no, I take that back. Williams versus the state, which is cited in our motions, a case that arose out of Savannah. There, the public defender's office represented two co-defendants who were charged in a single indictment, pleaded one out, and then the public defender himself represented the court that he did not think that he could continue to represent the defendant at trial because of the then pending formal advisory opinion of the bar 10-1, which talked about the imputation of conflicts among public defenders' offices. The court inquired there, determined that he didn't know enough about the other case, that his representation in this case wouldn't be compromised, and allowed him to go forward. Mr. Williams raised that issue on appeal, and the Supreme Court affirmed, because he did not show an actual conflict of interest. There was no evidence that the representation was impacted. Similarly, in Lewis versus the state, which Ms. Rosenwasser referenced, she says it's not quite like this, but I think a little deeper dive into that case might help, because what you have there was the former superintendent of the DeKalb County Schools, Mr. Lewis, who retained a lawyer, Mr. Brown, who was a member of the firm Alston and Bird. Alston and Bird also represented a witness in a number, or a witness's employer in a number of matters, and so the court inquired. There were representations made on the record that there was a discussion about whether the witness and the employer were the same, and whether there might be some conflict of interest between that would cause Mr. Brown to pull his punches. And there was speculation.
It talks about the rigor of cross-examination.
Yeah, the rigor of cross-examination, which is also something the 11th Circuit talks about repeatedly, whether there is going to be, whether there might be a risk of disclosure of confidential information on cross-examination, or whether there might be an interest in not cross-examining as vigorously as possible. And in that case, the Superior Court of DeKalb County disqualified Mr. Brown defense counsel, and the Court of Appeals reversed.
But isn't that different than what we have here? I mean, that seems to be kind of not what's going on here in the sense of this is a little bit more involved.
Sure, it's a little bit more involved, Your Honor. But at this point, what then Judge Blackwell said in the opinion was that, one, there is no evidence in the record that any of these things would be true. And it's noted that even if counsel stated that in their place, these general assertions were not enough to base disqualification on. The rare and extraordinary remedy of disqualification of counsel of choice. And all that the court was basing it on was conjecture upon conjecture, because we're speculating out there. So the claim there wasn't substantiated, just as the claim here hasn't been substantiated. We're speculating. I would also, since we're talking about federal cases, I might also point the courts to United States versus Harrison, which is cited, and I have copies of most of these cases if it would be helpful to the court. So in United States versus Harrison, if I may.
You may. You give one to Mr. Kearns too, please, if you have extras.
The facts are somewhat complicated, but I'm going to try to distill it down. It involves a father and son who were law partners and multiple co-defendants in an indictment. Now, the son had previously represented one of the co-defendants in a civil matter, and the co-defendant had, and then the father took on the representation of another co-defendant in the criminal matter. The representation, the co-defendant, the information from the civil matter was germane to the criminal matter, and the representations made by the co-defendant would have turned the son into a witness. Now, the Middle District of Georgia, applying Georgia rules of professional conduct and inquiring into the case, did not find that there was a risk that the father, who was representing the co-defendant in the criminal case, would not be able to effectively cross-examine his son and law partner. Similarly, we have, or relatedly, there was also not an issue with, there was not a showing that the confidential information might have been material to the case. So even if there's a presumption of confidential information, it does not mean that the representation will be materially affected. So the point here is, and in that case, what the court did was say, look, the lawyers are presumably responsible for figuring out whether they have a conflict or not. The government has not substantiated that there is a serious potential for an actual conflict, something that affects the representation. And if something comes up.
You don't think the predicate offenses that are listed in count 1 to Arnold, Greer, and Blaylock are serious potential conflicts?
I don't, Your Honor, because we just don't know enough. It is far too early in this process to be guessing about what's going to happen. The state may be making representations, but they may all say, we don't want anything. And they may say it to counsel other than Mr. Steele.
That would be, of course, they're truthful advocates. I mean, I'm not saying that what's in the indictment, they have to prove all the material allegations in the indictment as part of their case in chief. But certainly, if these were not in there, I would tend to believe that it's more than just mere speculation. They can prove it. So why would it be not? Why would it be speculative?
Because, Your Honor, just because those charges are there does not mean that it would be speculative that the several defendants would be interested in pleading. It would be speculative that the several defendants, that even if they pleaded, that their interest might or might not, their potential testimony might or might not be potentially adverse to Mr. Williams. It is speculative what the offer would even be at this point. We just simply don't know, and there's not enough evidence to substantiate that claim. Because, well, and if I can respond to that with Berger versus Kemp, which is a case from the Supreme Court of the United States that actually grew out of Georgia, I think down in Ware County. There we have law partners concurrently representing co-defendants in a criminal matter. So each one might well have the interest in turning on the other. And they challenged their conviction all the way up to the Supreme Court of the United States. And the Supreme Court said that that was not enough to show an actual conflict of interest in that case. So it just simply does not, it simply takes more to demonstrate an actual conflict than, well, this might happen. The joint representation, the simultaneous representation is enough, because in Berger versus Kemp, the Supreme Court assumed what we would call Rule 1.10 imputation, that law partners, that it's the same as one lawyer representing, but simultaneous representation by a single lawyer in a case where they might have adverse interests wasn't enough. The multiple representation is not by itself a basis for disqualification. In fact, I think in Wheat versus, well, both in Mickens versus, in actually all three of those cases, cite back to an opinion by Justice Frankfurter in Glasser. It was an opinion in dissent, but the majority adopted that point that a common defense might often be better strategy. And so the Constitution and the existence of an actual conflict does not turn on even just those opportunities. It takes more, and we are speculating. The other thing to remember here, Your Honor, is that an erroneous deprivation of counsel at this point. I mean, the state is concerned about ensuring that that any judgment in its favor is stable, but an erroneous deprivation of counsel at this point, no matter what quality of counsel Mr. Williams received at trial, if he's convicted, there's no showing of prejudice for reversal. He was denied his chosen counsel with whom he has a long-standing relationship of almost a decade, his chosen counsel who's intimately familiar with his business and affairs, whom he trusts, who has advised him in a number of matters, and who is simply not replaceable, even by other competent defense counsel, because he has been chosen. And even if the court were to find a conflict, it still has to balance the risk of the need for ethical conduct and the need to ensure the fair administration of justice against those concerns for the defendant. Even if we got there, even if the court were to find that the state had substantiated its claim, which we still say it doesn't. I'd like to loop back to two other points. As far as substantiation goes, Ms. Rosenwasser mentioned Edwards versus the state, the case out of the Court of Appeals, and it grew out of the Tallapoosa Circuit. And there, the public defender, the appointed public defender, had previously represented a defendant in represented then a defendant in a child molestation matter, and the state's principal witness was the mother of the child, whom the public defender under previous practice represented, I believe, in the divorce matter, not a divorce from this defendant, but a divorce matter. And there, the public defender himself put on the record that he was aware of confidential information that would affect his cross-examination. And that affirmative representation was enough to justify the Superior Court's disqualification of counsel, even though the defendant wanted to go on with his chosen counsel. The other thing, though, is completely different from what we have here. In Edwards, the witness, the former client, had offered no waiver. So there was no waiver of confidentiality, and the court did not accept upon investigation the public defender's representation that he could navigate around the confidential information. So he was trying to be ethical, but he conceded on the record that his representation would be affected. So there is a basis to infer that.
That's a little different because still under rules, all of us have an affirmative duty to, if a conflict develops and the potential that at the time the conflict is present, to raise that to the trier of facts. So he was doing what he was supposed to do.
Oh, absolutely, Your Honor. But the point is, when the issue went up on appeal, the court was not wrong in granting the mistrial because it concluded that he could not be effective, but there was substantiation. There was evidence in the record that would justify that conclusion, as opposed to, say, Lewis, where we were speculating, or even in.
But doesn't that scenario demonstrate anybody who's been practicing criminal law for a while will tell you that conflicts often develop kind of at an instant, meaning that when these equities change or evidence is made available, that's when we're people that think there's not a conflict then develops, and then the court has to take other actions to either salvage or even sometimes to re-engage the proceedings because somebody is pulled out because a conflict has developed through representation. So isn't that something that may potentially happen in this particular case, given the fact that you've got 28 folks, different equities? And I mean, I know you said this is speculation, the state hasn't offered anything as of yet, but isn't that part of the issue that the court as the arbiter and keeper of the process should be worried about?
I'm not saying the court should not be concerned, Your Honor. It is potential. Potential, however, does not mean serious potential, which is what wheat requires. And
I don't think it's serious potential that we've got 3 people that are that have predicates that are in the indictment.
No, Your Honor, I don't. Not at this point. Not without more. And
what would you consider to be more then?
An actual attempt to make an offer. If there were an actual attempt to make an offer, if the state said, all right, we're making an offer, and the court were to determine it wasn't simply to manufacture the conflict, which is another point it has to consider here under wheat. If the court were to actually make the offer, maybe we'd be in a different posture. We need to do something to address the conflict and perhaps change the posture of one of the defendants from present to former, and that's something that Mr. Steele would have to deal with. But that, or especially with Mr. Blaylock. But
doesn't that pose a problem for the people who are that Mr. Steele has represented in the past, in particular Mr. Blaylock, from even evaluating an offer or even being available to discuss that without the worry that the current client is going to potentially roll on them, or got the role being give adverse testimony to against their interest?
Well, let's take that for a second, Your Honor. So let's say an offer is made to Mr. Greer or Mr. Arnold or Mr. Stillwell Jackson. I know his name is Stillwell in the indictment. I think the waiver indicates the name is properly Jackson. But let's say that offers are made to them. They're going to be made through other counsel, and other counsel are going to consult with him or with them. And other counsel are going to advise them of the risks and benefits, and they aren't going to be able to get, and they aren't going to have a claim because they have other independent counsel advising them that the representation they got in this case was adverse. The only person who even might, and we're not there yet, the only person who even might is Mr. Blaylock, whom Mr. Steele represents in a different, though factually connected matter. We don't know if there's going to be an offer there. We don't know if the state's going to be willing to give up some or all portion of its of the motion for of the judgment it has and that it is now trying to defend against an appeal. But it just simply hasn't happened yet. And we also let's assume that assume for the sake of argument that Mr. Steele withdrew from that representation. Mr. Blaylock had other counsel. The counsel he had then could advise him.
He hasn't done that yet.
He hasn't done that yet. But again, if the state is speculating, well, this might happen, we might make this offer, Mr. Steele might withdraw. He might have other counsel. He might be properly advised. If we're talking about protecting the right, the interests.
How can he represent the interests of Mr. Blaylock, who's charged in Acts 76 and 70, 76 and 74, 76 and count 1, and the interests of Mr. Williams at the same time?
The state has conceded they're not presently adverse. So it concedes that in the motion, Ms. Rosenwasser indicated today. It only indicates that they might become adverse. If they become adverse, then Mr. Steele would be the first person to come to the court and say, oh, now we have a problem. I need to either withdraw from one representation. I need to do something. I point the court back to United States versus Harrison. At the end of the district court's order, the court recognized that there was a potential for conflicts to arise, and it reminded counsel of their obligation to inform the court should the equities change, should the conflict or the serious potential for one manifest. And in that instance, Your Honor, steps would have to be taken, but that one does not mean steps could not be taken to make sure that everyone had the right to effective assistance of conflict-free counsel. And in addition, that any judgment obtained against them would be sound, because when they received the advice and made the decision to plead or not, they would have had the benefit of independent counsel who didn't have these problems. It simply doesn't mean that, but all of these things could happen and it would still protect the judgment and wouldn't undermine the fair administration of justice. We just don't know yet.
Okay. Anything else?
I would come back to, Your Honor, that even if the court were to find the state has substantiated a conflict, there is a serious potential for an actual impairment of Mr. Steele's representation that could not be cured through withdrawal or something else. When it comes down to balancing the equities, we have to talk about what Mr. Williams loses in this case. He loses an excellent lawyer, one whom he believes to be the best of the best, and rightly so, and by Your Honor's own acknowledgement, and one who knows him for 10 years, who has an expertise about his life and affairs that is simply irreplaceable, and who is already, and there's also going to be a significant financial cost and loss of effort that's already been put in, and all of that counts, Your Honor. So even if the court gets there, then it still has to balance the equities before making a decision. And the burden is still on the state to show that the extraordinary remedy of disqualification is appropriate. And lastly, Your Honor, I have, looping back to the beginning, I have no problem with the court making the inquiry that's described in Taylor, because more than anything else, that would insulate a potential judgment against reversal on these grounds, because once the waiver has been placed on the record, none of these defendants could claim they received the ineffective assistance of counsel, because they would have induced the error. And induced error is an absolute bar to reversal.
I will tell you that from what you both have stated, I will, pursuant to Taylor, go ahead and probably do an in-person waiver. I think that would be prudent under the circumstances, and I'll set that up as soon as possible. So, but I definitely, as part and parcel of this particular analysis, would want that on the record, regardless of what I ruled. Okay.
All right.
All right.
So I guess that brings us to the question: if the court's not ruling today, Mr. Steele had planned to argue the bond motion. I know there's no present adversity.
Well, here's the thing. I have to resolve the issue of the counsel first, as I mentioned to Mr. Steele, before I do the issue of bond. And because he has chosen counsel for Mr. Williams,
Yeah.
So I believe I have to resolve that issue to begin with. But let me kind of ponder on that to begin with, okay? Yes, Mr. Steele.
May I speak, Your Honor?
I thought you were represented by counsel now. You can't have a twofer, sir. It's one or the other, all right?
I'd like to answer some of your questions, if it's okay with the court, factually.
All right.
Thank you, sir. And good afternoon, Your Honor.
Good afternoon.
Your Honor, I heard you ask multiple times the predicate acts in the indictment. How do the court deal with that? I need you to understand the following, please. Mr. Arnold, I never represented Mr. Arnold. You will find nothing that I have ever defended that man. I have never spoken with him about his case that there are predicate acts in this indictment.
I want to ask something. Does the state want Mr. Steele to testify about this? Because one of the things about these types of motions is there has to be some evidence. So if you're gonna, I mean, I know you're an officer of the court, you would not tell me anything inconsistent with that, but that is something that would have to, part of my determination has to be based on evidence that has been given in this case.
Your Honor, the state's position is so I had planned when I went back up to ask to just have the court take judicial notice of the exhibits I had already admitted. However, if Mr. Steele would like to testify, I would just simply like the opportunity to ask him any questions I might have, but I don't have an objection to him testifying on his own behalf right now, and I can ask him some questions afterwards.
Mr. Steele, I've had one of these go up before, and that's part of what was the other lawyer that raised the issue did ask those particular inquiry under oath. Do you have an issue with that, sir?
No, sir.
Okay, all right. Let me go ahead and swear him in. Raise your right hand, sir. Do you solemnly swear affirm the evidence you have given me in the case down here should be the truth, the whole truth, none but the truth, so help you God, so affirm?
Yes, sir.
Okay, all right, go right ahead.
With regards to Mr. Arnold, there was a shooting at Lenox Square Mall. I was at my office. I received a phone call, not from Mr. Arnold, and I don't know who it's from, but it's one of his supporters. It was either a manager or a female friend, is my memory, and said, the police are all over the mall. We're afraid that they're looking for Mr. Arnold. Would you please find out if there's a warrant for him so he can turn himself in? I was busy I was either on trial or doing an appeal. It's a long time ago. There's no file in my office. I asked another lawyer in my office, not affiliated with me, named Travis Glan, Glan, to go to Lenox Square Mall and find out if you could find out who is the police officer involved. Is there anything from Mr. Arnold? Travis Glan went to Lenox Square Mall. He got the name of an officer. I contacted the officer. I told the officer that I was contacted. If Mr. Arnold needs to turn himself in, if there's a warrant, then he would do so rather than the police have to potentially, I'm not saying any of this would happen, but go and waste resources finding the man. The officer told me, meet me at the police precinct. It's not far from the Honorable Don Samuel's office. I was there. I remember very late, 10 o'clock, 11 o'clock at night, the officer finally either showed me a warrant or gave me his word there's a warrant. I called a supporter. I said, there's a warrant. That's it. In the records, when the state raised this, they attached one page of an unsworn statement of a witness that says that I supposedly, and it's worded where you don't really understand it, but I supposedly made a statement, a confession on behalf of my client. I never spoke with Mr. Arnold in my life about that case.
And we're Atlanta's traffic expert.
We've seen delays almost 30 minutes worth of
Helps you get there on time, every time. 11 Alive Morning News is where you start the day prepared. Watch weekdays 5 to 7 a.m. If you see breaking news or severe weather near you, snap it and share it using Near Me on the 11 Live News app. Want to verify if something's true or false? Record your question and send it. Download the 11 Alive News app to use Near Me. 11 Alive News at 11 p.m. is where you find out what's happening now across Metro Atlanta.
We begin tonight with breaking news out of Cobb County, where a neighborhood is now...
Where you stay a step ahead of severe weather.
Our storm risk has now been upgraded to a...
And the only place where you can verify fact versus fiction.
11 Alive can verify that claim is false.
11 Alive News at 11 p.m. Where you end the day ready to take on tomorrow.
Weather can't run from the 11 Alive Thunder Truck. A mobile weather center with the power and speed to chase down the strongest storms and bring you on-the-ground conditions. The 11 Alive Thunder Truck, sponsored by Landmark Dodge.
Fighting social inequality is on all of us. That's why 11 Alive is committed to sharing diverse perspectives, exposing injustice, and finding solutions. Voices for Equality, sponsored by Georgia Power and our other partners. The 11 Alive Storm Trackers. It's how you see weather happening now across Metro Atlanta.
These severe storms are now closing in.
We could be talking about damage and winds, hail, and...
How you can plan ahead by knowing what's coming overhead.
Heavy storms are rolling in.
Expect pop-up thunderstorms and rain all day long.
And how you be weather ready wherever you are.
We expect at any moment a tornado warning could be issued.
The 11 Alive Storm Trackers. It's how you'll be prepared and stay safe. 11 Alive Morning News.
We began with breaking news this morning.
Is where you know what's happening now.
11 Alive is live on the scene.
Where you can confidently plan ahead.
This severe weather is intensifying.
By knowing what's coming overhead. And we're Atlanta's traffic expert.
We've seen delays almost 30 minutes worth of
helps you get there on time. Every time. 11 Alive Morning News is where you start the day prepared. Watch weekdays 5 to 7 a.m. If you
What y'all think, man? Hey, we got somebody new in the chat. He need to be accountable for his actions. They've been watching you for a decade. What a dummy. Oh, okay. Somebody who disagree. I disagree with that. Would you like to come up and join the panel? Let me put an invitation out there. Held accountable for what? Miss Cherry. The one thing I would say to Miss Cherry is held accountable for what? Because this is a RICO case. And I would ask Miss Cherry, it looks like a lady, and if that's not the right pronoun, let me know. I would ask Miss Cherry, are you familiar with the RICO law in the RICO case? Because the RICO law was created for the mafia for a certain reason, because John Gotti got his nickname Teflon Don. Remember that? Teflon Don, because they could not prosecute John Gotti. So Giuliani invented a law that actually breaks the law. The RICO law circumvents your rights. The RICO law breaks the law because they could not have proof. In America, you have to have evidence that I broke the law, right? There was never any evidence to convict John Gotti, but they were murdering people in the street. A lot like what's going on in Atlanta. There's a lot of shooting and crime in Atlanta. I don't know how you justify blaming Jeffrey and YSL for the problem that's been going on in Atlanta for a long time. You have homelessness running rampant in Atlanta. You have an issue with deadbeat moms and Black women and the children that the deadbeat moms produce in Atlanta. You have the LGBT community in Atlanta. No one's addressing the real issues in Atlanta. You put these 30 men in prison, you still have the system in place that created these criminals. That 15-year-old boy carjacked the lady. God is so good. He given us the evidence to talk about this. That 15-year-old carjacked the lady. That 15-year-old is not in this RICO case. This is my whole argument. If you were watching, you can rewind the tape. The 15-year-old carjacked the lady. That 15-year-old got 20-some years. When he get out of jail, he won't have a high school diploma. He won't have a college degree. He won't be able to take care of himself. That 15-year-old is not included in the indictment, right? He's just a 15-year-old Black boy, like all the 15-year-old Black boys in Atlanta who are products of deadbeat moms and a broken system. right? And now that boy's mother should be in prison. That boy's father should be having a job. But no mother was in court, no father was in court, no pastor was in court, no principal was in court, just a 15-year-old child. Just a 15-year-old child who probably wanted to just drive a car. Does anybody remember how bad you wanted to drive a car at 15? But he had no way to drive the car. So he carjacked the car. His life is over. In Atlanta, they throw away black men. There's a black female district attorney. These are black mothers who are heading the households in Atlanta. These are black women who are creating the problem in a way this black female attorney wants to solve the problem is throw away 28 black men, fathers, and the CEO of a corporation. What did Jeffrey do? There is no evidence that Jeffrey committed a crime. Yes, there are criminals in Atlanta because you guys are not cleaning up your streets and you won't deal. Y'all remember when they did that Section 8 thing in Atlanta? All them people. Do y'all remember how I was embarrassed? I was embarrassed. Do you live in Atlanta, Miss Cherry? Do you remember when they did that Section 8? The whole world saw all them black people out there. Do y'all remember that? See, people don't remember. This is my podcast. I do research. I've lived this life. I've lived in Atlanta. I know what I'm talking about. I'm not up here about conjecture, so don't come in my chat with no bullshit. Do you know what the RICO case is? What crime did Jeffrey commit? Jeffrey is Young Thug. If you would have been listening to my whole podcast, you would have heard me talk about TARP. You would have heard me talk about Lehman Brothers. You would have heard me talk about Saks. You would have heard me talk about all the corporations that stole my grandmother's house, that stole my mother's house, and not one CEO was brought up on charges. As a matter of fact, they got bonuses. Young Thug is the CEO of a multi-million-dollar record corporation. His artist, Gunna, probably will have the #1 hip-hop song of the year, nominated for a Grammy. His other artist, Jack Harlow, a Caucasian white person who was not included in the indictment, has the other #1 song of the year. This is not your cousin's record label. We all have a cousin who sells drugs who has a record label. This is not that. This is a multi-million-dollar corporation with the #1 record, the Grammy record, the award-winning record. This is a multi-million-dollar corporation, and he is the CEO, and there's no evidence that he's committed a crime. So you have to use RICO. The RICO law was used on John Gotti because now with the RICO law, all we need is hearsay. The RICO law allows us to break your law, to break your rights. And now I don't have to prove you did something. All I need is someone to say. I can bring in a criminal. I can bring in someone who doesn't like you. And if they can lie and say that you did something, then I can find you guilty under the RICO Act. That's how they got R. Kelly. R. Kelly is in jail. R. Kelly is going to get out on appeal. R. Kelly is going to get out on appeal because they used the RICO to bring up the same case from Chicago from 20 years ago. It's double jeopardy, but they were able to do it because RICO allowed them to break the law and go against the Constitution. And they were allowed, R. Kelly was convicted on testimony. There's no proof that everybody, oh, you saw the video. You saw the video. What did you see in the video? Do you see a child in the video? You see R. Kelly having sex, consensual sex with women. You see R. Kelly pissing on women consensually. You do not see what you think you see in the video, black people. R. Kelly is going to get out on appeal because of RICO. All they had in the R. Kelly case is testimony from people, questionable testimony from his brother and people, that the same people that testified 20 years ago. All they have against Young Thug is testimony. So what has Young Thug been doing? You know what Young Thug been doing, Miss Cherry? Young Thug has created the biggest rap label, just like Cash Money. Where he first was signed, he's creating $100 million corporation. Black men can create $100 million corporation. I'm confused. What crime did Young Thug commit? Not all of the crimes that black men are committing in Atlanta. What crime specifically did Young Thug commit that he's being charged? Do you understand the RICO? Let's see what she said. Has you children been robbed and carjacked at gunpoint? It's back on you. He's a leader, and we know how we roll if you know anything about gangs. So Miss Cherry is a troll. Miss Cherry is a troll and a self-loathing black woman. This is our issue with black women. Black women hate black men, and they are agents of white supremacy. She doesn't care. All she wants to do is be racist and prejudiced. My argument is irrefutable. The fact that Jeffrey is the CEO of a multi-million dollar corporation. But if she would have listened to the whole show, she would have heard the fact that YSL is a subsidiary of 300. 300, shout out to Sir Ism, 300 is owned by Liar Cohen, a very, very, very powerful small hat. This is why the federal government hasn't come in and charged the RICO. This is a state RICO by this black woman who is the new district attorney in Atlanta. And now we just heard how convoluted the case is, how messy the case is. Liar Cohen is an extremely powerful small hat with political influence. Did you know Liar Cohen was one of the CEOs of YouTube? Hello? Did y'all know Liar Cohen, after doing 300, became an executive of YouTube? How many people knew that? How many people know the influence that Liar Cohen holds over this platform? You talking out this, you know, my mother, rest in peace, Mama Shirley. Cherry is talking out the side of her neck. That's what my mama would say. You talking out the side of your ass. You don't know what the fuck you're talking about. You're just being contentious to be contentious, right? And you've actually made a fool out of yourself. You've made a fool out of yourself because this statement lets me know you don't know what the fuck you're talking about. You absolutely don't know what you're talking about. And you should, because you're a black woman, these are black men, you should be more concerned. You should be more concerned. You should be concerned that CEOs in America don't get brought up on criminal RICO charges like this, on frivolous, without proof and basis. Name the last CEO of a multi-million dollar corporation who has brought up on criminal charges. You can't, because CEOs in America are not prosecuted because this is a capitalistic country. The only reason this is happening to Jeffrey is because he's black. They're treating him like he's black. Right now in court, the argument is they don't want him to have Steele as his lawyer, who's been his lawyer for 10 years. Is he not a citizen? I don't get it. Are you guys awake? Are you guys fucking listening? Atlanta doesn't want him to have Steele as his attorney. This has been my lawyer for 10 years. I'm in jail. I'm the CEO of a multi-million dollar corporation. I have the #1 artist, and I have the best attorney in America. You won't release me, you won't give me bail, and now you want to take away my attorney. How can you take? I have not committed a crime. I don't carry a gun. I haven't shot anyone. As a matter of fact, my son's mother was just murdered. My son's mother was just murdered. Come on, Cherry. See, a lot of people, so it's a lot of people who watch me that think I don't like black women, that think I hate black women. Because I'm honest about black women does not mean I hate black women. I'm being honest about black women's hate for black men, and I'm being honest about black women's failure in family, marriage, and children. And the result of black women-led households for the past 50 years is the gangs. This is so funny because look at her picture. Look how old she is. You created the gangs. The gangs are your fault. The black household has been led by the black woman for the past 50 years. And now you made a mess. You made a mess. You got a bunch of homo thugs running around Atlanta not knowing how to conflict resolute. And now you don't want to clean up your mess. You want the white man to clean up your mess. Ain't that fucked up? This is what black women always do. You raise the child, that you don't really raise the child. But when you cannot get the child to do what you want the child to do, you call the police. You know why? Because you want the white man to clean up your mess. You could have called his father. You could have stayed married to his father. But when you create a mess, you always call the white man to clean up your mess. The black woman created the problem in Atlanta. I'm back. So we were talking about, we were having a good conversation, and we were talking about why that light don't look as bright as it should. That light should look brighter than that. I like that better. All right. We were talking about, right before I left, we were talking about the problem and the issue. This happened 2 days in a row, so I'm going to have to call Comcast. Every time I get cooking, I'm going to have to call Comcast. And really the thing is, I got a lot of people who hate watch. But I love the haters. Hate watch all you want. I love you. I love you. You do. I do. All the detractors. All the detractors. We were addressing the issue with Jeffrey in Atlanta, and the black man in Atlanta, and why it is we have the problem that we have in Atlanta. And my sister Tracy said, not all black women, right? My sister Tracy said, not all black women. And I think it's important that we talk about this, not all black women, because people may hear me in some of the things I said lately and say, oh, why Perfect is saying these things about black women. It's because everything that's happened in Buffalo, in society, and the truth that we got to deal with, right? Tracy said, not all black women, right? Do y'all remember, I grew up in the 90s. My birthday coming up, August 15th. I'm going to be a whole old nigga plus 2. Y'all heard me? August 15th, I'm going to be a whole old nigga plus 2. So there used to be in the 90s, there was something called the Million Man March. And also in the 90s, there was something called the 5 Percenters. Y'all familiar with Gold Professor? Gold Professor is a gentleman, Gold Professor is a brother who has a YouTube page, and he's a 5 percenter. You got Kane the God. She hangs out with Gold Professor and Kane the God. These are 5 percenters. In the 90s, we had something called the Million Man March, movie called Get on the Bus. And there was an issue with black men in the way black men was comporting themselves in society. So there was a movement put together by the great Minister Farrakhan, and there was a consortium of men called the 5 Percenters. 5% to me represent, y'all could tell me if I'm wrong, but to me it spoke to the fact that during this time that only 5% of black men were redeemable and worthy of being married to black women, who at that time we revered as deities, right? I've talked about this when I talked about Master P, Romeo, and the teachings and the blue pill inherent nature of black men. When black men are raised to believe that their mothers can do no wrong, and black mothers are infallible, right? So we talked about that before, right? We talked about that before, right? So now we're talking about my beautiful sister, my beautiful sister Tracy, and what she said about not all black women, right? So the way I'm going to address that is with the 5 percenters. When I was one of the black men, when Million Man March and the 5 percenters became popular, I took offense, right? Just like Tracy. If you're a good black woman, you would take offense to some of the things I said. Well, guess what, you guys? I took offense to the Million Man March. I took offense to the 5 percenters because I was gainfully employed. I was a good father. I knew my father. I had been raised to be a masculine man, and I was laying that down in my life. So this whole Million Man March, black man, pull up your pants, I really took offense to it. I really was offended because that was not my life. That was not who I was. That was not who my father was, who my uncle was. That's not how we got down San Francisco Bay Area. You didn't see a lot of the people from the Million Man March from my part of America. You feel what I'm saying? So I took offense. So Tracy, I relate to you, but there was a reality to the situation. The 5%ers was real. And at that time, we're going to have to agree that only 5% of black men were redeemable, worthy of being married to the black woman who at the time we revered as a deity. What I say to you, Tracy, is that I, like you, have a 15-year-old son, and it has reversed. It is the adverse now, to where only 5% of black women are redeemable. So let's say the B-dub, because I don't know if the algorithm or everybody might like that. So let's say the BW, right? Only 5% of the BWs are redeemable, just like in the 90s with the 5%ers when we needed the Million Man March. And tell all men, does anybody know the actual definition of aggregate? Because a lot of people use this term when we talk about the aggregate. You know what I'm saying? We couldn't address the 5% because the problem was so pervasive that we had to address you as a whole, black men. And that's what the Million Man March was about. So everybody got swept up, even people like me who were gainfully employed, right? High value men got swept up in the Million Man March, right? Because this change needed to be a holistic change. The same thing exists now for black women, where you maybe have 5% of the BWs who are redeemable. So the question for you, Tracy, and the question for me, Tracy, if we don't address all of the BWs as a whole and use aggregate, right? Then how do you tell your 15-year-old son, how do I teach my 15-year-old son to find the 5%? It's impossible. Now it made sense to me why we had to address all black men. Because if you are a father of a black woman, how do I, in that time period, how do I train my black daughter to seek out the 5% of worthy black men? It's impossible. We have to address the aggregate. We have to address all of the black men. And that's what the Million Man March was about. The black manosphere exists for the same reason. We have to address all of the BW. Because how do I tell my 15-year-old son? And this is the honesty. Tracy, you got to join the panel one day. Tracy, you got to join the panel one day and be honest, because I've had this debate with beautiful, intelligent black women like you. And then I ask her, what will you do if you don't prepare your son and he brings home a Megan Thee Stallion, a big booty with a weave, and she's disrespectful to you? How are you going to feel? And you know what happens in that debate with that black woman? She gets quiet. And she said, you know what, Dennis? It already happened. And I had to talk to my son. Oh, really? Oh, okay. You got to protect your son. Okay, so now it's a different debate. Now she wants advice from me because now I broke down the walls. And now she knows I don't hate black women. And now she knows I know the truth, right? And I exposed her truth by pulling out her own prejudice. What happened when your son brought home that big booty girl and you got afraid that she might get pregnant? Oh, now you want to join the black manosphere because now your son wants to have sex and your son wants to have sex with this big booty girl. And you know how black women are raised in America in 2022. Tracy, can you please tell me? Can you please tell me? Because they want to flag me. They want to lie to me. They want to say I'm evil. Tell them now. What you going to do when Megan Thee Stallion comes in your kitchen with her whole ass hanging out, and you want your son to not end up in Cobb County prison detention, and you want your son to not be on child support? What you gonna do, Tracy? You gonna call me. You gonna call me because he ain't gonna listen to you. You gonna call Perfect. You're going to say, could you please talk to my son? I don't want him to hate black women, but I want the best for my son. I don't hate black women. Perfect, please, I don't hate black women, but I'm afraid if my son dates this woman or what his future would be. Tracy, can you be honest, please? Can you be honest, please? Cherry, can you be honest, please? This is why the black man is angry at black women. I love my son. I don't hate black women. I love my son. When you wake up, I love my son. How do I tell my son? How do my son? I'm married to a Sicilian. I don't date black women. I don't deal with black women. But how do I teach my son to find the 5% for everybody that thinks I hate black women? Tracy, how do you teach your son to find a good black woman in America? Come on, it's like going back to the 90s and having your daughter find a good black man. And why would she have to? Why does she have to jump over all these hurdles? She shouldn't have to. Well, my son shouldn't have to do magic to find a good black woman. It shouldn't be that hard. It shouldn't be that hard. And we shouldn't be upset. We shouldn't be upset when black men call out the truth. Tracy said, I love my son. He won't bring home Meg. He already knows. Tracy, if he wants to date a black woman, have you freed him up? Remember LeBron James' son. So look, if he wants to date a black woman, have you told him how difficult it's going to be? Have you told him, I can't help you? Have you freed him up and told him, son, if you don't have to, have you told your son, society says you could sleep with a man, you could sleep with a woman. And I'm going to tell you as your mom, if you could sleep with any sex, then you could sleep with any race, as long as you're in love. Do not feel pressure to date a black woman. If we're not going to pressure our sons to date a woman, how can we pressure our sons to date a black woman? Because then I would ask you, how do you prepare him? How does he find a black woman who's adequate and prepared? And this is the thing right here. See, he already told her who he wants to date. So let's go to LeBron James' son. Let's go to LeBron James' son, because this is a broke issue. Because people could see what I'm saying as hateful, right? If you're broke. If you are a broke nigga, if you're raising a broke nigga, oh, I'm gonna hurt some feelings. And I need to do this because I love Tracy. I got to raise up the people. I'm older than everybody watching, so I need to hurt some feelings. This is a broke nigga issue. Yeah, it is. This is a broke nigga issue. LeBron James is not pressuring Bronny to date black women. Okay, so imagine Tracy's son is worth $100 million at 15 years old. Let's change the dynamic, because we're all broke. We are the oppressed people. I want to hurt some feelings. I want to hurt some feelings out there. The FBA is worth $1,500 without the car. The FBA, the ADOS American is broke. By 2053, there would be $0 in the ADOS. This is a broke nigga conversation. Now imagine, Tracy, your son is worth $100 million. I want to hurt some feelings. Imagine your son is worth $100 million and he's black and he's going to the NBA. Yeah, let's have a real conversation. Is he allowed to date black women? Is he allowed to date the BW? If you're a billionaire and your son is LeBron James Jr. worth $100 million and potentially $1 billion one day, are you pressuring him? I don't mean to hurt nobody's feelings, man. We gotta have this is broke nigga shit. This is broke nigga shit. Because anybody with real money, it's a non-starter. Don't bring no BW in my house. And think about what I'm saying. I'm trying to hurt your feelings. I want to hurt black mothers' feelings. I want to hurt your feelings. This is broke nigga shit. Nobody with money, if you have a young black boy with money in future, you will be terrified if he dated a BW. You would be terrified. If your son is in college playing NBA basketball, all you are praying is that he don't date a BW. Can I get somebody to be honest with me? Can I get somebody to be honest with me? Do you know why LeBron James' mother is not pressuring him? LeBron James Jr. is not getting pressure because LeBron James Jr. is worth $100 million and we don't want no gold diggers. Who else can he marry that's a BW who's worth that kind of money, who understands what my son is worth, who won't try to divorce my son, who won't try to, look at Brittany Renner. Look what Brittany Renner did. Look at what Brittany Renner did. Look at what Brittany Renner did. This is recent. I'm not talking about Mike Tyson. I'm not talking about Robin Givens. I'm talking about Brittany Renner right now today. I'm talking about Brittany Renner right now today. Look what Brittany, LeBron James Jr. might find Brittany pretty. If he like black woman, she's light-skinned, she's pretty. Don't you think LeBron James' mother, LeBronny's mother is looking out over every girl he dates? Because she knows. See, Tracy, I'm not trying to put you down. I just want you to put yourself, Tracy, just be honest. Put yourself in if you were the mother of LeBron James Jr. and just be honest, bro. Just be honest. Just be honest. You're gonna be speculative over every woman that he dates. But in 2022, you might have to get counseling. I'm gonna be honest. You might have to go to church because you probably would tell your pastor, I'm conflicted because I don't want my son to date BWs and I think I hate myself. When we gonna be honest? When we gonna be honest? If you were a billionaire, Tracy, if you were a billionaire, you would have to pray about this. If you were a billionaire and your son was worth $100 million in 2022, you would pray. I know it because I know what I would go through. You would not, every black woman that he dated, you would feel some type of way about it. And then you would have to go talk to your pastor. You would be conflicted because you would wonder why she was there. And then you would ask yourself, why do I feel this way? Because I am telling you the truth. Only 5% are redeemable. And how do you know if she's worthy? How do you know if she's one of the 5%? How do you know if she had a mama, if she had a daddy? And is it fair that every black woman that your son bring home, that you sit her down and ask her all these questions? Think about it. If you had $1 billion and Megan and any BW came in the house, you might be polite, but you would say, hey, how's your daddy? Huh? How was your father doing? Oh, I don't know my father. He's in jail. I'm being honest. I'm being honest. See, when we talk about race, we talk about it from a black perspective. We should talk about race from a perspective of power. We shouldn't talk about these issues from our vantage point. We should take ourselves out of ourselves and talk about these issues from a different vantage point. Look down on the issue. You get a different perspective, Tracy. Look down, all the black women watching me, look down on it. Take yourself out of being a black woman. Put yourself in a different place. Look down on this issue. Look downwards. Put yourself as a billionaire and look down at the issue as I bring it up today. You will see it differently. Now let's get back to Atlanta. Let's get back to this district attorney. Because in November, we have a ballot coming up. And I'm going to tell you guys the same thing I said to Ferguson. Right now, you should be registering to vote. You should have your ballot. You should be a registered Democrat or Republican, because if you want to vote for the Republican candidate and you're registered as a Democrat, your vote will be voided. Right now, we need to be politically active. You need to understand that the district attorney with this messy, murky case was a black woman who was elected to power. I would challenge her in debates. I would put money behind a different candidate. I would ask her, why do you think the best solution for 30 black fathers is to imprison them when we created the problem as black people in Atlanta? These are black children. These are black boys. Some of them are under the age of 25. That means they're not even fully adults, not even fully grown like this 15-year-old. But this black woman says, throw them away. What about Judge Joe Brown? What about Judge Joe Brown and what he taught us about recidivism? Please, you guys, I don't hate BWs. I'm giving you a top-down perspective on this issue so you can see what's happening in Atlanta, so you can see what's happening in Chicago. I want black people to vote and become politically active and stop being reactionary so you don't react to a brand new aggressive district attorney. If you were buying politics, if you were buying land, then when this district attorney popped up, you would have known who she was and you would have known her ideology. But if black men say, I don't vote, then guess what? We don't know who the politicians are, and we don't know what their ideology is and what they believe. And when they come arrest us and we get surprised, why are you surprised, Young Thug? You own a multi-million-dollar corporation in Atlanta. You should have known who the district attorney is. You should have been involved in her election. I'm giving you guys a top-down view. You should have known who the district. Now, think about it. I make $50,000 a year, not me. But Young Thug is on his way to becoming baby Brian Williams, of the owner of Cash Money Records, $100 million company, maybe a multi-$100 million company. He has the beginnings of that now. Young Thug is the second coming of Lil Wayne. He signed Gunna, an artist who surpassed him. He just signed Jack Harlow, a Caucasian artist, who's the #1 artist. This is a real record label. Pushin' P is the hip hop song of the year. This is a real record label. Young Thug is the CEO of a multi-million-dollar corporation on its way to being $1 billion company. YSL Records, it's on its way to be the next Cash Money. So a lot of people hear these numbers and think I'm exaggerating. I'm not exaggerating. YSL is on a trajectory to be the next Cash Money. Mr. Blackwell made a comment that I spoke about 2 weeks ago. Mr. Blackwell, after listening, it was obvious to him that they won't be able to get Young Thug on really anything, right? So Young Thug and Gunna won't serve a significant amount of jail time. So Mr. Blackwell said, why is this happening? Well, I told you why. Because of the hate that the B-Dub has for black men and their success, and they had no other recourse. What the goal of this RICO case is to destroy YSL Records Incorporation. This is illegal. You cannot use the government to take down the corporate. We're a capitalistic country. The goal of this district attorney is to decrease the influence of these record companies in Atlanta. So we're going to call the record company a gang. We're going to put them through a RICO lawsuit that's going to bankrupt the corporation. Now, Young Gunna with Pushin' P, this is the song and album of his career. This song, he could win the Grammy this year. And this song and this album would catapult him into superstar fame. That's over. That's done. Gunna's rap career is over. We could play the violins right now. Gunna's rap career is over. Now, what we are fighting for is YSL as a viable corporation and record label. Now, the real question is, does YSL come out of this as a viable corporation in the American construct capitalistic country, right? Because Cash Money got $100 million from Universal 6 or 7 times, damn near $1 billion. How many record sales? Somebody look up what's the net worth of Cash Money. YSL was on a track to be the next Cash Money Records, worth over $100 million. Corporation CEO ran by a young black man, 30 years old. Black men don't have companies like Mark Zuckerberg had, but this is a young black man with a company on the way to be $1 billion company. That's not talking about the fashion, because Young Thug is a fashion icon. Kanye West made $1 billion in fashion. Young Thug has a clothing line that we haven't seen yet. He's waiting to put out his clothing line, waiting for Kanye West. But we all know Young Thug is a fashionista, a fashion icon. He planned to make more money in fashion than he did in music. The goal of this case was to kill YSL. The goal of this case was to kill YSL as a record company and a corporation. The RICO, if they had a crime that Young Thug committed, they would charge him. They used RICO because they did not have any proof that they could get him on. They knew his lawyer was Steele, so they used RICO. Even with the RICO, the feds have not come in. So you have to ask yourself, why? People are scared of black men with money and power. They want to cripple these black men and cripple their power and influence. This is racism. This is racism. This is why I've been going in on the BW, because it's a black woman leading the charge. This is racism. This is racism. That's what this is. It's a RICO. RICO means you don't have proof. You don't have proof, or you would have charged them straight up. This is a route. They are going to kill YSL as a label. Young Thug won't do no time. Let's say he gets found guilty. 1 year, 2 years. It doesn't matter. The record label is gone. Young Gunna's career is gone. Jack Harlow is going to sign with someone else. They accomplished their goal. The influence that YSL had in Atlanta is gone. That's why they're not giving him bail. They don't care about him going to jail. They're trying to kill YSL and kill the influence. That's what it is, you guys. That's what's going on. I love doing these court cases. I love doing these court cases. There's so much to unpack. There's so much to unpack. Did you know the Johnny Depp case was about Me Too? If you were watching my channel, if you even look at my thumbnail, in my thumbnail, I got Amber Heard saying Me Too. I got Johnny Depp saying Men Too. I've been saying it for 3 weeks. This case is not about Johnny Depp. This case is not about Johnny Depp. This case is about Me Too. This case is a referendum on Me Too. If Johnny Depp wins, then men win, their fathers win, husbands win. It says that you cannot convict a man on allegations. Johnny Depp got fired on allegations. What that lawyer was just arguing with Young Thug is that we don't know yet. All the state has put forth is allegations. We don't know nothing. I don't have discovery. We don't know anything on the case. All we have is allegations. Yo, Johnny Depp was so important for men, black, white, purple, brown. Johnny Depp fought that fight for all men in America. Johnny Depp is a champion. Johnny Depp will go down in history for being a John Wayne motherfucker, man. Johnny Depp is a John Wayne motherfucker. He did that for men. He did that for fathers. He put all of his business out there. He put all of his business out there for me and for you. Who's in the family courts? Who gets called domestic violence? Black men. Do you know how much Johnny Depp did for you for black men? You know, Me Too took out black men left and right. R. Kelly, Bill Cosby. Me Too was a way to hang black men. Johnny Depp just put a stick in the heart of Me Too. I love the court cases, man. I love the court cases. There's so much we could talk about. With men, with fathers, with black men. How we are treated in the court of law. How we don't get fair and judicial treatment in a court of law. That's what made me start doing this. Because Kyle Rittenhouse, everybody said Kyle Rittenhouse got too much justice. You know what I said? I said Kyle Rittenhouse did not get too much justice. Kyle Rittenhouse got the amount of justice that Americans should get, black men should get what Kyle Rittenhouse got. The judge should be my advocate. The judge should make sure and remind the state and the jury that I'm always innocent, and it's on the state to prove my guilt. And the judge should keep the state in line and not allow the state to get creative to prove my guilt. Kyle Rittenhouse did not get too much justice. Black men just don't get the same level of justice. That's why I started this. Kyle Rittenhouse was out on bail. Kyle Rittenhouse was out on bail after This is racism. Kyle Rittenhouse was out on bail after killing 2 people. Young Thug has not hurt a fly. As a matter of fact, Young Thug's baby mother was murdered less than a month ago. He's been at home helping the kids heal. Cherry, when you watch this in the replay and you so evil and vindictive toward Young Thug, do you know what he's been doing and where he was? He wasn't at a strip club. He wasn't with a white woman. He wasn't in Europe. He was at home with those children who just lost their mother to murder. I'm going to say it one more time, Cherry. Do you know where Young Thug was when he was arrested? Because Cherry said Young Thug is doing all this bad stuff. Young Thug is in the gang. YSL is not a corporation. Cherry didn't hear me describe YSL being a multi-million-dollar record company with the #1 artist, Grammy-winning record, on its way to be a billion-dollar company like Cash Money, where he came from. Cherry didn't hear that. So Cherry, where was Young Thug when he got arrested? Was he getting high? Was he on a street corner? Was he at a strip club? Was he with a white woman? Was he in Europe? No, Young Thug was at home. Jeffrey was at home with the children who had just lost their mother to murder. And now he can't even have his lawyer. He can't even have his lawyer. The state has brought a RICO case against him, arrested him, not giving him bail, which is his constitutional right. It's not a favor. Do y'all know giving me bail is not, you're not doing me a favor. You understand? You're not doing me a favor by giving me bail. Give is the wrong word. You're not doing me a favor by giving me bail. It's my right. Right? I'm an American citizen. It's my right. You're not my fucking friend. Okay? Kyle Rittenhouse had bail. Kyle Rittenhouse fought his case free. Murder, double homicide, right? But Cherry said Young Thug deserves everything he's getting. I don't know how you get there unless you hate black men. Are you that willfully ignorant? Are you that willfully ignorant? I don't think so. I think it's malicious. You know what people hate about me? That I'm so intelligent and articulate. I shouldn't be this intelligent and I shouldn't be this articulate. I should not be able to communicate these messages this way and this effectively. I should not be able to speak to you in a way that you can understand my intellect, because I know I'm more intelligent than you. But what makes me the host is I can take my perspective and I can communicate it to my audience. So now everyone in the audience is more enlightened. I know this for a fact. And I know this is why black people hate me, because black people are ignorant. And they despise my intellect and my vernacular, my articulation, and my ability to translate a message from a high perspective. I've been chosen to do this shit. I've been chosen to do this shit. Get over it. When you listen to me, get out your feelings. I don't have any hate for anyone. I love you. I love you, Cherry. I don't dislike anyone. I have a beautiful life. I'm extremely blessed. That's why I pray. That's why I pray, meditate, and I eat really good, and I get a lot of good pussy. I have a great life. I'm not angry. I love my son. I love black men, and I need these truths to be out and be told. I need these truths to be told, because black men deserve to be loved. Black men deserve to be loved, and black men deserve to be free to find love. If I could fuck a man, then why can't I fuck the woman who's going to love me back? If I could fuck a man, right, And why can't I fuck the woman who's gonna love me back? LeBron James Jr. gets it. You know what's so beautiful about this time we live in? Because anybody that has an issue with me, you cannot debate LeBron James Jr. He gets it. He doesn't know me. He doesn't listen to the Black manosphere. This is what's so hurtful. Bronny doesn't know me. Bronny doesn't listen to the Black manosphere. Something else shaped Bronny's opinion of you. You shaped Bronny's opinion of you. You did this to you. I need Black BWs to take responsibility the same way Black men did with the Million Man March. LeBron James Jr. doesn't know me. He doesn't listen to the Black manosphere. Something else shaped LeBron James Jr.'s opinion. Can we be honest about what that thing is? It's not Black men because we don't have influence and power in America. Something else shaped LeBron James Jr.'s opinion of you. Tracy said we need to help our Black community. Don't put them in jail. We need rehabilitate them, put them in job court, some classes. I agree. Do you know when I heard that interview from Judge Joe Brown, I've been in jail, I've been to court. I never knew that. Mr. Blackwell, like I never knew that. I have so much respect for Judge Joe Brown. And what did they do to Judge Joe Brown? Do you know Judge Joe Brown is not on TV because of Me Too? Man, God is good. Y'all see how this shit be connecting? This why people don't, this why the internet, this why I get froze. God created me to give you guys this message, and God provides the footsteps for the message. That's why the message be so powerful. Because I pray and I believe. I pray that you love me and you believe in me too. Do you know Judge Joe Brown? Tracy said, I learned that, Tracy, from Judge Joe Brown. Judge Joe Brown taught me about how the judge is held accountable on. I knew the term recidivism, right? But I didn't know that judges were judged on it. And I didn't know that judges were supposed to bring that percentage down. Judge Joe Brown went from an 80% rate in that courtroom. When he sat on the bench, he brought it down to 15%. People knew in LA that if you got Judge Joe Brown, you would not go back to jail again. That's just the fact. He will create a program, like Tracy said, that would involve all of the things. Because what he said in the interview is, I have all of those things at my disposal. We have state-run rehabilitation. We have state-run Job Corps. We have state-run psychiatric. I can force you to get therapy. I can force you to get an education. I can force you to get training. I don't have to put you in prison. And I can talk to you, bring you back into court as we go through the process, and I can father you. I can mentor you to make sure that you understand why I'm doing what I'm doing, and that what I'm doing is having a real effect on you. That's my job. I never knew the judge's job was like that you're not just supposed to throw people away for 30 years and never see the case again. That's not a good judge. Judge Joe Brown said that's not a good judge. You're supposed to be reviewing your cases. I was blown away. I was blown away. He said, I know all of my cases. I put them in jail. I was like, my mouth dropped. He said, not only should you be reviewing your cases, but the feds review your cases. I was like, he's like, yeah. You should know everyone you put in prison because someone else is reviewing that and it could come back up. So he said, if I ever had an appeal or anybody, I was prepared because I had been reading and I knew where there were mistakes in the case. Think about that, you guys. Think about all the movies that you watched. Judge Joe Brown said, I reviewed my cases, and you're supposed to review your cases, because other people review your cases. This is not the way Black men know judges and courts. That's why I started this process. Young Thug has not been getting treated like an American citizen in this court case. He hasn't. He's been getting treated like a Black man. How does he not have bail? He has not. There's not a violent crime here. So Young Thug children's mother was just murdered weeks ago. Young Thug can get bail, and he is the breadwinner. What happens to these children? Remember, it's a Black female DA and there's a Black judge. What happens to the kids, you guys? What happens to the kids? I just want to ask Trey, I just want to ask Cherry, and anybody, because I was on a panel the other day and there was a brother talking about, oh, them guys in Atlanta doing bad. Young Thug's, the mother of his children was just murdered. He was at home consoling those children. Now he's incarcerated, unable to get bail. Their mother just was murdered. Who is caring for the children? If this was a woman, she would be out on bail simply because she would have to take care of the children. He's not getting treated like a human because somebody said he's not being humanized. Black men are treated like dogs, like fucking dogs. My kid's mother just got murdered. I'm a CEO of a corporation. Who is taking care of my kids right now, Judge? I won't run away because I have a $1 million corporation to take care of that's going to be left to my children. They're going to inherit this record label. Why is he not free? If this was a white man, he would be free to run his business. If it was a white woman, she would be free to take care of her kids. But only Black men get treated like dogs. I'm only charged. I'm innocent until proven guilty. My corporation will fail. Capitalistic, you're supposed to protect my corporation, Judge. My company could go out of business. Who's going to take care of my company while I'm incarcerated? Who's going to take care of my kids? Their mother just got murdered. This is why I'm here, you guys. I know you haven't thought about this. Judge Joe Brown changed his life before he was a judge. So going back to Judge Joe Brown, what happened to Judge Joe Brown? Judge Joe Brown got taken out by Me Too. He's not on TV anymore because the people on his staff wrote a letter. 50 people on his staff wrote a letter asking them to fire him. He didn't do anything wrong. There was no crime. Judge Joe Brown would say yes, ma'am, and no, ma'am, and he would open the door for people. I got in trouble for this. I did. I got called into the office. Things have changed. You cannot say yes, ma'am, and no, ma'am in corporate America anymore, and you cannot be chivalrous in corporate America. I got in trouble for opening the door, holding the door. My boss said, don't open the door for women. Don't hold the door for women. Don't say yes, ma'am, and no, ma'am. I couldn't say it in corporate America. Some of you guys, remember when I said Black people, we at a low frequency, we dealing with stuff from being broke. Well, if you in a corporate environment in 2022, then you cannot open the door for a woman. You can't hold the door for a woman, especially if you're a manager. If you're a manager in the Me Too era, if you open the door for a woman, that could be seen as a sexual invitation. I didn't know that. And everybody listening, you should know that. You cannot open the door for a woman anymore. You cannot hold the door open for a woman anymore. And you cannot say yes, ma'am, and no, ma'am. You have to ask what are her preferred pronouns if you work in a corporate environment. Judge Joe Brown lost his job for being chivalrous and opening the door, closing the door, and saying yes, ma'am, and no, ma'am to people who were offended by the sexual orientation. Right. Non-binary, non-gender specific, gender neutral. You can't say yes, sir. I got in trouble for saying yes, sir, to someone who looked like a man but didn't consider themselves a man. Now, that's like saying the N-word. That's like saying the N-word. If you don't think you a man and I say yes, sir, that's like saying the N-word. So I had to learn that the hard way. Judge Joe Brown got taken out by Me Too. So when we talk about Johnny Depp, when we talk about YSL, when we talk about Kyle Rittenhouse, this shit is all connected. You hit a nerve on that one. I have a story to tell at some point. I'm out of the country now because of trusting the BW. Please, brother, when you get a chance, come on the panel. Because we got to talk about it, man. We got to talk about it. Because it's not for me. It's for my son. LeBron James Jr. already know. Tracy said her son already made up his mind. How? My son already made up his, like who is influencing LeBron James Jr.? Who helped him make up his mind? This is the conversation right here. This is the conversation. This is what it comes down to. You could, because people come to the Black Manosphere and get mad at the Black Manosphere and say that the Black Manosphere is doing it. The Black Manosphere is not influencing LeBron James Jr. See, when we're ready to have this conversation for real, when we're ready to come up with progressive solutions, that is what we're going to have to deal with. That's what we're going to have to deal with. No, it wasn't his mom. It wasn't his father. It's society. The BW is responsible. LeBron James Jr. has eyes. He can see. All of his uncles are basketball players. All of his uncles have the issue that you're having. All of his uncles are basketball players. You can imagine the stories he's heard. You could imagine the stories that he's heard. Society, you're doing it to yourself. And you want to blame the manosphere. You want to blame Kevin Samuels, rest in peace. It's not Kevin Samuels. It's not the manosphere. The kids have eyes. The kids can see. They're intelligent. That's what's going on. That's what's going on. Hey, everybody, as y'all come in, man, y'all hit that, I got to guess. Hey, Miss V in the background at the stream. Ms. V,
put me in the game, coach. What's going on?
Not much, not much. Having a good stream, good day, talking about all this young stuff.
I kind of missed a lot. So they didn't give him a bond?
So I got shut down before we got to that part. We was I don't know if somebody flagged me or whatever, but my internet went out, so I'm on my cell phone right now. So I don't even know what happened. When we left the case, yeah, when we left the judge, they were arguing. Young Thug has a very powerful attorney.
Hey, what's up, Tracy?
Hey.
Hi, everybody.
Young Thug has a very powerful attorney by the last name Steele. Atlanta does not want him to use that attorney in his case. So when we left, Atlanta was arguing that he should not be able to use Steele as an attorney because Steele is representing someone else on the RICO on the murder charge, right? But Young Thug is saying that this has been my attorney for 10 years. He's represented me for 10 years and he represents me in my business. If I'm not allowed to have him, then you really are violating my rights. Like, this is the best lawyer in Atlanta. The judge admitted that. This is the best lawyer in Georgia. He's been my lawyer for 10 years. And now you have a frivolous RICO case. And then the state says, I got to get a district attorney. I'm a multi-million-dollar corporation. And now you don't want me to have my lawyer. You want me to get a district attorney? How can he represent me effectively in the same fashion as Mr. Steele? And the judge admitted that Mr. Steele is beyond reproach. So when we left, they were arguing. So people need to understand how convoluted and messy this is. Like, the only reason they're doing that is to keep Young Thug in jail. If you had a slam dunk case, why are you arguing his representation? His lawyer.
Why? I mean, I'm not understanding that. When they start telling you what kind of lawyer you can have, obviously, I don't know a lot about the court system, but so that's crazy.
The state is saying there's a conflict of interest because
never been done before. They
Right.
always never been done before stuff to black folks all the time. We always the guinea pigs for all the bullshit. We know that. And
And,
it
and
started. It actually this whole Rico shit didn't it start with Bill Cosby or was it
so it started with
R.
John Gotti.
Kelly?
It started
John
with
Gotti.
John. It started with John Gotti and the Italians, right?
Wait, how
Remember
long ago?
that was in the 80s.
I'm talking
John.
about recent.
So
This is
recently they used the RICO against R. Kelly.
exactly. So
Recently
they ain't used it in years, and then they popped it back out with R. Kelly, and now they hitting everybody with that.
right. The only difference is R. Kelly was a federal case, which is why it happened in New York. This is not a federal case. And every other RICO you've heard about has been the FBI and the feds. This is not the feds. This is the state. This is this DA in Atlanta who has overcharged these young black men. This is a brand new district attorney in Atlanta who's seeking political gain.
Oh, that black woman, right?
Yes.
Always a black face. Always. I seen her. It don't matter what your status is. It don't matter how much money you got or what you do for a living. You come to Atlanta doing that, you going to jail. Yeah, she was talking all kind of shit. That's all I seen as far as this case go. I haven't seen nothing else.
So that's basically where we at.
Well, he pleaded guilty to all that. Why he ain't make them do their work? He just said okay, and he looking at all this time. He gonna get all that time.
No, he didn't plead.
He didn't plead guilty.
No, they
I
haven't
did
even.
hear them ask him though, "Are you pleading guilty or something?" He said yes.
That was another case. That was a 15-year-old boy who got charged with carjacking.
Oh, okay. Well, I didn't see anything then.
So the court, so they just been before they got up to Young Thug, they've been letting some other cases play. One of the cases that came on before, and it was good for us to see how they adjudicate trials. There is a young black man, 15 years old, carjacked a lady, and he pled guilty. And he got 10 years and 7 years and 5 years probation. So at 15 years old, there was no mother in court. There was no father in court. There was no grandmother in
Did you
court.
say 15?
15 years old.
They gave him 10 years for a carjacking?
No, I think it's going to amount to almost over 20 years.
For a carjacking?
Yeah, nobody was hurt. And then they found the car. The car wasn't messed up, but his girlfriend left something in the car.
Okay. Did he have a gun?
He had a gun, but they didn't say whether or not the gun was loaded or not. They just said he carjacked it, drove the car, parked the car in the apartments. His girlfriend left something in the car. That's how they found him. And he pled guilty.
What the fuck?
And no adult.
He could have beat without no money and no lawyer, but they didn't have him. They had his girlfriend. She must have turned over on him.
I don't know that to be a fact, but what bothered me is I've been that little boy and I didn't go to jail because my mama was in court, my grandma was in court. I did worse shit, but they knew I had somebody that I would go home to. You know what I mean? My pastor came to court. The judge was like, okay, this boy got a foundation. My pastor said he's going to be in church every Sunday. The judge was like, okay, probation. But
you know what? What pisses me off about it the most is you can rape a child and get probation. That pisses me off. It really do. I'm mad. I gotta be quiet.
What I said about Young Thug,
22 years. Come on, man.
A 15-year-old, he a baby. Tracy said her son 15. Like, what I said about Young Thug is that Kyle Rittenhouse murdered 2 people and he got bail. What about the guy you did a story on? All these white men, they get bail. Kyle Rittenhouse murdered 2 people, got bail.
He murdered 2 people and shot somebody's hand off or something. Like he shot 3 people.
And got bail and was able to fight his case in a nice suit, not in the orange jumpsuit. Exactly. He got bail. Young Thug has not committed this is a RICO case. All they have is hearsay. So that's why I went back to John Gotti, Teflon Don. If y'all remember Teflon Don. John Gotti got the nickname Teflon Don because New York could not prosecute him. They had 4 murder cases. They could not prosecute him. Giuliani became famous. Rudy Giuliani became famous because he was able to put John Gotti in jail and the mafia. How did he put them in jail? He created a law that broke the law. RICO actually breaks the law. In America, you have to prove I did something wrong with evidence. You have to see me or have proof, right? Well, RICO says that I can't get John Gotti. No one is going to have a fingerprint. I can't get him on camera. The only way we're going to get this man off the street is if you allow me to get this criminal over here to testify against John Gotti. Now, wait, I'm going to give the criminal something. I'm going to give him some money. I might let him out of jail. But this criminal will testify that John Gotti is the leader of a gang and John Gotti told him to kill somebody. Now, if you accept that, then we can get John Gotti off the streets. Guess what? They accepted it. The RICO law was made into law, but it was only really used in New York on the mafia because every other time you try to use it, the people appeal and they get out because it's violating their constitutional rights. It was only designed for the mafia because the mafia was doing some special heinous shit in New York. So the RICO law comes back up with R. Kelly. R. Kelly got tried in Chicago 20 years ago on a videotape. Everybody hate R. Kelly so much that no one ever asked, hey, what this new trial about? Well, guess what the new trial was about? The same case that he got vindicated for 20 years ago. Now, everybody would say, wait, you can't do that. Well, we're going to use the RICO law. If we use the RICO law, then we could use the witnesses from 20 years ago.
That's bullshit. That's straight up bullshit. And the RICO law was created for gangs. So what gang is Young Thug in? Ain't that a record label?
So YSL is a multi-million-dollar corporation. You know Pushin' P, right?
No.
You never heard the song Pushin' P?
No. I mean, I probably have and didn't know the. So I don't. Yeah, I probably heard it, but don't know what it is. I don't really listen to that.
I don't listen to it either, but Pushin' P is one of the #1 songs in America. Possibly going to be the
I'm sure I heard it and didn't know what it was.
Possibly going to be the #1 hip hop song of the year, right? That artist is signed to YSL. He also has Jack Harlow, a Caucasian artist with the #1 song, First Class. That song that everybody playing on
Where
their
my
show.
lemons at?
You know what I mean? Jack Harlow is a #1 artist right now, also signed to YSL. YSL is a multi-million-dollar corporation. But this district attorney is alleging that YSL is a gang. And what I say is, like, all of us have a little cousin that's a rapper, right? All of us got a little cousin who sells drugs, who thinks he's a rapper, right? YSL is not your little cousin. We listen to these stories and we think Young Thug is not your little cousin. YSL is not your little cousin's rap label. Young Thug artist has the #1 record in the country. He has a new white artist who's potentially going to be the next Drake. YSL is set up to be the next Cash Money, $100 million record label. Also, YSL is a subsidiary of 300, owned by Liar Cohen. Now, Sir Ism put in the chat, Liar Cohen. A lot of people know who Liar Cohen is because they came from Def Jam. He created 300. He created the Migos. He also signed Young Thug. He gave Young Thug YSL as a record label. But there's one more thing that people left out and why this is not a federal case. Liar Cohen, if you're a YouTube content creator, you should also know that name because what did he do after 300? He became a head executive at YouTube. So when people ask about whether the feds will come in on this case, I don't think the feds will ever come in on this case because then you could potentially bring in Lyle Cohen and 300 financials. And you're not going to bring in Lyle Cohen and 300 financials. Then we're getting into people like Tommy Mottola and the people who killed Prince and the people who killed Michael Jackson and the real gangsters. The real, not black gangsters, but the real gangsters. You know what I'm saying? Them small hats. So this case, if you look at that from that perspective, that YSL is a subsidiary of 300, this case never is going to materialize into something, right? So me and Mr. Blackwell were discussing, why did she do this? This is a racism. This is prejudice. This is something that a white person would do. She has brought this RICO against YSL to kill the company. Young Thug's record, as a record artist, what you got, 2-3 years? Young Thug's hip-hop career is over. He will never be a big star in rap ever again.
What happened to the one guy with the rainbow hair? He was in all this trouble and got out after snitching. He came back. What the hell? Anyway,
he don't sell no records. He can't sell no.
He cannot.
He can't sell no record. He could do an Instagram and people see his face, but nobody will buy his music. And I'm not putting Young Gunna down. I'm not saying that he's gonna be like a snitch. I'm just saying that popularity, when he get out of jail, he's gonna be over 30. There's gonna be a 16-year-old rapper who's gonna be popular. You got DDG, you got NLE Chopper, we got these young guys with their shirt off. Gunna is gonna be 30 years old when he get out of jail. He's not gonna be the number one rapper. Today he's the number one rapper. That's gone. Now, if Young Thug doesn't get out and have the ability to manage his corporation, then his company will be destroyed, right? So what happens? Gunna maybe gets 1 year. Young Thug maybe gets 1 year. That's not a lot of time, right? But the company is dead. Their hip-hop career is dead. And the influence that YSL had is no longer in it. That's what they want to do. They want to kill the influence of these young men by destroying their reputation.
I think it's always in a plan. Like, first of all, they rise up these young guys that don't really have a future, that's been out here thugging and shooting and getting it how they get it, and then they rise them up to be these celebrities, knowing that they cannot meet that expectation, and then they let them make them a couple $1 million, and then they put their ass in jail so they don't have generational wealth.
So look, Miss V, this is what I agree with everything you say. So when you get debates with some of the black men on the YouTube and people say something like you just said, sometimes black men will say, "Who is this they?" Right? And I'll get upset because who I mean when I say they,
White
right?
folks, the powers that be, the ones that put all the bullshit.
Okay, right?
Whoever they is, it ain't us.
Right, I know what you meant, right? But this is why I'm pissed off, and this is why I've been talking about black women, because in this case, the they is not them. The they is the black woman who is doing this, and all the they in this case is black. There is no white they. Atlanta is a black utopia. Atlanta is black Hollywood. Atlanta is a black chief of police. Atlanta is a black mayor. Atlanta is a black principal at your school. Atlanta is a black teacher. That's not how I grew up. If you grew up in Atlanta, it's black, 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 black. That means you created Young Thug. No. There is no. Go ahead.
Those are black faces who have no power, that's being puppets. That's it. They put them black faces out there to give us hope, knowing that they following the same rules as them. They just a face.
They are. But I'm just saying, who created the men and the women of Atlanta? There are no white influences. There are black families, black leaders, black infrastructure.
We under the same government.
But I'm just saying,
here's
my thing. The people who created the problem in Atlanta are black people, right? And the answer to the problem should be a different problem than what they would do, right? But the response is a they response. That's been my issue. That's why I brought up Judge Joe Brown, because Judge Joe Brown told us that we don't have to respond like they respond. You don't have to do 100% prison time. You could do rehabilitation. You could do drug rehab. You could do mandatory education. Judge Joe Brown took down his recidivism rate from 80% to 15%. And this black female DA is not taking the Judge Joe Brown vantage point on this problem. She is taking the they perspective, just like Joe Biden, throw all 28 black men in jail.
That's why they chose her, because they knew she was going to be a puppet for them. And so with that being said, they still in charge.
So
I'm sorry, I ain't giving.
No, I agree. I agree.
They know which ones is gonna go with the bullshit. They be the worst ones on their own people, and they know that. They've been doing this for years. They got it figured out. It's still they. I don't care if it's a black face.
I agree. I agree. I
Okay.
agree. I agree.
They
I
ain't
need,
getting out of that,
I
Tracy. They
need,
ain't getting out of that. Never.
I need, I need people to see that because I'll join on the Roger Report Live. If y'all watching on the Roger Report Live, Roger, we say something on the Roger Report Live. We say the VW has become a white supremacist. And more often time, when you see a black face in that position, it's a VW being used for white supremacy. And what I've done today is I want to call that out to people because we can't move progressively if we're not being honest about how VWs are being used by white supremacy.
Who
Because
killed
people,
Malcolm X?
so I think that
Who
just
sent
came
them in there? Is my point. See, it
that
was a black face sent by the FBI, right? Which is
well,
they.
it turns out now that the people that they said killed Malcolm X actually got exonerated and just got out of jail because they didn't actually kill Malcolm X. And the truth came out about there was actually FBI agents who were there who actually killed Malcolm X. Like that's a good story. Like them guys actually got exonerated. Like the men who were like, you killed them and went to they recently got exonerated with the family and all this shit. And
Yeah, they were being intimidated by them or something like that. It was still something with them. You know what I'm saying? I remember that because,
right.
yeah.
So I wanted to bring this up today, and me and Tracy was having a back and forth because, like you probably consider yourself one of the good black women, right? Tracy considers herself one of the good black women. In the 80s, in the 90s, when they had the Million Man March, I consider myself one of the good black men. I was offended when they said black men pull up your pants, get on the bus, Million Man March. I was offended because I knew my father. I was raised a certain way, but I had to accept the reality. And then the 5%ers come from the perspective that during that time, that only 5% of black people.
You Borgen.
Huh?
You Borgen.
Again? Damn.
And froze. Now you unfroze. You might be good.
All right. I'll hurry up. So during this time, we had a group called the 5%ers. And they were black men, and they finally just realized that only 5% of men are worthy and we need to change. And that's where the whole Million Man March came from. I say we have a similar situation now where we have 5% of black women are redeemable, right? And if we don't start addressing it and do a similar progressive action like the Million Man March, then we won't have a black community anymore. And it's because black men are afraid to address it. I'll say it because black men are the leaders, right? If black men don't come out and say that we have this problem and that we need to fix it, and we keep pretending like, and every time it comes up, we say you don't like your mama or it's an issue. Like if we don't address the fact that LeBron James Jr., because it's always, someone always pits it back on me. So this morning I brought up LeBron James Jr. LeBron James Jr. is not watching the Black Manosphere. LeBron James Jr. is not listening to Kevin
What do you
Samuels.
do? I heard you saying that. What do you do?
He got in trouble a year ago for saying he doesn't want to date black women, right? And he came up in the news 2 weeks ago for his prom pictures.
Proud.
Prom.
Oh, prom. Okay. What the?
Right.
Mm-hmm.
But a year ago, him and his dad got attacked because he said something in an interview
Wait,
about
he was with a white woman or a black woman?
with a white woman in the prom picture.
Okay.
But this is not the first time we heard about it. This was a big thing in the news a year ago when he said that he prefers to date who he prefers to date. But it went away. But his prom pictures came out 2 weeks ago. It all came up again.
Mm-hmm.
So what I was saying to my point about the 5% of worthy black women is that LeBron James Jr. is not listening to me. LeBron James Jr. is not listening to the Black Manosphere. LeBron James Jr. doesn't know who the fuck Kevin Samuels is. Something else.
He might know.
Well, I'm just more than likely it's 15-year-old. Something else is shaping his opinion, right?
Probably
And
the
now,
neighborhood they moved in when they got money.
No, that.
You know they moved out the hood. That's what got him there. He got two black parents that's still together. What swayed him is moving to the white community. I can tell you
No,
that
no,
right now.
I disagree. I disagree because
What
it's not
happened?
just it's society. It's Megan Thee Stallion. It's all of his uncles who are divorced paying child support. All of his uncles are basketball players. All of his dad's best friends are basketball players. They're probably all divorced. They're probably all bitter. They probably all have a woman trying to take their money. There's probably
And the other races take the money too. They take it
no,
just like
but
the white black folks.
I'm not going to disagree with that. I'm just saying what LeBron James Jr. experience is in life. And we have to be honest about what he is seeing. He is not seeing my opinion. He is seeing how he's seeing the BW and he's making a conscious decision. He is seeing Meg Thee Stallion. He is seeing.
Okay, you froze. So we gonna still blame them for that because they raised up Meg Thee Stallion to be this role model for black girls and be this like this is the role that everybody is supposed to follow. So who rose her up?
So,
They
but
did.
this is the thing.
So
I'm
screw
talking.
on them.
So this is the thing. I'm talking about like with the million. Is it to show and educate not only black women but black men? Right? That's what the Million Man March
I
was about.
missed it because you froze in the
I
process.
see it too. So the Million Man March was was about us checking us.
But wait a minute, because I'm trying to understand something. You said something about being upset about the Million Man March because they said black man pull up your pants.
No, I'm saying I'm admitting how I felt when I heard it.
How
Just
did
in case.
what did they say? Because I'm lost.
No. I speak in analogies, right? Just in case there's a black woman listening to me right now who may be upset with what I'm saying, right? Because she considers herself a good black woman, right? I'm putting myself in your shoes. I too felt the same way that you may feel now when people said the same thing about black men, because I consider myself one of the 5%. I consider myself a good black man. But I had to be honest about what the situation was on the ground for us as a people in America at that
Well,
given time.
honestly, with me, I don't feel no kind of way when people be like, well, black women, because I don't fall into that category. I'm not a hit dog. I don't know who you talking about. I'm black, but I don't get hit by the black women because that ain't how I think and that ain't who I am. So what you think don't matter as far as how it make me feel. I'm good.
So I respect that. So what I'm trying to do is put myself in the perspective of someone listening and maybe in the replay who feel like they're in that 5%, but still the understanding is the problem has to be addressed. What I had to respect at that given time is that the problem needs to be addressed. Whether or not I'm affected by it, whether I'm a hit dog or not, we have an issue with black women and black mothers and how what they are producing. 75 to 80% of the households are ran and led by black women. They are the producers of these children in these cities who are in the gangs and causing this violence. We have to talk about it. We got to talk about why.
But where the fathers at though? We don't never want to talk about that part. Okay, so it take a man and a woman to have a baby. Whether dad is in prison, whether he just a deadbeat, you still gotta blame the person, the parent that's not there. In my opinion, too.
No. Because what we've proved in the past 20 years is that, and this is not just by me saying it, this is by the census, by people going door to door and saying who lives here and what you do for a living, how much money you make. What we found out through data, which we didn't have before because we didn't have computers like this, but what we know now by the data is that there are more than enough good black men to avoid that argument. Over 60% of black men are single, no kids, and make over $50,000 a year. So what we learned is from the numbers is that the VW is choosing to procreate with a Pookie. And then when we look at the Pookies over aggregate of black men, it's only 5% of black men who fall into this category. That's why you got brothers with 30 kids, 40 kids. Because in order, this is a reality.
That was a hot mess.
But the reality is the majority of black men are the good black men that the city girl won't date. Let's just get to it. The the majority of black men are the good black men that the city girl will not date, right? They get cheated on and they get left and they get put on child support. So they're leaving black women by the droves, right? Because in the black community, a good black man is seen as square and expendable. And we're not honest about that. So good black men don't feel valued by black women who value what the city girl value. The same girl who said last week that Martin Luther King ain't shit. Remember the girl Simone who said Martin Luther King ain't shit? You know what she said? She got famous before that. She said, I don't want to date someone with a 9-to-5. What are you telling black men? And this is the black woman that black women look up to. When she first got money, she said, I got money. I can't date nobody with a 9-to-5. Then you just got famous again for saying Martin Luther King ain't shit for having multiple women. But you want a man who don't have a 9-to-5 who's worth $100 million, but he only gonna sleep with you. It's like it's not real. We're not being honest about the problem in our. It's not a two-sided problem. It's black woman is the problem, and black women keep choosing bad men. And by the aggregate, the majority of black men are good men. That's why Kevin Samuels got to be 1.6 million, because he kept telling black women, no, that's not true. 60% of black men are single. And my son,
I don't really believe the statistics. I'm just be honest. You can make that shit up. Who take the statistics? And as far as those census and stuff like that, you know how many people don't open their door? They don't know. Like a lot of people don't even get their census read. So those damn
in real life, the 20-year-olds is not fucking. We was fucking. Okay, let's get down to the brass tacks. The 20-year-old is not fucking. Okay, they not fucking. I was fucking. They not fucking. They not fucking. They not fucking and they not dating. They got mental health issues. They own pills. They own uppers and downers to deal with their shit because society put them in. But the 20-year-olds right now, they're not having sex, and you know it. They're not dating.
Who created the drugs, man?
It's not about who. It's not about who.
Society. To me, it's society.
It's not about who. It's about the fact
that the way that they want it.
It's about the fact that black men have chosen not to date black women or white women or any women. They are afraid.
So this is just they dating men. Is that why
they are? Yes, they are.
That's why they're changing the whole world.
By design, but
exactly.
So when are black women going to get in the fucking game and say we got to start changing who we are? And it's going to take the good women to say to the 95% that look what's happening by design.
It's all kind of different women.
Your men are leaving you for other men. Your men would rather be with another man than put up with your bullshit. How about you create a better environment?
That's because they putting estrogen in men they sneaking it in men. They putting it in they putting it in the water. They putting it in the food. They're putting stuff in vaccinations and stuff. You know what I'm saying? It's still them. No matter, you could bring up any scenario, and I'm gonna still take it right back to them.
No, I agree. But perfect timing is saying that the solution won't come from them. Like they say, the revolution won't be televised. Everything you're saying is right, but the solution,
New world order, is what it is.
But the solution won't come from them. They didn't do the Million Man March. They didn't support the Million Man March.
That Million Man March, I don't even remember. So I don't think the Million Man March is affecting anything.
It was pivotal. It was. It changed a lot. It was pivotal.
Did it change some laws?
It did. It changed culture and behavior. After the Million Man March,
I don't even remember the Million Man March. So people that's in their 20s, they don't even know about it unless they read about that shit.
But they had it to read.
How many people you think read it?
Think about that. No, think about the Million Man March. Wait. Think about that as a black man. Think about that. Think about what we accomplished. It's in history. No white man helped us. And we changed culture and behavior. That's a hell of a thing to have in history, right? That's pinnacle. That's a hell of a thing. That's an accomplishment for black men. That we saw that we were fucked up. A white man didn't tell us. A black woman didn't tell us. Black men recognized for their own self that we had to fix some things, and we fixed them. That's a hell of a thing to have in history, right? I'm proud of that.
I just don't remember it. I would literally have to look into it because that was before I was following news and stuff like that.
But you can though.
Yeah, I
The,
could.
the,
Yeah,
the
I
beautiful
didn't ever
thing,
think about it till you bringing it up now.
and the beautiful thing is that it's there. It will always be there. And the solution that exists today, if Black women decide to do something, it will stand the test of time. And even if they sway off, you can always veer back to that point of when we checked ourselves. Hey, Black men didn't tell us to do this. White people didn't tell us to do this. We recognized there was an issue between us and our men. And we said we want to do something about it.
What do you think the Million Man March fixed? What was their goal anyway?
So there were 10, they were like 10 commandments. And there's a movie for Spike Lee, Get on the Bus. And there were 10 tenements they were asking of Black men, like pull up your pants, get a job, take care of your kid, be more respectful, protect Black women. It resonated. And the movie resonated. After that, you saw a trend of marriage. After that, you had a song. I talk about this a lot because in the manosphere about when things really changed. We were on the streets in the 90s. You had this Million Man March. Then you had neo soul, and you had songs like Jagged Edge, Meet Me at the Altar, and there was a trend of Black love and Black marriage. And a lot of us who were in the street life, when the money came in via the hip hop and things like that, we transitioned to marriage. A lot of us got married in the late 90s and the early 2000s, along with the neo soul. After this movement, Black men got off the street, stopped selling dope, got jobs, and got married. Where we are now,
It's amazing how music can change things though, because just like all of those beautiful things you just said about the music and how it used to be, who's in charge of that? Them. They control who they produce, who they put out there before the world. They don't want positive music for Black folks. They want death. And that's it. And that music is causing all of it. It's causing a lot of this, man. And the people that control that, which is them, they pulling the strings on everything.
when we first did the Three Kings, one of the paramount topics that we talked about was drill music, the effects of drill music, and how drill music has been proliferated out of Chicago. You know, drill music has been in Chicago for a long time.
It's death.
Drill music ain't new. For some reason, somebody, like you said, wanted drill music to get popular and be in every other city and create the same shit in every other city as it was doing in Chicago. Drill music never should have got up in Chicago. Just so anybody listening, what Miss V is saying is very powerful and very true. The powers that be saw that as a way for us to hurt ourselves and said, we need to get drill music. We need to push drill music out everywhere because the effects and powerful music.
And they don't even want to hear nothing positive. I hear too many people saying, if you got positive music, you ain't going to make it nowhere. So, I mean, this is just the way that they want it. It would be nice if Black folks would stop being they fucking puppets.
I agree.
And just say, forget it. I can make it on my own and stop giving them your money. What would the world be without Black music?
I agree.
I wish they understood the power that they have.
I agree.
They don't. So who do you blame for that? Because a lot of these rappers are speaking deaf, and those are Black men. If they were strong enough to be like, you know what, I'm not going to continue to kill my people with this dumbass music. But they don't.
Short-sighted. They're short-sighted. Like what we say on the Roger Report is you have a lot of women-led men, right? And that's a polite way of saying bitch made, right? But a lot of women-led men, right, who don't know their father, who have never had men in their life, and you're asking men to do some logical things, right? And to you, I can see on your face, these are very logical things that should be a simple thing to do for a man. But we don't have a lot of men who have been trained to be men.
And their fathers ain't men.
To be able to make logical, calculated decisions. The other day, we were having a discussion about masculinity. And I was talking to men about how we have an inability, like in America, it's become perverse, that women are raised with the understanding of death and killing. as it relates to Roe versus Wade. I don't want to use that word, right? But women are raised to understand death and killing in a more logical, realistic, circle of life way, right? But whoever talks to a young boy about death and killing, right? And the appropriate time to kill something and the appropriate time for death and these decisions, right? Like to really be a man, because if you're a soldier, you go to war, you're going to have to kill somebody, you know what I'm saying? But no one ever talks to you about it. But if you're a woman in a Roe versus Wade America, you're going to have a talk with your OBGYN, you're going to have a talk with your mom about family planning, and you really understand whether you believe it's a baby or not, but you understand that it's within your rights that you make this decision. It's not a light decision, but I can make this decision of where I want my life to go. That's a very logical, calculated thing that women have understanding in America. But it used to be men had to kill a cow. Like people, you know what I said to God? I said, man, we need to stop going to the supermarket. Because every time I bring up killing, you think I'm talking about killing a person. But if you, Amber Heard, people don't get why Amber Heard was such a gangster. Imagine growing up and your pet is a cow. And then one day your daddy take you and you kill that cow and he cut that cow up and put it on the plate and he tell you, if you don't eat, you're going to starve. This was your best friend. You knew this cow since you was 8 years old. Your father just slaughtered this cow in front of you, cut it up and cooked it and put it on your plate. It said, if you don't eat it, then you're going to starve.
That's cruelty.
No, that's a country girl.
You shouldn't be able to get close to the animals they know they gonna kill. But anyway, yeah, that's rough.
That's a country girl, right? That's a country girl. That's what it's like growing up in the country. You learn that lesson young. She get over it. She's still a girl, but when you meet her at 23, she's different than other girls you met. It's a country girl.
Since you brought up Amber Heard, did you hear how her and Johnny Depp met in the first place?
Yeah, on the movie.
But did you know allegedly that he was with a woman for years, the mother of his kids, he was with her for years and he never married her? And
yeah,
then he ended up leaving her for Amber, who was in a full-fledged lesbian relationship.
Yeah. She was married to a woman.
Okay,
yeah.
So that's why Johnny Depp, he really get what he deserved. You know what I'm saying? When I was first watching this, I felt bad for him because of what he was going through. But when I found out how he did the woman that he left for her, I was like, that's karma, baby. He thought the grass was greener. He shouldn't have never did that. That woman took him through hell.
Johnny Depp was 52 years old. Now imagine him being your homeboy. And she 23. You know everybody who loved him said.
See, I didn't even know that, but that's what he get. I'm just being honest.
Everybody who loved him, I know they told him, it's okay if you date her, you sleep with her. Please do not marry her.
Old ass shouldn't have been with no 23-year-old.
No, he should not have
pedophilia, you ask me.
He should not have been. So when I discussed Johnny Depp, it's a theme I have on my podcast that my old co-host of mine named Sunclaw, and he illustrated this point. And he would say, perfect, a lot of the things you talk about, you're illustrating needs versus wants.
He rather be with a woman that want another woman. That woman didn't even want him. He probably had to bring other women in there to please her.
Listen. He said, you are illustrating needs versus wants. And a lot of times I would like to do a show where you talk about to people so they understand a lot of times in life, they would be more successful and happy if they could figure out their needs are more important than their wants. And most times when you find yourself in the ass end of a situation, you put your desires before your needs, right? Johnny Depp put his desire, his wants before his needs. And now he ended up in a sling, right? He wanted that young 23-year-old woman, but that was not what he needed at 52 years old. That was not what his children needed. But this is in America, you know, we microwave cocaine, premarital sex.
Now the court's got to clean up his shit this many years later.
But the kids
he caused his own damn problem.
The kids never get it done. The kids
That's
never
what he get. I'm sorry. I'm not sorry. That's what he get. Because
No,
I'm
no.
thinking about the woman that he was with that was loyal to him, that was stuck by his side before he was Johnny Depp all the way, correct?
Johnny Depp is a lesson for all men for so many perspectives.
Why ain't nobody talking about that?
I talked about it for a whole week.
Oh no! Oh, you talked about how he got with the woman and stuff.
Yeah, I talked about it
Okay,
for. I talked about it for. That's
I
why I
missed.
know. That's why I know about it. The movie was called The Rum Diaries.
Oh, I ain't never seen the movie.
Me neither. He met Amber during The Rum Diaries,
Hmm.
and then he didn't see her again for 2 more years. Is what they claim. I believe he fucked her on the movie set. I believe she only got the movie because she gave up the pussy, and I believe that he never stopped fucking her until they start dating 2 years after that. And you pay for that in life. People think that karma not real. You can't do that to people. You
But he
cannot.
ended up winning the case, right? He won the case.
He won the case, but he didn't. He doesn't. He got fired from Pirates. He got fired from Harry Potter, and he lost $650 million. He didn't.
Dang, he really lost it. Man, okay, so I heard they got a petition going to try to get him back on the Pirates. Last time I checked, it was like a bunch of signatures, like 1 million or something. No,
Well,
maybe, yeah, about 1 million.
So what happened was he was vindicated, right? So now Disney can't make Pirates without Johnny Depp. You can't make Pirates without Johnny Depp. It's not even like you can't even. Let's not even argue that. Johnny Depp vindicated. Amber Heard lied. You fired him for no reason. You can't make Pirates without him because nobody will go see it, right? Disney's in a screwed up situation, right? Now, because everybody is championing Johnny Depp. So if you ask me, check this out. Since we on Johnny Depp, I'll share with you my opinion of why it happened. So remember, you've been talking about the they, right? The all-powerful they, right?
Yeah.
So Disney made an announcement a couple weeks ago that 50% of their actors would
Disney
be
pedophiles too.
exactly.
Anyway,
But you can't say that. You can't say that word. YouTube don't like that word.
Okay, pedos. I know.
Yeah.
I knew that. Hold on, I gotta walk away right quick. Sorry.
Oh, they calling you back to work the drive-thru? Y'all know Miss V work at McDonald's, right? Y'all know she at work right now. She be taking breaks and shit. Her family probably owns 6 McDonald's and shit. That's why she get to be on YouTube at the same time. She about to go yell at her.
Let me go catch this order right quick at the drive-thru.
See? That's like going to Disneyland and Mickey Mouse ain't there no more. Facts. Hey, you guys. Thank y'all for hanging out, man. My internet's still down. Oh, we back. All right, we got some internet. You know what I'm so proud of, you guys? I gotta call my big brother, because my big brother, big black man. I gotta call my big bro because he coming back into my life and him sharing some things with me have really helped me manage my emotions a lot better.
Hi everyone, Mark Barden here at Sandy Hook Prom.
And you know, with the way the events of the morning have went, typically I would have been really frustrated.
Emotion is
But I've been pretty even keeled, and I think it's because my brother come in my life. I know my mom passed away, but I remember overreacting with a lot of this stuff when YouTube would pick on me, when people would flag me. Oh, I would get upset. I would think because I like Angry Man and Tommy so much, right? So I would think because Angry Man and Tommy would cuss out everybody, that I would need to cuss out everybody. And really what it was is I was angry and I was using my platform to get off my anger, right? So what I do now as a man is when I'm upset at YouTube and I'm upset at StreamYard, I actively, consciously think about my emotions and I put them out and I make a logical decision to continue going forward with my podcast and not address the frustration. And look at the views. The views have gone up. I used to just get upset and start cussing at the screen. And one day my big brother said, stay on topic, keep teaching. And I was upset because I'm like, big bro, you don't understand. And YouTube, you gotta address the beef. And then you know what I realized? I was like, there's not no disrespect to the people watching me, but one day the channel is gonna be really big, right? Right now we're getting bigger, a few people watch. But do you guys see how many people watching the replay? And what I realized from my brother is I'm being disrespectful to the people who watch me, who may not watch me live. So when I overreact, the people who don't watch me live, who love me, who are entertained by me, don't get the person that they came to see. So it's been very difficult, right? Because I see the numbers go up and down. I see the shady shit in the chat, but I've learned to ignore it because my big brother in my life, and I've learned to stay focused and be on point and create better content. And it's showing up in the channel and the views and in the replays. People are better able to be entertained by the content because I don't get shaken by the people who be doing the sucker shit, right? And I never should have in the beginning. But I came into YouTube under a mistaken tutelage, right? Just because those YouTubers cuss out the people doesn't mean I have to cuss out people, right? And that's what I learned. And I realized that a lot of people watch me, and because it's kind of difficult doing this YouTube thing, right? And understanding
I hate I missed this talk because you've been spazzing out some of the time I be popping in here.
Oh
Like,
man,
oh, I don't think I'm gonna say nothing. He tripping.
see, come on, man.
Man, you was like, this shit ain't for free, bitch. Send me a cash app. I'm like, what? Like everybody get offended, even me. I'm like, wait, I'm in the chat. What the hell are you talking about? So
You just said hit dog don't holler.
Well, that's what's that?
Wait.
Dang. Okay, it's the V show. Oh, okay. Dang, he backed that quick. What you do? Get on the internet?
Yeah, I'm back. We can go back to the.
Happy birthday, Tracy. You know what? I did not know it was your birthday, ma'am. And happy birthday, Miss Timing.
They both Gemini. Geminis ain't shit. This ain't.
Well, Gemini men ain't shit.
Here we go. See.
Well, I only experience men in a relationship. Gemini women is cool.
Experience Gemini women, and it ain't about y'all right now. It ain't about y'all. It's about Young Thug and Mrs. B in Perfect Timing is on the podcast. Not no damn Gemini, and they just always want to be about them. They want to be about both sides of their lives.
What's their birthday? Happy birthday, y'all.
Even if it ain't their birthday, they would lie.
Check your cash app, Tracy.
They would lie and say it's their birthday.
I'm mad she didn't tell me. Oh, you got it. Maybe she just said thank you because I said happy birthday. But yeah, check your cash app.
They would lie and say it's their birthday. Because that's what Geminis do, they lie.
So today the 2nd. I didn't even know, Tracy. That's crazy.
That's what Geminis do, they lie.
Geminis are liars?
Yes.
Your wife is a liar?
It's inbred in her to lie. She got two faces. And to them, they don't think it's lying. To them, they don't think it's lying because it's too.
Okay. So back to this money. You talking about a hit dog? Nah, but I was like one of the only ones in the chat. It was like me and just me, I think, that day. And I was like, well, who the hell are you talking to? And I never said nothing because you was angry. I was like, I'm just gonna take my ball and go home. So yeah, I'm just telling you that because you will make people feel bad and make them leave. Even though I know me and you ain't had no problem, I didn't know why you were so angry and saying talking like that. I would never recommend that you do that again about cash apps because you know YouTube is a choice. You chose to do this, and so nobody really owes you.
If they
Cause I
watch
was
me,
like,
they owe me.
so I owe you right now.
Yeah, if you watch me and you enjoy
So
my
you owe
content,
me then. Where my bread? Where my cash app?
so if you don't want to donate via Cash App, you should donate via hitting the like, hitting the subscribe,
Playlist. I seen your description.
all
You was
all
asking people to
all
run your
that.
playlist,
So
but
I give people instructions to support for free, but there is no option to not support. You know what I'm saying? This is not a free platform. It ain't free for me, and it ain't.
okay. So
So
the
that's I
support,
got to get that out
the
there. And I'm
support
okay. I'm
comes in
okay
for
if
the
people.
view, for
I'm okay
watching.
if people don't like that. I'm okay
The
if people
watch
don't like
hours is very important. The view ain't, but the watch hours, the
this.
people that's sitting in your chat, those are very, very important. So even the people that be watching from the clouds, because that's something I noticed with your channel, that you might have like 10 people watching, but 2 people commenting. So I don't know what the heck do that be?
I got hate people. I got hate
But
watchers.
haters watch you like that. That's support.
Yeah,
That's why they say your haters is your fans.
yeah,
Because shit, they watching the whole damn shit.
yeah.
Look,
I
I'm
got a lot of
cussing
people.
Tracy.
I got a
You
lot of hate
welcome,
watchers.
Tracy. Buy some dinner or something when you get off. As a matter of fact, I'm about to go across the street to this crab place. Man, I've been having a taste for that for like 2 days.
What is it? Boiling crab? What you got out there?
It's called Cincy crab.
It's like boiling crab though.
Yeah, where you had a bag, boil
Yeah,
bag or
yeah,
whatnot.
yeah.
I always be telling them, I don't want my sauce poured on it because it'd be too messy. I might eat it messy today. I don't know. Just
That's
to
what
see,
they call
just
it.
to get the real.
They call it hot and juicy, right? The hot and juicy sauce. That's what you want it to be. They call it hot and juicy.
No, this is you well, yeah, it is. It is, man. I get the extra spice. Yeah, my mouth watering. I'm about to go over there.
Is you gonna get
Dang, I
cross?
just think Tracy my food money.
Tracy, go get some crab. Tracy, go get crab boil.
Yeah, because it's under $20 too. The
No
one that I
way.
get.
Oh, not in
It's like,
California.
huh?
Not in California. Crab is market price.
Yeah. Facts.
Everything,
Yeah, Tracy, man. That's what
everything
I'm
on
about.
our menu, on the seafood menu out here, it's a market price. It don't even got a price.
I think I'm gonna go live too because I got to do my live. I'm doing a 30-day challenge. I started yesterday,
On
where I'm
what?
supposed to go live. I'm supposed to go live every day this month for at least 30 minutes. But I'm trying to just like I've been slacking a little bit because I've been so busy in the background. I'm about to come out with a lip gloss line. I'm revamping my website. I got a brand new website coming. I'm offering courses online, and um I started a new YouTube channel.
Oh yeah, what is it? Promote it right now.
And I got denied monetization. So that's also helped me start a new channel. But
What you
eventually
mean?
yeah, they denied me monetization again
Why?
because they say I reuse content.
Oh fuck, they gonna do that
It's
to me?
not true. No, they not. For me, they going back to when I first started YouTube. When I first started YouTube, I was learning and I was editing videos using other people's videos. And
Oh,
so
okay.
those are some of my most popular videos. So basically, to be able to get monetized, I'm gonna have to delete all of them videos and
And
either
that's gonna be
delete them, huh?
that's gonna mess up your watch hours.
I ain't even worried about that. I just want the videos. You know what I mean? Because
Oh,
it was a case that I was working on, Orson West, and there's some very important videos that I really want because that case is near and dear to my heart. So it's like, and even though I wasn't talking in it, and it was somebody else's content, I still edited them and stuff like that, and it just showed, what I did in the beginning. That was the first big case I worked on. So yeah, I'm having a hard time deleting my videos, but if I want to get paid, I'm gonna have to do that, and I ain't on it right now.
it's funny you bring that up because I have been doing things to my channel where I took down some videos again. Back to the same thing about the Cash App. Like I agree about maybe my tone and vernacular, but I'm not backing off of my pay to play. So people need to really understand that I recognize my talent and my worth and how good I am. And I, a lot of times I'm pissed that I came through a black window because I know I deal with this shit because it's black people. Only black people got this issue of paying for something that's of value, right? So I know niggas act like niggas, so I took a lot of my most valuable content off my channel that I know people rewatch for emotional and spiritual upliftment, but they don't support and they don't donate. I got bills.
It don't matter if they donate or not. When you get monetized, those videos gonna pay you.
But I'll bring them back when I get paid.
But no, let me tell you something. Hold on. You need to notice when you private a video, those watch hours no longer count.
I saw that. That's why I'm bringing it up in the same context of you bringing this up. When I took all that content off, my watch hours went down.
Yeah, and they ain't gonna come back when you unprivate it. You can't private or make videos unavailable.
So I'm
not
okay.
If you want credit.
I'm okay with that because you know who else was getting paid off of it?
Who?
YouTube.
Because they put ads on it.
So there's this thing where they're pimping black men. I've talked to other black men about this. They keep black men below 1,000 because they keep it like a dog yipping at the bait, right? And I create so much money. Think about all of the black men under 1,000, how much work we put in, how much fight. When you said I'm gonna go live for 30 days, I'm like, I do that in my taking a shit. I go live every day, 4 hours a day. I mean, if you look at my channel, I got over 200-300 videos. I've been going live every day. Black men who are chasing this 1,000 subscribers, they are lining the pockets of YouTube.
You know how many videos I got?
I'm just saying, from my perspective,
1,600.
I understand, but you're monetized. Think about you're over 1,000 subscribers.
I'm not monetized.
But I'm just saying, think about you're over 1,000 subscribers. Think about the black manosphere and how many black men on YouTube are vying to get monetized and how that generates revenue for the company. Everybody say y'all need to stop arguing. YouTube ain't never sent us an email to stop the bullshit. They want us
to like the bullshit.
They like the bullshit. It pays YouTube. And as long as we're under 1,000 and we're all trying to slit each other's throat to get to 1,000, creating content, they are making buku bucks. I'm not getting paid. I'm not getting paid for my efforts.
You would have eventually.
For my intelligence. So I took the videos down. I still have the videos. I can put the videos on another platform, but YouTube is not going to pimp me for another year or two to when they want to pay me like a hoe, as they've already made millions of dollars off my content. Then you want to send me a check for 2 cents. When you actually made millions of dollars off my content. But like you said earlier, I've allowed it. I allow myself because of what I put needs versus wants. I want the popularity. I want the subscriptions. So I allow
you just gotta keep at it. Like, don't get discouraged.
Well, that's what I'm doing.
Don't get discouraged. Just
no.
boost yourself up.
I'm
you
excited.
know what you should do? Network more. Go on more people's panels. I know you go on a Roger Report, but just maybe do a little bit more of it and promote yourself. And I'm about to bring back. I'm promoting, like, for these 30 days. I'm allowing people to drop their links in my chat and stuff like that. I started yesterday and I did that. And then Sunday, there's a thing going on called the Live-a-thon, and they got some slots open. If you want to get in on that, I could get you in touch with the ladies that's in charge of that, and you can get in on that. Huh?
I don't fuck with them. Yeah, you said Sheila E, right?
Oh.
Yeah, they messy. Sheila E, Bomb Cherry. Like, be careful, man, with them. You know what I'm saying? You see that shit going on? You see that shit going on between? You see that shit going on between Snoop and Misunderstood?
I hear. I hear the names.
It's hard to miss it. It's hard to miss. I'm just saying.
Yeah, it is because I ain't in that sector, but I do follow Misunderstood.
You're not right, but okay. So listen, look, them some messy bitches. You had your issue. You had your issue with messy bitches before. This is the thing about black women, the way they treat black men. Mama Shirley raised me. Ida Mae raised her. Like, I was raised by a bad black woman, a bad bitch that none of you black women could ever be. But y'all act like we ain't shit. We don't know nothing. But no, I learned everything. So I know what a real messy bitch is because I seen my mama whoop.
Well, okay. So I found out through Sheila E, and I don't know the other people, but Sheila was making changes on her channel and saying, you know, she want peace and all that kind of stuff. So I mean, I'm not planning on getting in on the stuff. I made the intro for them, and I got a slot. I'm not gonna be. See, I don't entertain
They're
it if
trying
it
to
don't have
use
nothing
you.
to do with me.
So be careful because people do that to me too. They trying to use you.
Well, it's not using me because I'm a business, and so anything
I
that I
said the
put out
same
there,
thing, Mrs. I said the same thing. And
anything that I put out there, like the
look,
intro, is
look,
gonna
look.
come
My
back
wife,
to me.
look, my wife warned me too. And now look how niggas act. I knew Too Raw was trying to use me. I know because I know how good I am. I am charismatic. I am compelling. People want to use me for the light. I said to my wife, it's a mutual thing. It's a business. He wants to benefit in a certain way. I want to benefit in a certain way. So I hear what you're saying. But these niggas on YouTube, man, we got to stick. The real motherfuckers got to stick to the real motherfuckers because when you just said that you made that intro, I don't need to hear nothing else. I know them bitches in and out because I done met them bitches in real life. Archetypes. You know what an archetype is? Like when you write a book, you know what I'm saying? I know, so I know that character. I know Bomb Cherry. I know Sheila E. in real life. My mama smoked crack. I sold crack. I know these people intimately. I'm really from a place where that's why they don't like me, because you say and you move and you do a certain thing, bitch. I'm on your ass, bitch, because I know that mannerism, because I sold crack. I know niggas, I know messy bitches. And when you do certain shit, I'm on your ass. And I'm never going to fuck with you because I know you so much. You was my crackhead auntie. I don't care if you rehabilitated. I don't care if you changed. She still fuck with Bomb Cherry?
I don't know. I don't know Bomb Cherry. I heard the name, but I don't know her.
Just be careful, bro. Just be careful. Just be careful, because
Always.
I don't think people change overnight. And like Mama would say, leopard don't change their spots, and she ain't did it in 24-hour period. Because this
Sheila E. or Bomb Cherry?
Sheila E.
Oh.
A leopard don't change their spots, and she ain't did it in 24 hours. And I know you to be a good person, and this shit just happened to you. And look how quickly them people changed on you for nothing. Look how people changed on me
for nothing.
for nothing. And say some sinister bad shit about me, about my wife, for no reason. My wife was upset. I'm like, baby, it's cool. I'm never gonna be cool with that person, because them motherfuckers included my wife on some whole shit over nothing. Like, I'm never gonna be cool with. This is why I'm calling. That's why I'm not afraid to call Sheila E. by all messy bitches and call these bitch ass niggas out on their shit. And I'm not afraid to ask for my cash app. I am extremely unique. Black people don't.
I can't judge people by what what somebody else,
No,
what they've been through. Like she ain't never did nothing to me.
I'm not doing that.
No, I'm saying for me, because you looking out for me by telling me that, but I don't. I'm not gonna hold her accountable for something that she did to somebody else, and it wasn't me. And then I see her making peace, and then she supported me. Sheila E. was a person that when I was going through that stuff, she came up and she supported me. And a lot of people didn't. People sat back and they watched. They didn't say a damn thing. But Sheila E. got up there and she did say something, and she did say something to the other one too, and she had my back.
Ain't it a trip?
And she been supporting me, so I support her.
Ain't it a trip? How
She asked me to be in it. I just said, yeah, and then I did that, and it ain't no big deal.
It's gonna keep happening because of who you are. So I can't tell you not to fuck with people, because it's gonna keep happening like it happens to me. People gonna keep wanting to work with you because of your talents and who you are. I just want you to be protect yourself. That's all. And it's not a bad thing. I'm not.
Somebody testifying. Blackwell said Kevin Lyles is testifying.
Get the fuck out of
right
here.
Now.
Get the fuck out of here.
But thanks for looking out, though. I hear you.
Okay. So we're going to go back to the case. The case is heating up. I didn't know they were going to go in depth today. No, I love you, and I appreciate everything you've done for me. And I'm
That's another thing. Oh, I'm sorry. Go ahead.
No. I'm in love with the real, and that was some fake shit. And I love how the cream rises to the top. Look at me and look at you and look at the suckers. One of the suckers already quit. The other suckers got like, yeah.
Quit what?
In your situation, I heard somebody over there quit. Somebody else got 2 people in the chat. Like, you know what I'm saying? God don't like ugly.
Oh, I knew it was coming back because
God don't like ugly.
God
And look,
told me to be
and look at
still.
me. And look at me. Look at me. My channel has gotten better and bigger. Look at my numbers. That gotta make them mad. That gotta make them mad.
Quit. Now I want to know.
I seen a live stream. I seen a live stream where somebody said they didn't want to do YouTube no more.
Really?
Yep.
Put it in the back chat. I want to know. Put it in the back chat. I'm curious. Because I don't watch none of them.
Yep. I seen a stream where somebody said they didn't want to do YouTube no more. Yep.
Well, I can't lie. I was in Ross chat yesterday, but I don't watch none of the other ones.
I ain't mad. I wish the brother, I ain't mad. I ain't tripping. You know what I'm saying? I've been so blessed. I got like a 1-year-old daughter. My life is full, but I love God, and God tells you He will show you certain things to keep you going on your path. So He'll take me to the side and be like, "Hey, son, check this out."
Oh.
Nah.
Cut it out.
So.
You should.
What you talking about?
You should quit.
Oh, you should quit? Oh.
Yeah, bitch, you should quit. Fuck out of here.
So, but let's go to it. Everybody's excited. I'm excited too. So we're going to go back to the court case, you guys.
You know why? Because I was the glue holding that shit together. I was the one with the plan. I was the one telling them what to do. Now you ain't got me no more. Anyway, I'm done.
This is why you got to pay to play, because people don't appreciate when you give shit.
I got a lip gloss line coming out. Did I already say that? Because I'm putting on lip gloss.
Hold on. Put the lip gloss on. Hold on. Go ahead, put the lip gloss on. I seen you with the lip gloss yesterday with your shoulder off. I was gonna tease you.
Oh, wait, you didn't talk to me. I was in this mug freezing, like, look. And I said, I can't wait to come back with my hoodie on, man.
I had something to do, so I couldn't really say nothing. But I was
whatever.
Like,
you could have said
look
hi,
at this
dude.
me with the sexy shoulder on. She got the sexy shoulder. I was like, okay. She got the
I
sexy
was
shoulder.
freezing. Okay, I'm freezing now.
Hey, Tracy, did you see Miss B with the shoulder? Killing with the shoulders.
Look, I was getting some play in there too. Like, man, I couldn't hold them off me. I'm like, damn. Jeez. And I got a Cash App yesterday.
Just a little collarbone. It's funny with a little collarbone to do. You know what I'm saying?
Little cabbage shoulder, you know what I'm saying?
Let's bring back real ladies, man. You don't need to show all of that. A real man.
Thank you, Tracy. She said I'm sexy, honey.
Come on. You see I noticed it? I remember it.
That's a shame, timing. You need to say something so I know who's supporting me. I always pop in on you. I don't always say nothing, especially if you're yelling. But I pop in on you, hit the thumbs up and all that. That's why I'm telling you, quit that, man. You running people off, even me who like you. I'm like, okay, it's a bad day for timing. I don't know who pissed in his Cheerios, but I'm out of here. Shit.
Oh, okay.
Stop doing that.
Thank you for the advice.
You're welcome.
Thank you.
And you said you wanted to do a network and grow event. I'm about to get back on that. But anyway, we'll talk. You play your video.
Yeah, whenever I'm ready.
Okay. I'm shut up.
All right, me too. We back, y'all. Coverage of the Young Thug hearing. And I didn't know this was going to turn out to be such a hearing. So, like Mr. Blackwell said, there's actually going to be some testimony and some witnesses testifying today. We didn't expect that. So let's get into it.
We start, I believe, on Sunday the 17th, I believe, Judge.
Of what month?
July, Judge.
Okay.
And we're normally out that week or most of that week, Judge. I think Mr. Smith and I have already filed a leave for that week to cover it. Okay. But other than that, I believe we're open into the future other than that week, Judge.
Other than the week of the 17th? Like,
Yes,
so that would be the 17th through the 22nd?
whatever that week of July is, yes, Judge. I believe the 15th is Friday, so the 17th would be Sunday, 18th probably Monday.
Yes,
July.
sir, that's correct.
Yes, sir. That week we filed a leave for. Other than that, I believe we are at the discretion of the court to be here when you need.
All right. Mr. Steele or Mr. Adams or Mr. Sharp, any conflicts during the month of July? I mean, I'm gonna probably, more than likely, I'm looking at early August, is what I'm thinking.
Go ahead, Brian.
I'm fine, Your Honor.
All right, well, guess who's not? Judge, in the month of July,
I'm not talking about.
not July at all, just August?
Yeah, because there's too many conflicts. People like, like take vacations and have kids in camp and other assorted things that they need to kind of take care of. So
Yes,
I was
sir.
trying not to compete against with that issue. So
Yes,
I
sir.
was thinking probably sometime in early August.
So along those lines, I've got to leave between August the 3rd and August the 10th. It actually goes beyond that, but I'll be available anytime after the 10th.
Where's that? Ms. Chamberlain? How's August 18th? Well, no, we have jail. We have people at the jail. So
So you have, somebody's being brought back from.
no. I want to do it.
No, I'm saying remote from GBC and the jail. You can't remote, you can't give out that day 18.
Is the trial date, and I am in receipt of your demand for a speedy trial pursuant to 17-7-170. And I note in your motion that you're aware that the statutory speedy trial has been told by Chief Judge Brasher by order until, I want to say I think it is the 3rd of January. We're going to check 2023. Oh, it ends on January 1st of 2023. So we'll keep that in mind in terms of scheduling. Okay.
Of course.
All right.
Thank you, sir.
All right. Go ahead, sir.
So I may just have one moment. Your Honor, there are two people that will be proffered, but they're in the waiting room, the Honorable Court's waiting room on Zoom. Is there any way the Honorable Court would allow those two people in?
Who are they?
Amina Diop and Garfield Lemon.
I do not have anybody in the waiting room right now, other than I assume that your beloved wife, Miss Steele, is in the waiting room. And then I have a Justin French and a Kindy's iPad. So we have otherwise restricted that unless you're a witness or counsel, since we are in a public forum. So if you want to make a phone call and have them join the Zoom, but are they going to testify as a witness, and what are they going to testify as to?
Yes, I would proffer the two, but I thought you'd want to hear that.
You can proffer them. That's fine, sir. Yeah, but they're not in the waiting room at this point in time.
Your Honor, may I approach?
You may.
May it please this honorable court, I wish to thank you for all the time that you give to everyone, always. Your Honor, on behalf of Mr. Jeffrey Williams, Mr. Adams and I respectfully request, along with the Honorable Avis Hornsby, bond to be set today. Your Honor, I gave a case law to this honorable court, as well as the prosecution and Mr. Adams. Mr. Williams is aware of this case law, Your Honor. And the first case I gave this honorable court is Coward, C-O-W-A-R-D-S versus State. It's 266 Georgia, 191. It's a 1996 case. And on page 2 or 3 of the copy I've given this honorable court and the parties, the right-hand side, it's in Division 2. It's 15 lines up from the end of the paragraph, first full paragraph on the right-hand side. And it reads that the defendant's guilt or innocence of the underlying charge is not an issue at the bail hearing, especially since the defendant enters the proceedings cloaked with a presumption of innocence. And then the court explains that in the next lines, skipping 2 lines in the middle, the decision of defense counsel to bring the extraneous issue of guilt or innocence into bail proceedings did not preclude, and goes on to another
I'm not going to
issue.
consider it anyways. That's well settled. That's a well settled premise, Mr. Steele. We can move on from there.
In United States versus Solano, S-A-L-E-R-N-O, which is 481 U.S. 739. It's 1987 on page 14.
Of 20?
Correct.
Okay, all right.
And on the left-hand column, Your Honor, that last paragraph in the Division 3, the highest court wrote, in our society, liberty is the norm, and detention prior to trial or without trial is the carefully limited exception. We hold that the provisions for the pretrial detention in the Bail Reform Act of 1984 fall within that carefully limited exception. The act authorizes detention prior to trial of arrestees charged with serious felonies who are found after an adversary hearing to pose a threat to the safety of individuals or the community, and this is what I stress, Your Honor, which no condition of release can dispel.
All right, sir.
In Jones versus Grimes, which is Grimes, 219 Georgia, 585, 1964 case. It's cited often, Your Honor, on page 3 of 4. On the very top right-hand side, it's in Division 1, the High Court wrote that excessive bail is the equivalent of a refusal to grant bail. And that's what my issue was. I just want to point to court because in the next case, which is Coleman, C-O-L-E-M-O-N versus State, 361 Georgia Appeal, 901. Your Honor, this came out recently, November of 2021, so maybe 8 months ago. It's on page 3 of 4. It's the appellate court, or second highest court, is talking about excessive bail, which obviously is equivalent to no bail. And then the court wrote on the left-hand side, on the in the paragraph that is indented, excessive bail is prohibited by the Georgia Constitution and the 8th Amendment to the United States Constitution. For purposes of the 8th Amendment, excessive bail is defined as bail set to an amount higher than an amount reasonably calculated, and this is what I'm stressing, Your Honor, to ensure the presence of the defendant. When fixing bail in Georgia, a trial judge's foremost consideration, and it's stressed in the text, Your Honor, is the probability that the accused, in this case, Mr. Williams, if freed, will appear at trial, and to a lesser extent, which is also emphasized in the text, Your Honor, the accused ability to pay the seriousness of the offense, and the accused's character and reputation. A defendant who seeks release on bail has the burden of showing roots in the community, that the defendant does not pose a significant risk of fleeing, threatening the community, committing another crime, or intimidating a witness. Your Honor, if you then look on the same page, on the right-hand side, the last paragraph, again, the court writes, and we're reminded, certainly we are not unmindful of the length of Coleman's pretrial detention and the presumption of his innocence. Your Honor, in Brown, which is BROWN versus State, it's 314 Georgia Appeal 1, 2012 case on page 3 of 3. On the left-hand side, in the second full paragraph, the appellate court wrote, the General Assembly, which is our General Assembly, provided for the creation of programs of electronic pretrial release to, among other things, assist sheriffs in alleviating jail overcrowding by creating alternative methods of pretrial release and monitoring and home confinement. Indeed, the General Assembly found that a, quote, program of electronic pretrial release, monitoring, and home confinement incorporates modern technology to accomplish various purposes. Thus, the General Assembly explicitly recognized a defendant's home as a place where he or she could be kept within bounds and restricted in movement for purposes of electronic pretrial release program. The next case, Your Honor, because we are going to ask for home confinement as an electronic monitoring. The next case is Ayala, which the court already noted, AYALA versus State 262 Georgia 704. Your Honor, on page 2 of 3 that I've given this honorable court and the parties, the very top left-hand side, our highest court wrote, the purpose of a pretrial bond is to prevent punishment before a conviction and to secure the appearance of the person in court for trial. And then it goes through the 4-part test, which is indented, Your Honor. On the the right-hand side, Your Honor, the first full paragraph in the middle, our highest court wrote, in this state, unlike many other states, the presumption of innocence has always remained with the person accused of a capital offense, even during trial. The most fundamental premise of our criminal justice system is that a person ought not to be punished for a criminal offense until the state demonstrates guilt beyond a reasonable doubt, unless the right to bail before trial is preserved. The presumption of innocence, secured only after centuries of struggle, would lose its meaning. Your Honor, the last case is Dunn versus Edwards. If I gave it to you, if I didn't give it to you, I apologize.
No.
Okay, I will then hold it for a minute. And then the last case, did I give the court easy out bonding versus State? That is 224 Georgia Appeal 706, 1997 case. It's on page 3 of 3, Your Honor. Second to last paragraph on the left-hand side. And the appellate court wrote, it is further assumed that appellant who has taken a financial risk, appellant in that case with the bonding company, in ensuring the defendant's presence at trial would be motivated to keep track of the defendant's case and prevent the defendant's flight or relocation until the surety is relieved of its bond obligation. Such risk of flight is inherent in the criminal justice system, without which there would be no need for bail bonds or bail sureties. We have a bail bonding company that is here today, Your Honor, that will be representing that they would be willing to go on Mr. Williams' bond. They've vetted Mr. Williams and they will be heard. Your Honor, with that being said, that is the premise of our law, and I'd like to call as our first witness, Mr. Charles Middlestad.
What's Mr. Middlestad going to testify to?
Your Honor, he is a private investigator. He is good standing throughout our state. I know him personally, and he is going to talk about his efforts in securing home confinement with current law enforcement officers working second jobs, detail, 24 hours a day, 7 days a week to ensure that Mr. Williams is confined to his home, no contraband, no weapons, no flight, no visitors come to his home whatsoever. And Mr. Middlestat has done all this work in the case.
Okay. Swear to you, Mr. Millsap, please. You need to stand up, sir. Stand up. Stand up, please. I'm sorry.
I do.
Thank you.
Please state your name, sir, for court. My name is Charles Middlestat, and the last name is spelled Mittelstat. And my occupation is I'm a criminal defense investigator.
And Mr. Middlestat, would you do me a courtesy and give this honorable court your background?
Yes.
In your
Excuse
profession?
me. Your Honor, I've been involved in this profession. I started out in the security industry. My background is in corporate security and dignitary protection. And then for the last 25 years, I've been involved in criminal defense investigation. I've been both a board certified security professional, and I'm a board certified criminal defense investigator. I've done cases coast to coast now for the last 25 years. I've done hundreds of cases here in Fulton County. I have worked with the DA's office in assisting them on cases. I have helped represent members of the DA's office at the highest level and worked with former DAs in private practice post career in their after they left the DA's office. So I've had extensive experience at this, and I've had the opportunity to be a part of similar sort of efforts that have been responsive to trying to address the concerns of the court as consideration with regard to bond. And Mr. Steele contacted me for that purpose to try to craft some solutions responsive to concerns that you might have, and to do some investigation into different circumstances that might be present with regard to some of the offerings that Mr. Steele is going to make today.
Investigator Middlestat, would you tell this honorable court, first of all, do you have any relationship with Mr. Jeffrey Williams, who's on the Zoom?
I do not. I have not met him at present.
Okay. Tell this honorable court what specifically I asked you to do, and explain what you did, and take the court through every scenario of what we are proposing and through your work.
Okay. When you contacted me, you asked me to get with Mr. Williams' representatives for purpose of having access to the various properties that are within his control. There are 4 such properties located within the metro Atlanta area. For purposes of evaluating the potential of these properties for home confinement purposes, and looking at them from the perspective of a security professional, and in terms of what the staffing requirements might be for each property, and the feasibility of creating a home confinement program, and what those staffing requirements might be for law enforcement, currently certified, post-certified, only law enforcement staffing with regard to a home confinement, essentially program that also would include ankle monitoring, 24-hour, 7-day a week, physical monitoring performed by off-duty law enforcement, and including making contact with law enforcement officers around the state that would be available to perform such a function, that would be authorized by their departments to perform such a function, that are ready to go as we speak today, that are ready to mobilize right now. And to date, I have secured 24 such officers that are authorized and ready to mobilize for this sort of assignment. The purpose of doing so and using law enforcement only is because they are active, they are sworn to uphold the laws of this state. They would be responsible for reporting any sort of violations that might be committed by Mr. Williams should he not comply with the terms of his bond. And so by utilizing active law enforcement only in lieu of utilizing private security or private investigators or anything lesser than a post-certified officer, we seek to provide comfort both to this court and to the state, responsive to the concerns that I've heard. Frankly, I sat through the first hearing a week ago, and I was relieved to hear that what we crafted is entirely responsive to the concerns that I've heard from this court, which really revolve around the issue of witness tampering and any other concerns that could arise from communications that might occur.
And Investigator Millstat, is it fair to say that we did all this work well prior to the Monday, May 23rd, 2022 initial hearing that you're referring to?
Yes, as a matter of fact, if you'll note, Your Honor, the letter that I addressed to you is dated May 20th. And so this was everything that's contemplated within this proposal here was crafted well before, I'm sorry, and it contemplated these sorts of concerns. And candidly, it's the most extensive, far-reaching effort that I've ever been a part of in terms of trying to directly address the concerns that could be anticipated in such a wide-ranging indictment with 28 defendants and 56 counts and the nature of these sorts of allegations. And so in addition to the home confinement piece, ankle monitoring, a GPS ankle monitor for Mr. Williams, literally 24-hour, 7-day-a-week law enforcement. There are 4 different settings which have been contemplated, some which, based on my estimation, would require 2 officers, some which could require 1 officer only. And very candidly, we're completely, I have the staffing and we have the ability to supplement the staffing to any force level that we need to. So if Your Honor decided that we need 3 officers per shift, that's feasible. If the state, and the way that I have contemplated this is whatever the state, whatever concerns they may express, we have the ability to respond to that. Part of that contemplation also deals with the fact, incorporates what I'm terming a hammer, which is a 60-day reserve. So the best way I can explain that is there's 60 days worth of advance funding, and this is an incredibly expensive proposal. Just doing the math based on 2 officers, Your Honor, the cost to Mr. Williams is in excess of $1 million a year just for the staffing alone, and there's additional fees on top of that. That math is based on 2 officers per shift times 3 shifts at a negotiated rate of $60 an hour. That is what law enforcement is requiring to undertake this sort of off-duty assignment. And this is money that he'll never get back. This isn't like a bond. This is money he'll never get back. It's a tremendous amount of skin in the game. But in addition to that, there is a 60-day workforce reserve incorporated. So if he were to violate for any reason, that 60-day reserve would be dispersed amongst the officers that are working that assignment. And so it almost gives them an incentive to violate him in a sense. Beyond that, this plan also ensures that whatever restrictions the court puts in place with regard to limiting and restricting and controlling visitor access or any sorts of devices or any materials that you would not want within that environment, that law enforcement, not me, not the defense team in any way, but the law enforcement officers that are assigned to this responsibility are empowered to actually control everything that comes in and out of that environment.
So if somebody comes to my house and it has a burner phone, or are they gonna be searched or whatever before they come in? Or?
Yes, sir, absolutely, Your Honor. What's contemplated is the moment that you approve this bond, that prior to Mr. Williams occupying it, is that a complete search will be conducted of that, whichever property you deem, whichever property you assign. It will undergo a complete search that can include canine, drug dogs. We'll do whatever it takes to satisfy Your Honor. And we will search that and we will bless that environment. And from that second forth, law enforcement will be put in place and nothing will come in and out of there. And I think that's very, very significant, because what we've heard, and I have heard, throughout these proceedings is almost sort of an admission by the state at its, frankly, inability to do so in a detention center. We've heard the state talk about the fact that, in fact, it's even in the indictment, there are charges relating to the possession of communications devices by incarcerated persons. We've heard about drones being flown in or attempts to drop phones in. And we all know that the fact of the matter is, in spite of all the best intentions of the good men and women of Fulton County Sheriff's Department or the Cobb County Sheriff's Office, or frankly, any detention center around this country, is that contraband gets in, whether it's in the form of phones or it's drugs or any other sort of contraband. It's just a fact of the matter is detention centers are just wholly unsuccessful in keeping that out. It mostly does not come through visitors. It mostly comes by the jailers themselves. And we've also heard testimony and proffers by the state about the fact that there are other ways to beat communications if we're talking about threats being called in or any sorts of orders being called in, through code sharing and other means of making that happen. If the real concern is, in this case, accepting the state's concerns at their face value, is to basically freeze Mr. Williams out, eliminate his ability to communicate, eliminate his ability to present a threat to anybody. This is the only plan that's going to be responsive to that. The state has demonstrated, or not the state, the law enforcement, unfortunately, based on its, again, in spite of its best intentions, has demonstrated an inability to do any of that.
Free, 1 second. Mr. Steele, do you have that letter that you included in your materials from last time?
Of course.
Can I have a copy of it, please?
Of course.
I mean, I know it's in the binder we submitted last time, but you have a copy of that.
I do. And Your Honor, I'd like to give redacted parts because I didn't think the court would want the law enforcement officers' names, but we have that as well in additional names. So if you want that, they're unredacted. Thank you so much.
We ain't gotten there yet, so, but I just wanted to take a look at it, so, okay, all right. All right, go ahead, continue, sir.
In addition to that, we also make provisions for closed circuit television monitoring. There are a couple of these properties that already have fairly extensive surveillance systems in place, and we'd be happy to turn over control of those systems, access to those systems to whoever the court deems fit, whether that's even the state or Fulton County Sheriff's Office or anybody for that matter, whoever you've seen fit or wherever that comfort level may arise. And we also are willing and capable of adding additional cameras to increase the monitoring.
Mr. Millsap, may I ask you a question?
Certainly.
About the video surveillance outside the home and inside the home?
Both inside and outside.
And if, let's say, this honorable court set bond, but with all these requirements, and wanted the opportunity to have certain designated people, whether the sheriff, prosecution, and the honorable court itself, to have access to the, to see for themselves live video or the past video, would that be able to be done?
Absolutely.
Thank you. I apologize.
Mr. Steele, through your witness, can you tell the court about the issues involving communication in terms of phones, email, internet, and other third parties that would come to the house? Because one of the things that the court was made aware of was the potential to engage in his trade or occupation while he's pending trial.
Your Honor, we will go to the extent that we will agree to a condition as far as there's no electronics in that house. There's no internet in the house. There's no cell phone. There's no burner cell phone. Anybody who comes into the house, if approved, they would be on a list. They would be patted down and wanded, by the way. And if it's a woman coming, they would have to have a designated time because there'd be a female officer to pat down that woman. As far as work for Mr. Williams, we contemplated, if the court permits, building a studio in his home, wherever of these 4 homes, if the court ratifies and approves. And those people would, of course, be searched, and then all that equipment would leave, and there would be a search of the house as well, or the apartment as well. So we thought about it, Your Honor, and Mr. Williams is aware. I've spoken with him personally about it. As opposed to the way he's living now, he would live without, he would go back to the time I was young, and there'd be no electronics whatsoever.
Will there be people present when he has other people in the house, other law enforcement present?
We had that discussion as well, and we would have video surveillance. Mr. Williams would waive any privacy rights, would be in the house, and law enforcement can be present at the same time. Or, and we're not asking for this, but Mr. Williams can have 0 visitors in the house as well, except obviously his lawyers, doctors would have to go see him, and we would hope family members and business associates. But if the court says, willing to give a bond, but no one's visiting him, we would take that as well, except obviously I'd like counsel to go.
Oh, you were, goes without saying.
Okay.
You would be able to visit him as well as any medical providers or whatever. Okay. Anything else, sir, you want to ask Mr. Millsap?
With regards to drugs, there's allegations of drugs in the home. I heard you mention drug dog, drug testing, if the court wanted drug testing to occur.
That's correct. Again, this plan essentially contemplates addressing any and all concerns of this court and the state, frankly. And we have the ability, and I will make it my personal undertaking and responsibility to secure any and all necessary, whether it be a canine dog or any sort of drug testing, any experts we need to pull in to satisfy the court's concerns. As Mr. Steele had touched on, you know, one of the things, Your Honor, that we wanted to ensure you of is the fact that we had in place the ability to do thorough screening. And so that's why we do have both male and female officers, so that we have gender appropriate screening and pat downs and wanding for the very purpose of keeping out anything that you deem to be restricted. And I've heard you loud and clear over the last two hearings about the concerns with regard to communicating and the potential of threatening witnesses. And so paramount to that is the ability to keep those devices out, to keep those to prevent that very thing from happening.
And if a visitor stated, you cannot wand me, you cannot pat me down, you have constitutional rights, what would be done with that person?
They would not be allowed access.
And there'd be reports each day by each shift. Is that fair to say?
That's correct. And I'm sorry, I failed to mention that. The plan would be for the officers at the end of each shift to, during their shift, they would be generating activity logs to be completed at the completion of their shift. And then once a day, we would upload to a cloud, through cloud access, all 3 shifts, the reports for that day. And those could be, again, available to whoever the court designated needed access to have those, including the state. The state, I'm sorry.
And with regards to weapons, there'll be no weapons in that home. By weapons, I mean hand grenades, handguns, whatever it is. Same thing?
I think it goes without saying, there would be
Okay.
no weapons in that home. We would seek to keep all of that out.
Now, when Mr. Williams does have to come to court, would there also be provisions that he'd be transported to and from court by the sworn law enforcement officers while on bond?
Absolutely.
So he will never leave that home except in the custody control of lawful officers who are off duty but sworn. But if he refuses that, they report it to the court as a violation of bond.
That's correct.
Okay. Did you leave anything out, Mr. Middlestead?
I don't believe so.
If the court wants to hear about the different locations, Your Honor, we can do that. Otherwise, there are 4 different locations, Your Honor. Mr. Middlestead did write about them. We did redact. Obviously, we could give the state the exact addresses in this honorable court, but for privacy purposes, we did not file that with record. And Your Honor, each one of those, or I'm asking you, Mr. Middlestead, each one of those locations, 4 locations, have they been vetted and approved for this type of detail?
Yes, I personally visited each one of those and vetted those and assessed the various features associated with those, which I have enumerated in this letter to Your Honor. And I stand ready, and I'm certainly willing to provide any more details or answer any additional questions with regard to any one of those locations.
And then finally, if this honorable court grants bond, conditionally that the house, which is chosen for Mr. Williams to reside, is then properly swept, approved, sealed, all that goes to the court and the prosecution. The prosecution can bring in people if they want as well. You would have a sworn law enforcement officer meet Mr. Williams outside of the release area of the jail at the Sally Port. Is that your understanding?
That is my understanding.
So it's not like Mr. Williams gets in a car with one of his family members. He would be right from the sheriff of Fulton County into the hands.
That's correct. He's essentially remaining in custody, but remanded to the confinement of his home.
Okay. Now, with an ankle monitor, since I gave this honorable court the option, or suggest, I don't give the honorable court anything, but suggested that if the honorable court was troubled, electronics would be removed. It's not my first choice, but if that happened, the ankle monitor, to your knowledge, can an ankle monitor work without there being electronics in the home? And if you don't have that information, there's another person here to talk about.
I'll defer to that other person.
That's fine. I want to thank you. Is there anything else that I've neglected to ask you that's important to this honorable court?
I don't believe so.
Okay, and the off-duty police officers, right now, they have been given approval for this type of detail?
They have, and I have been reassured of that. And as late as this morning, once again, I have reconfirmed that all of the 24 officers are still good to go.
And if there is a visitation list that has been approved by this honorable court, those visitors lists would obviously go to each detail. Is that fair to say?
Correct.
Okay. I don't have any other questions for Mr. Millsap. Thank you so much. Your Honor.
Cross, Mr. Geary. Okay, all right. Sure, you can stand out. Thank you. Thank you.
Your Honor, we would call Mr. Jamil Mitchell, which is Jamil. Mitchell's Mitchell.
Where's Mr. Mitchell? Is he?
He should be right here, Your Honor, coming to your court.
All right, Mr. Mitchell, if you would please approach the witness stand. Once you get there, if you'd be so kind to turn and face Deputy Talk and be sworn as a witness, please. Please sit down.
Jamil, Jamil Mitchell, Mittchell.
Good afternoon, Mr. Mitchell.
How you doing, sir?
I'm okay. How are you, sir?
All right.
Can you do me a favor when the Honorable Court is ready? Just where were you born and raised? But let's wait for the Honorable Court. Where were you born and raised, sir?
I was born in Jersey City, New Jersey, but I've been in Atlanta since I was 4 years old.
Okay. And when you speak, just address the court.
Okay, sorry, Mr. Steele. Go ahead. I apologize.
Mr. Mitchell, where were you born and raised?
Jersey City, New Jersey, but I've been in Atlanta since I was 4 years old.
And where in Atlanta area have you been since 4 years old?
I reside from Cleveland Avenue.
Okay. What's your educational background?
I went to the University of St. Augustine, then I transferred and went to the Art Institute of Atlanta after my freshman year.
And what type of study did you do?
At St. Augustine, I was doing sports management. And then when I went to the Art Institute of Atlanta, I did videography, audio engineering.
Do you have any prior criminal history?
No, sir.
In your community on Cleveland Avenue, tell this honorable court the types of works that you do.
I actually own a nonprofit organization where we have football players and cheerleaders. So we trying to push kids into sports, you know what I'm saying? Trying to get them to do something positive instead of just being around, just running around, doing nothing.
Okay. And do you know the gentleman who is on the honorable court's Zoom screen, Mr. Jeffrey Williams?
Yeah, I've been knowing Mr. Williams since he was like 13 or 14.
Okay. Tell this honorable court the ties that Mr. Williams has to this community and what he does to support the community that you are in.
He actually supports my football team and cheerleading team a lot. He sponsored my football team with uniforms, banquets, buy trophies. When we do barbecues for the kid, that he helps with that. He pays to cook. Like we did a Juneteenth event one year, a barbecue, because we never heard of it. So when we heard of it, we was like, okay, this our 4th of July. So he helped give me money for that, and we paid to cook. He helped do a lot for the community, really, when it comes to the kids and everything.
And what did he, I'm sorry, go ahead.
He's trying to push positivity with the kids.
And does Mr. Williams speak with the next generation of children to do positive things with their life?
Yes, sir. I have him plenty of times where we FaceTimed each other. Cause, he moves around a lot. He's an international star. So he FaceTime. I put the kid on FaceTime with him. They be excited. They shocked. They be like, oh, you really know him? I'm like, yeah, this is my friend. Like, he'll come to the banquet if he get a chance, or come to a game.
And does he also come to the area in Cleveland Avenue?
Yeah, he came there, passed out shoes a couple times, do community barbecues, feed the homeless. One year he came, gave out like 90 pair of shoes to the homeless and to the kids out there. Like, he do stuff for the community a lot.
How old are the children in the football program?
My crew go from 5 to 13. The 13 is the cheerleaders, but from football it's 5 to 12.
And are there girls playing or a girl playing football as well?
I had a girl last year. Yeah, I had a girl play football last year.
And what's the name of the organization?
Cleveland Avenue 49th Youth Organization, Development Organization.
Does Mr. Williams support that organization through the children as well as breast cancer?
Yes, I told him my grandmother passed away from breast cancer right when COVID hit. And he sponsored my football team with breast cancer uniforms. And on the uniform, you'll see his record label logo, because whoever sponsored, we put the logo on there to try to show support.
And what's that logo?
His label, Young Stoner Life Records.
YSL?
Yes, sir.
How about tell this honorable court what Mr. Williams did with trunk or treat?
This is around COVID time, so the kids couldn't really go trick-or-treating. And they not used to that, like, especially like my daughters, they used to going trick-or-treating and stuff like that. So instead, I sponsored I teamed up with another program, another nonprofit, and we did something called Trunk or Treat, where we had people decorate their trunks. It was like going to a house, and we gave out candy, and then we gave the best trunk award.
And did you team up with law enforcement officials on that as well?
Yes, actually we did, because right where we practice at, I guess there's like a training academy back there, like back there by the post office, and we had police out there. We gave them food, barbecued, everything. They was there, police was there.
And Mr. Williams is integral in all these events.
Yes, sir.
With regards to children going to school, getting educated, please tell us, honorable court, what, if anything, Mr. Williams does for school supplies.
We did a backpack giveaway one time in that neighborhood, or 2 times in that neighborhood, and he helped sponsor that, where he gives us the money, we go buy the backpacks, we put it together, and then we just give them out to the kids right before school starts. So make sure everybody have like supplies for school, at least for the first month of school.
And we're talking about papers, notebooks, pens, pencils, folders,
everything,
calculators,
everything you need.
And
don't matter the grade.
And that was Mr. Williams'
Yes, sir.
Power behind that?
Yes, sir.
And is this for kindergarten through high school, everybody?
Yes, sir. Kindergarten through high school.
But the entire area in Cleveland Avenue?
The entire neighborhood.
And he does that often?
Yes, sir.
How about tell this honorable court what Mr. Williams did, if anything, involving shoe wear for people in the
well, like I said earlier, he just popped up one day, like didn't nobody expect him to come, and then he had like 90 pair of Adidas, and he just gave them out. Like anybody of your size was there, you could have got a pair. A lot of homeless people got a pair of shoes, so he do a lot of stuff like that. Like he just popped up that day, didn't nobody expect him to come.
How about food for the people in the community at Cleveland Avenue?
Yeah, we do barbecues a lot. We try to do that. Barbecues a lot just to feed the neighborhood. Then we did like a barbecue one time inside the apartments, and that's the same day he gave away the shoes. Okay. Like we got plenty of things he do when it comes to that stuff.
And Mr. Williams feeds people off in that community?
Yeah, we do one big barbecue every summer, but we just do barbecues when we get bored. Like let's have a barbecue.
How about
pay the DJ? We'll have a DJ come out there. Pay the DJ.
And like, this is all Mr. Williams?
Yes, sir.
Giving back to the community?
Yes, sir.
How about assisting in an effort to have children read and being interested in reading? Does he do anything with that?
Yes, sir. I had a book company, and I told him about it. And then what I did, like, whenever I got ordered kids' books, I would give them out to my kids' school. Or, you know, if you go in the neighborhood, like I stay downtown, you go in the neighborhood where they got put a book in and take a book out. Well, I just leave the books and I wouldn't take no books out. Or I give the books to my daughter. And I think she was in like the 6th grade when we started doing that. And I was like, you take some and give some to your friends or your teachers. And he helped sponsor that because during COVID, when my company was having a bad time, I told him like, man, I'm having a bad time. And he helped me buy books. And then whenever I buy kids books, I just give them back to the school.
How about Mr. Williams actually speaking to people in the area? Does he do that?
All the time. He's a motivator. Everybody know that. Like, without Jeffrey Williams, I'm going to keep it real. Without Jeffrey Williams in the neighborhood, I don't know if y'all ever been to Cleveland Avenue, but without him, the neighborhood would be terrible. Like, You got to think about all the people he helped motivate. Before rapping, it wasn't nothing else to do. He helped motivate people to rap. And I seen other people from my neighborhood get deals and become stars and do what they had to do. See what I'm saying? So to me, and I know to a lot of other people, he's a motivator to us. You know what I'm saying? Because before that, didn't nobody motivate us. We either were playing sports or running around.
Did you ever hear Mr. Williams talk to the people in the community, the vast number of people in the community, about staying in school?
All the time. He tell you that all the time. He got that. He tell people that all the time.
And what does he tell them?
Stay in school. That's the best way to do. What else you gonna do? Become a lawyer. Become, you know what I'm saying? Get into sports. Become a rapper, entertainer. Be a manager like me. I'm a music manager. Like, he motivated me to do that.
You ever hear Mr. Williams say something to the effect of be a thinker, not a criminal?
Most definitely.
And he tells that to the children?
Yes.
And the parents?
Yes, sir.
And it doesn't have to be hopelessness?
No, sir.
Is that true?
Yes, sir.
Okay. How about, you know anything about Mr. Williams paying for the bond of strangers from the Fulton County Jail just because they couldn't afford their bond?
Yeah, I was actually there in the meeting when they was talking about it. It was like, we're gonna pay for bond for people with bonds who can't afford bond. I'm like, bro, that's cool. Like, nobody does that. Like, you gotta think, Atlanta been the hub for music for what, the last 20 years? Name a rapper who ever bonded people out he never knew, never met before, and takes them out to eat.
All of the items that you talked about, does Mr. Williams want any credit for that? Does he ever say, hey, put my name on this, tell people I'm doing it?
No, not at all. He's not that type of person. He don't want that type, like, he don't care about that. Like, he don't care about the credit. He sit back and watch it. And I watch him, because I don't know how other people, but I watch him, I see him, I'm like, yeah, he happy. Like, he did something for the community. Because nobody did that for us coming up. See what I'm saying?
And he doesn't publicize it to your knowledge, he just does it.
He just does it for sure. He might just call you and be like, hey, let's barbecue. Call everybody, tell everybody to come, everybody there, everybody eat. Don't nobody go hungry at all.
Your Honor, if the court would allow my coworker, I'm honored to work with Ms. Courtney Edwards, Courtney C-O-R-T, anyway, to get on your Zoom link. She's in your courtroom, but she cannot access it. I'd like to, with the court's permission, show the court photographs and the prosecution for Mr. Mitchell to explain.
Where are they, sir?
Oh, it's in Colette's, it's in my wife's name, Your Honor.
So you want me to admit your wife so that she can show me these pictures?
Yes, but it will be an alias because it's Courtney Edwards who's actually must be on that device.
I see your better half on here, but I don't see.
Much better. I agree with the court.
But I don't see Miss Edwards.
Right. She said that she's using my device that is in my wife's name, I assume.
All right, okay.
Mr. Mitchell, if you can look at what Ms. Edwards just displayed on the screen. Ms. Edwards, if you could blow that up at all. Is that a representation, an example of some of the one of the uniforms?
Yes, actually, that's one of the uniforms he helped sponsor.
And you see the logo you were talking about?
Yes, sir.
And that's YSL.
Yes, sir.
Okay. And it's the 49ers, the Cleveland Avenue 49ers.
Yes, sir. We're
All
playing
right.
the City League.
One more time?
We're playing the City League, yeah. So
Congratulations and thank you. Okay. Next, Ms. Edwards. Do you recognize, can you blow it up, Ms. Edwards? Do you recognize what this is?
that's our trunk or treat the year we had.
And that's what you explained?
Yes, sir.
And that's by Mr. Williams. I know he's not named on there, but that was his,
Yeah,
that was
yeah,
him
yeah.
doing that.
Yes, sir.
Okay. And that was all for the children,
Yes, sir.
so they can have Halloween. Is that true?
Yes, sir.
Okay. Next, please.
That was a Juneteenth barbecue.
And Mr. Williams, again, without taking any credit, he's the one who was behind that.
Yeah, he helped sponsor the food, helped pay for the the cook, everything.
And you called it our 4th of July.
Yes, sir.
And this was just brand new information. People
Yeah,
in
that
that
was
area.
something we never knew about. So when we heard it, it was the idea.
And Mr. Williams wanted people to be educated?
Yes, sir.
Okay, thank you. Next, please. What is it?
That's the football team right there.
And all those uniforms, all the Gatorades, all the equipment?
Yes, sir.
Who pays for all that?
He paid for the uniform. This year we was doing the equipment and everything.
Perfect. Okay. Next one.
Yes, you can see the logo more often. You can see me out there coaching.
Okay. Next one, please.
There was the cook. This one we went to buy the food for the Juneteenth event.
And that's the cook who's going to buy all the supplies?
Yes, sir.
And Mr. Williams is backing all this?
Yes, sir.
Okay. Next one, please.
This was the event. I don't know if y'all want to play the video.
With the court's permission, Ms. Edward, can you play it for a moment? Is that okay,
You can see kids out there running around, everybody having a good time. They tore down the volleyball thing the kids did. We had them out there playing volleyball. This is actually the park that we practice at, and it's the same park we had the trunk or treat at. And right behind here, on top of that hill, is why I was telling y'all the police academy or the volleyball thing up. That was the police academy up there where the police came and helped us.
Now, maybe you can't tell from the video, but many people come to this?
A lot of people come. Yeah.
Thank you, sir. Next, please.
This was the video when he came to the neighborhood.
Your Honor, with the court's permission, can Ms. Edwards play that, please?
And he gave out the shoes.
Yes.
Thank you. And this is just Mr. Williams just coming? And
Yeah, we didn't even know he was coming. He just came, and then everybody came out once they heard he was there. He gave out shoes to the community. A lot of homeless people got shoes.
And that's Mr. Williams right there?
Yes, sir.
Okay. Coming back to the community.
Yes, sir.
Thank you, Your Honor. Mr. Mitchell, we are here for a motion. And a motion is it's a term being used a lot in courts, but we're asking this honorable court to consider releasing Mr. Williams on a pretrial bond.
Yes, sir.
Okay. On your oath, knowing Mr. Williams the way you have since he was 13 years of age, do you have any evidence or belief that if granted bond by this honorable court, Mr. Williams would flee the jurisdiction of the court? What that means is he would not come back to court.
No, he most definitely come to court.
Do you know if Mr. Williams has family in this area?
And what you mean, in Atlanta?
Yes.
I know his whole family. Yeah, so he's never leaving his family.
His whole family's here?
Yeah, I know his whole family.
Same on your oath, any evidence or any belief, any speculation that if granted bond, Mr. Williams would obstruct justice?
No, he wouldn't obstruct
bribe
justice.
a juror?
No, never.
Intimidate a witness?
Never.
If granted bond, do you have any evidence that Mr. Williams would be a risk to commit a crime while out on bond?
Never.
And if granted bond, do you have any evidence that Mr. Williams would be a danger to any person in the community or any property in the community?
Never. He's a motivator to our community. So I can't see him hurting nobody.
When you say a motivator, does Mr. Williams actually talk to people in the community about being lawful?
All the time. We can get, if y'all want, we can bring hundreds of people in here from the community, and they can tell you one by one, he motivate them. Like, if you got I got a buddy who cut grass. If you cut grass, he'll help buy you more equipment to cut grass. Like, this what you want to do? Okay, do it, and do it 100%. He got to think. He stayed down with music, and we seen him go to the top and say the same thing. Stay down. You can have 3-4 lawnmowers. You can be hiring people. Like, that's how I look at him. I know, and a lot of people look at him like that, as a motivator. If they didn't, we wouldn't be in here supporting him.
I want to thank you so much. The prosecution, the honorable court may have questions for you.
Okay.
Scared?
No questions, Judge.
Your Honor.
Mr. Mitchell, thank you very much. You can stand down.
Okay, have a nice day, Judge.
Have a seat in the gallery. Thank you. You're welcome.
Your Honor, we will call, thank you so much, Mr. Corey Jackson.
What's Mr. Jackson going to testify to?
Your Honor, he is a young man
How many witnesses do you have, Mr. Steele?
Six, Your Honor.
Okay, and what's the next witness going to testify to?
Your Honor, he's a young man. He's just turned 15 years of age. He met Mr. Williams when he was 8 years of age. He was selling CDs in the perimeter mall. Mr. Williams, he was in poverty. He's from Jackson, Mississippi. His family's here as well in your courtroom. Mr. Williams explained to him that.
Hang tight. Mr. Steele, if it is your goal to establish that Mr. Williams has significant ties in the community, I believe that you've established that to the court's satisfaction. Not that I don't want to hear your witnesses, but it's cumulative at this point in time. I mean, if that's the purpose of these next witnesses, unless they go to some other bond factor, you know, I'm kind of really at this point in time, I'm not really interested in hearing from them at this point.
Well, he goes more to a different factor, Your Honor.
And what is that?
Danger to the community, which is what I thought the state is arguing.
Okay, all right. If he's going to danger the community, all right. Come on up, young man. Please approach the witness stand. Once you get there, if you'd be so kind and turn face Deputy Talton to be sworn as a witness. Well, hold stand up before you. Okay, go ahead.
Raise your right hand. You swear to affirm the testimony I give the court the truth, the whole truth, and nothing but the truth.
Yes, sir.
You can take a seat. State and spell your first and last name.
Corey Jackson, COREYJACKSON.
Good afternoon, Mr. Jackson.
Thank you. Good afternoon to you.
It's up to the court, and it's also up to you if you want to take off your mask with the honorable court's permission. If you want to keep it on, you absolutely keep it on.
Okay.
Your choice, young man.
I'd like to take it off then.
Mr. Jackson, introduce yourself to the court. Tell the court what you do.
Well, I'm Corey Jackson. I'm a recording artist, motivational speaker, and actor.
And are you in school?
Yes, sir.
What grade are you in?
I'm in the 11th as of right now.
And you're 15 in the 11th grade?
Yes, sir.
How did you do that?
Well, I'm homeschooled and I stay up on my studies and I work on that.
Do you remember meeting a gentleman named Mr. Jeffrey Williams?
Most definitely, yes, sir.
Do you see him on this honorable court's Zoom screen?
Yes, sir.
And how did you meet Mr. Williams?
Well, the first time I ever met him was in the mall. It was in Cumberland Mall. I was probably 8 or 9 at the time. I had first met him with my music and I approached him and I didn't know who he was. But later on that day, after I had met him, I found out who he was as far as artist, and I found out more about him. And then when I really met him and we made the connection, made the bond, was later on when I was like 10 or 11 years old at the time.
And were you in, I know it's personal, but were you in poverty at that time, if you know what I'm talking about?
Yes, sir. I understand what you mean.
And where were you living at that time?
Well, I'm from Jackson, Mississippi originally, so down there it's called Cromwell Street, Shady Oaks, Christian Brotherhood.
And is your father in the courtroom?
Yes, sir.
And other family members?
Yes, sir.
Okay. Tell this honorable court if Mr. Williams ever took you to where he was raised on Cleveland Avenue.
Yes, sir, he has.
And tell the court what you learned from that and what the purpose was.
Well, at the time, he took me there because I always expressed to him how at me being at such a young age and being able to achieve what I have and have the knowledge that I do have, that's why I started motivational speaking, because I want to inspire the youth and show them that anything is possible. Because you can look at somebody older and you say, oh, that's good, they doing it. But now you have an example that's your age and close to you in age that's showing you that it's possible. And Mr. Williams, he took me to where he was from. And he showed me where he came from. He showed me the property that he lived in. And he told me, he told me a saying, each one teach one. which is something that he lives by. He has also helped instill in me that I live by now. Each one teach one. And he told me whatever knowledge you have to be able to spread it, because this is who you are trying to inspire and show them that they can become successful. So that is what he took me there for, and to show me how he was able to achieve what he has and where he comes from, and what I have to do if I want to motivate more young people like me.
And tell this honorable court whether you have gone across our country talking to other students, people your age and younger at schools.
Yes, sir, I have. I've did different things like different school tours and doing motivational speeches for different organizations like the Boys and Girls Club and different things of that nature, and different youth centers, detention centers, of course, schools. Yes, sir, I have.
And has Mr. Williams put upon you the duty that you have to always be positive and try to get other people not to do crime?
Yes, sir, he has, and he has always motivated me in that goal and that mission. He's always showed me that path, and always deterred me from anything that could be negative or affect me in a negative way. He always deterred me from that and showed me the right way and showed me a positive way to do anything I have going on.
Has Mr. Williams taken you on tour with him, with your family's permission, and taken your family?
Yes, sir, he has.
And if you can remember, what are some of the places that you went with Mr. Williams?
Atlanta, Georgia, Los Angeles, California, St. Louis, Chicago, New York. I've been to New Orleans with them before, many different places, Tampa, and some more places. It's been a lot.
Houston, Texas?
Houston, Texas, Dallas, Texas.
Okay. And have you been on stage with Mr. Williams and talking to people about all positive, motivating in a positive direction?
Well, yes, I have been on stage with them, and we have also made motivational videos with motivational messages.
And when you go to schools, is that with Mr. Williams' request?
Yes, sir.
And what do you tell the other children when you're there?
Well, first, I speak on my 5 keys to success, which are hard work, determination, dedication, motivation, and ambition. And I show them how you can utilize, if you are utilizing these 5 keys to success, how you yourself can become successful. And that is also what he helps and he sponsors me with. And when I go through the schools, I also speak on things that aren't at this stage in life taught, because while you're in school, you're going off of your report card. But when you get out of school, you're going to go off your credit report. And that's why I also teach and speak on financial literacy.
Mr. Jackson, do you have conversations with Mr. Williams about your, the way you are outlooked, and it has to be positive, as opposed to some people look at him with the name, quote, young thug? Ever explained to you that not to do that?
Well, actually, we have had conversations, and he has been very vocal about not liking the image that is associated with the name Young Thug, because whenever you picture that, you assume, he's a thug. And that's why we have talked, he has discussed with me how he would like to reevaluate and reshape his image into his name, Jeffrey, and how he would like to go forth with that being his name, and that's what people associate with him, Jeffrey, instead of the image of a young thug.
Is it Mr. Williams' communications with you that he wishes that people do not do drugs or alcohol or be a danger to the community?
Yes, sir. He has expressed that to me, and he has also expressed that to many others.
And does he use you as a lightning rod to express it to other people?
Yes, sir. He has, and he still does.
What is YS? Are you a member of YSL?
Well, I'm not signed to the label on papers.
What is YSL to you?
Well, to me, YSL is a family. To me, YSL is, ever since I first met him, it's been all love, all respect, and it has been pure. And for me, when we spoke on it, other than, the name of the label, Young Stoner Life Records, I told him my YSL means Young Successful Life, because that's something that he has created. He is a young, successful man himself, but also he is helping more young men and young women have successful lives, such as myself, for example. And that's why my YSL stands for Young Successful Lives, because that is what he has done, and that is what he is now creating and showing and putting into the community.
Sir, has Mr. Williams' tutoring and guidance to you taken you out of poverty and your family?
Yes, sir, it has.
Has Mr. Williams ever asked you for a nickel?
No, sir, he has never asked for no profit or proceeds from anything that he has helped contribute with. Never.
Your Honor, with the court's permission, Ms. Edwards has a very short video that relates to Mr. Jackson.
Okay, what's it supposed, I mean, he's testified here, so it's kind of like, so.
It'll explain background.
I don't see the dangerousness in this, Mr. Steele. I mean, he certainly, he buttresses again what I have indicated earlier, which is he has significant ties. He's helped a number of people in the community. I don't see the danger of the community that you promised me from the testimony.
It's the opposite. I think that my promise is good. Mr. Jackson is saying that the entirety of Mr. Williams' desire is that people do not commit crime, do drugs, do violence, and to stay in school. That pinpoints the whole danger community is risk of crime, risk of committing crime. He's doing the exact, Mr. Williams through, and along with Mr. Jackson, diametrically opposed.
Okay, all right. All right, but this video, you want to show me, how long is it?
2 minutes.
And what's it going to show me?
It'll show you Mr. Jackson on the Ellen Show. It'll show him on CNN. It'll show him interacting with Mr. Williams, interacting at schools, just to give you an idea of how this message is all across the country.
I think you testified that more significantly. I mean, I'll accept the video as proof of that, further proof of that particular issue, but I think Mr. Jackson here has well articulated that issue.
Okay.
Okay.
Then I have no other questions for Ms. I want to thank you so much for being here.
Thank you, sir, and thank you, Your Honor, for allowing me the time to come and speak.
Oh, you're very welcome, young man. Any questions, Mr. Geary? No, sir. All right, young man, you can step down and seat in the gallery if you like.
All right, I'd like to proffer. Next person then.
Okay, who's your proffer?
Your Honor, she would like to be identified as Diamond, D-I-A-M-O-N-D. I have a video of her, a news video if you want to see it, but in the sake of time, but we have that if you want to see it. She is, she was raised on Cleveland Avenue. She lost her child, her son, to gun violence. He was murdered. She heads a team to stop gun violence. She is partnered with Travion Martin's mother, Breonna Taylor's mother, and unfortunately countless other persons known and unknown who've lost family members to violence. And Mr. Jeffrey Williams, she would testify, is instrumental with trying to stop gun violence and trying to get people not to think that this is a video game and shooting is okay, and that everybody needs to speak about their controversies and their disputes and put down the guns. And she wanted that to be known, and there is a video if you want to see it, but otherwise that is my proffer.
I'll accept your proffer. That's fine, sir.
All right, next is, he's a witness here, Mr. Kevin Lyles, which is L-I-L-E-S, and he has known Mr. Williams since Mr. Williams has been just an adult, and we'd like him to come and talk about the factors for bond. He is with the record label, Your Honor, and he has come here to give testimony on behalf of Mr. Williams, and he flew here from, he was at the state, he's in New York, but I don't know where he flew here from.
All right, where's Mr. Lyles?
He is right here, Your Honor.
All right, Mr. Lyles, good afternoon, sir. If you could please approach the witness stand. Once you get there, be so kind to turn and face Deputy Talk and the sworn as witness. Before you sit down, hold on.
Raise your right hand. You swear in front of the testimony in court, truth, the whole truth, nothing but truth, so help you. You take your seat. State and spell your first and last name.
Kevin Lyles, Kevin Lyles.
Good afternoon, sir.
How you doing, Mr. Steele?
I'll let you know. can you do me a favor and give this honorable court, educate this honorable court on who you are, your background? The court may not be familiar.
Your Honor, I'm a 54-year-old father of four. I'm kind of emotional because how good this guy is. I have Morgan State University. I built a stadium in my old school. I have a street named after me. I have all kind of honorary doctorates. I employed probably 5,000 people. I was the president and CEO of Def Jam. I've been in this music called hip hop for 38 years. And for the life of me, I don't understand why I have to testify the good that hip hop has done around the world. I've also started a company with Jeffrey called Young Stoner Life. And I remember what he said to me. We're not just starting a company, we're gonna change some lives. And that's what he's done. And he's definitely changed mine.
Mr. Lyles, how long have you known Mr. Williams?
Well, I was a fan for probably 12 years, but I personally got to know him over the last 10 years.
Okay. And have you signed, or your company signed Mr. Williams?
Yes, he signed to us. And I hate to say that he signed to us because it's my partner, but we have two deals. One deal is a deal for him as an artist, solo artist, and the other deal is for Young Stoner Life.
And I know this is personal, but financially, there's been testimony that if this trial, and I'm not saying the court would allow it, but if it doesn't take place for a year, there'd be over $1 million in expenses just for 24-hour security of police officers to ensure, off-duty police officers, second jobs to ensure Mr. Williams does not flee, does not get types of weapons, does not intimidate a witness, is not a danger to community or property in the community. Can he afford, from your personal knowledge and how much money he earns, can he afford that type of undertaking?
Jeffrey can afford it, and I can afford it, so it will be paid for.
And you are willing to back him as well?
I'm willing to back him personally and professionally.
Okay. Please explain, if you can, and discuss fully how your life intersected with Mr. Williams' life.
My job is to seek out talented people. And I think God brought us together in a very weird way, but I think we were meant to be together. Jeffrey is not just an artist. He's an influencer. He is a person that I think was put here to change the people around him. And he's so talented. He's creative, he's innovative, and he's fearless. He's a risk taker. And those kind of people, I call them change agents. I'm not signing just artists, I'm raising a young man. He looks at me as a father figure. He's not, like I said, we can't limit it to just his lyrics or his music. He's a young man, and he will be a contributing citizen to this world. And that's what I invested. And I truly believe this whole thing that people are talking about, it's not him. The Jeffrey I know give me clothes off his back. The Jeffrey I know, I'm giving my kids, he give me his kids. That's the Jeffrey I know.
You mentioned lyrics. There's been a lot of argument by the prosecution about the lyrics in songs. Can you explain, if you have the insight, what is selling in the rap industry dealing with the lyrics, and why are they being promoted, and why are people wanting it?
Your Honor, you've I don't know how old you are, but no. Older than you. So I've been fighting this battle for over 40 years. It's not new. And it's funny how we're the #1 music in the world now, and we want to bring this back up. Now, we don't argue about any other movies or other genres of music that talk about I ran them over in my truck, or I got drunk and I went and shot him. We don't bring those things to court. But quote unquote, our music, we've been on trial. And we constantly on trial about who we are, what we are, and why we're. And nobody gave us nothing. So we sit here on trial, we talk about lyrics. Lyrics, I don't understand the thing, but I'm gonna be here and I'm gonna keep fighting for it because I believe self-expression, and I believe we should protect Black art. We should protect Black art. And I'm on trial for lyrics. Come on, man.
With regards to Mr. Williams, the court may not be familiar. Where does he rank in, if there is such a ranking, in the music industry?
Objection, Judge, that's not relevant to anything.
Shows his employment status as part of the Ayala factors and whether the record company is going to continue to back him.
I think you've already established that to the witness. He's used to potentially be on alternative release.
Okay. You understand that Mr. Williams was charged in 2018 in DeKalb County with a offense involving, he was riding in a car with two other people, and there was a gun and a small amount of drugs in the car. Are you familiar with what I'm talking about?
Yes.
Okay, and you know that case, it's still pending, believe it or not, but it went up to the appellate court. I don't know, are you familiar with all that?
Yes.
Everything was suppressed by the Honorable Superior Court judge in another county, and then the state appeal got reversed and it's pending. You're
Yes.
aware of all that?
Yes.
Okay. So Mr. Williams is actually on bond for that case.
Okay.
The allegation also entails the fact that when Mr. Williams was arrested at the home here in Atlanta, a search warrant was then executed at that home, and there were multiple firearms. One firearm is allegedly illegal. It's to like a machine gun. And there was supposedly about 2 pounds of marijuana and some items in, looks like an energy drink, but it supposedly contains either Schedule 2, 3, or 4 drugs in it, codeine, supposedly. You familiar with that?
I read it.
Okay. Understanding all those facts, the DeKalb County case, current bond, and the search of the home, you're also aware that many other people were in that house at the time of the search warrant, right?
Yes.
Okay. I'd like to ask you the following questions in addition to the fact that we are charging 2 counts in this current indictment. You're familiar with the RICO conspiracy and the gang count? Okay. On your oath, would you be willing to back with your own personal property and wealth, or as well as your own company's personal property and wealth, bond for Mr. Williams if the Honorable Court wanted a high bond?
Objection, Judge, it's ask and answer. The witness actually has already stated that, and I very
Yeah, he already said
I very clearly heard the
he put up
gentleman
his own company's resources, so it's outstanding objection.
Would you be willing, okay, if it's the same question, I apologize, but I thought it's a different question. You have to understand that you would, if the court wanted to, you would lose that wealth if Mr. Williams violated condition of bond. I mean, it's not just going by when Mr. Williams in custody, you're released. The court could have signed as a co-signer on that bond, and you would actually have a lien against your wealth if Mr. Williams violated condition of bond. Are you willing to do that?
Like a son to me, yes.
Okay, without hesitation. Obviously.
Without hesitation.
All right. Do you believe that if granted bond on your oath, Mr. Williams would intimidate any witness?
Nah.
Obstruct the administration of justice?
No.
Be a danger to the community or property in the community?
Not at all.
And a risk to commit a crime while out on bond?
No, not at all. He has too much respect for me and too much respect for the company that we're building and too many people that depend on him. It's not about Jeffrey. It's why it's about the family. It's about the community. You know, he understands. He's inspiring the world right now. There's a kid that he changes their life every day. I really believe that.
For the better?
For the better.
I have one last question for you. If this honorable court granted bond, but it was very, very restrictive. Mr. Williams is not coming out to studios. He's not doing videos. Speaking with him may be curtailed. Is your record label still willing to keep him as a vibrant member of SIN?
That's my partner.
And just for the court's edification, I think you just said, but Mr. Williams not only an artist, he's an owner of the company, right?
He's a businessman. I told him hip hop has given him a way to be an entrepreneur, a way to empower people, a way to educate people. And he has a responsibility. He knows that with this success comes responsibility. And we made a commitment to each other that we're going to do this for the rest of our life.
I want to thank you so much.
Thank you, Your Honor.
Hold on one second. State, any questions?
No questions, Judge.
Okay, all right. Then I'll release you. Thank you very much, Mr. Jackson. Mr. Lyles, I should say, apologize. Go ahead.
Your Honor, I'd like to proffer the next person. He is on your Zoom. Thank you for letting him come in. And if I say anything wrong, I would just ask, if, with the court's permission, if Mr. Garfield, Garfield, Larmond, Larmond, Jr. would make sure that I am corrected, because I'm not trying to say anything wrong.
What's Mr. Larmond going to tell me?
Your Honor, he would say the following. He's a part of the management team for Mr. Jeffrey Lamar Williams II, also known as the performer Young Thug. Mr. Larmond graduated from Georgia Southern University with a bachelor's degree in business marketing. In 2015, he met Mr. Jeffrey Williams in the Atlanta, Georgia area. At the time, Mr. Larmond was pursuing a goal of his career of photography, but soon found himself receiving the opportunity to put his college degree to work on the management side. Despite his young age and lack of experience, Mr. Williams gave him the opportunity to learn how to manage and get involved in the music industry. But now moving forward to 2002, he would state that he has built a strong, well-rounded, and positive relationship with Mr. Williams, a relationship that he upholds with the utmost respect. As an individual in society, he would testify, Your Honor, that Mr. Williams is kind, well-spoken, intelligent, and a giver to the community. Not only does Mr. Williams influence millions of listeners around the world with his music, he does so with his actions as well. During the holidays, Mr. Williams ensures anonymously to give back to the community through tour drives in the city of Atlanta, donations to various organizations such as Planned Parenthood, to the Cancer Society, and others to support causes that affect people around the world. Just recently, in 2021, Mr. Williams, along with the record label, paid bond for numerous inmates in the Fulton County jail system in an effort to reunite people with their families, show them no matter what, they've not been forgotten or lost. And Mr. Williams didn't know any of these people and didn't ask for anything from them. Mr. Williams is a family man. He has his parents, 6 children, brothers and sisters, all right here in the Atlanta, Georgia area. If Mr. Williams is not working and bringing his talents to the stage outside of the state, he spends every holiday and celebration in Atlanta with his family. Mr. Williams' family gathers together for dinners, Christmas celebrations, birthday celebrations. They have recently purchased a home for future family gatherings not too far from this courthouse. Mr. Larmond would tell this honorable court on his oath that there is no world where Mr. Williams would abandon his side of the family and children in order to avoid fighting this case. His family and the community are both large pillars in his life, and they both support Mr. Williams throughout every court date and every step of this upcoming trial. Mr. Williams has never been convicted of a crime. He has never missed a court date. And Mr. Larmond has personally traveled the world with Mr. Williams. They have performed on every single continent, Your Honor, except Antarctica. Mr. Williams has performed in front of as many as 300,000 people. and he always returns to the state of Georgia with no issue. Mr. Larman's oath backs Mr. Williams for pretrial bond. Mr. Larman was also at the home at the time of Mr. Williams' arrest. He would testify, and it's on video, the surveillance video, that there were many other people in that home. Mr. Williams did not have a gun. Mr. Williams did not flee when the police came to the home. I received telephone calls from Mr. Larman. I received telephone call from Mr. Williams. I told Mr. Williams, no one's going to hurt you. Surrender peacefully to law enforcement. He asked me to please come to that area. I came to his home. Mr. Williams was then, after I got there, escorted out of the house. He did nothing wrong. He was actually drawing in the house. There are drugs and guns in that home, according to law enforcement. Mr. Williams, I've interviewed these people already. They hide those items from Mr. Williams. He can be drug tested. He's been drug tested, by the way, since 2018. Mr. Larman would testify to what I just said. If I am wrong, Mr. Larman, though, you have to correct me because this honorable court takes that as your testimony.
I will accept that. This is proper, okay?
Thank you, sir.
All right. Anything else?
Yes, sir. Your Honor, this is Jeff, which is Geoff, Ogunlesi, and he is in your courtroom.
What's he going to testify to?
Your Honor, he is very close with Mr. Williams. He's a very accomplished young man. He's very, very well known in the music industry. He will testify that in 2018, I received word that there was a warrant from DeKalb County for Mr. Williams' arrest. Mr. Williams was actually performing at that time in Las Vegas, Nevada. Mr. Williams, it was the first ever tour with a performer known as J. Cole, Your Honor. And when Mr. Williams was informed that there was a warrant from DeKalb County, he immediately left the tour, missing several dates of the tour and significant income. He turned himself voluntarily in. I was with him, Your Honor, to the sheriff in DeKalb County, and he would testify that Mr. Williams will comply with all conditions of bond, and he will not be a flight risk because Mr. Williams' commitment to the law, to the family, to his family, to his musical career, and his roots here in the Atlanta, Georgia area. And that if Mr. Williams did become a fugitive, he would end all of his contractual obligations, all of his money would end, and all of his royalties would end because he's, as a fugitive, nobody would deal with him. It would be harboring a fugitive. Mr. Ogunlesi, Your Honor, is the current vice president of A&R for 300 Entertainment and vice president of Young Stoner Life Records. It's a record label that was created by Mr. Williams. Mr. Williams, by the way, Your Honor, is CEO of that record label. Mr. Ogunlesi has worked since the inception of the 300 Entertainment company in 2014 and for Young Stoner Life Records since that inception, since 2016. Young Stoner Life Records has become a hugely successful Black-owned company enjoying millions of records sold. In 2020, he also became Mr. Williams' personal manager and has been working on a one-on-one relationship with Mr. Williams since Mr. Williams' ascension to stardom. But he'll also tell you that his relationship transcends Mr. Williams as an artist, a record label, or a business partner. They've developed a deep friendship. He would tell the court that Mr. Williams has achieved the following successes. He was 2017, Your Honor, MTV Music Video Awards, Best Editing. he won that. 2017 United Kingdom Music Video Award, Video of the Year, Best Urban Video, Best Editing Video, he won that. 2018 MTV Music Video Awards, his Video of the Year. That was a song called Havana with another great artist. They won that. 2018 American Music Awards, Collaboration of the Year, Video of the Year, as well as Favorite Pop and Rock Song. He won that. 2019, Mr. Williams won Grammy Awards for Song of the Year. In 2020, Soul Train Music Awards, Mr. Williams was the Best Collaboration as well as the Best Dance Performance. Won that. 2022 at the Grammy Awards, Album of the Year went to Mr. Williams. 2022 XXL Awards, Your Honor, Video of the Year, Mr. Williams was deemed the winner of that. Also in 2014, BET or Hip Hop Awards, Mr. Williams was nominated for Who Blew Up, Make You Look Award, and Best Banger Award. 2015 BET Awards, Your Honor, Coca-Cola Viewers Choice Award was nominated for Mr. Williams. 2017 United Kingdom Music Award, Vivo Must See Award. 2017 Music Video Awards, Best Production Designer in a Video. 2018 MTV Music Awards, Song.
Jack, at this time, this is nothing but repetitive.
It's pretty impressive to show who we're dealing with, Your Honor.
But you've established, I think, his ties and his depth. So I'll accept Mr. Ogensay's proffer and what he would testify to in its entirety.
Yes, of course. OGUNLESI. Your Honor, since flight is the most significant issue that this honorable court has to deal with for consideration of bond, as the cases that I've already referred to, Mr. Ogunlesi would also explain that Mr. Williams prioritizes his family. He's had opportunity after opportunity, even before he was well known. He had an opportunity in 2015 to work with Kanye West, Kanye West, WEST, to collaborate and work. It was a rare opportunity. Mr. Williams wanted to bring his family with him, his sister, his mother, and Mr. West stated no. And Mr. Williams then said he didn't want to hurt his sister's feelings, so he declined that opportunity. And that's who we are dealing with, Your Honor. He is not a risk to flee. And I appreciate the court saying that he has ties to community, but also a risk to flee the jurisdiction of the court. Is that true, Mr. Ogunlesi? He's raising his hand to the court and said yes. Your Honor, Dr. Matthew Norman is here, I believe, in your courtroom. Okay, he is outside, Your Honor. Hopefully he will come in. And
is Dr. Norman outside, Madam?
Judge, just a question. We were told 6 witnesses about 8 witnesses ago, so I'm just curious how much we're going to repeat.
Yeah, Mr. Steele, I believe that we already have, I was clicking off that as well. By testimony or by proffer? This is number 6. Mr. Ogensay would be number 6.
I wasn't counting the proffers.
I'm counting those. Because you want me to
Then I
accept
have
you want me to accept it, you want me to accept his testimony, so.
Of course.
Yeah, so.
Well, I have 3 more witnesses or proffers, but I'd like to make them for the court's understanding.
What's this
Mr. Williams where he's being held, and he would, I'd ask him to educate the court what the conditions are for Mr. Williams and how that Dr. Norman is a very well-known psychiatrist, and how the studies show that the conditions that are being placed upon and Mr. Williams is living under are detrimental to his mental health, and they disintegrate people. And that's what Dr. Norman is here for.
Object, Judge, not relevant to the Ayala factors.
It's not, Mr. Steele, and I have great respect for Dr. Norman as well, having had him testify in court on for the state, for the defense, on a number of matters. I don't believe that would be one of the bond factors that I would need to consider in this case.
Well, I'd like you, may I just make my statement for the record then? And I'll do it myself. Okay. And if I say anything wrong, I'm saying it's not wrong. Your Honor, currently, Mr. Williams is held 22 out of 24 hours a day in a cell, except for when I or Mr. Adams or Ms. Hornsby goes see him. That cell, according to Dr. Norman, will break a person's spirit.
But that's not part of the bond factors. In prison, pretrial incarceration is viewed as being oppressive. It's not lost on the court. We don't jail people for shucks and giggles. That's why we have bond hearings, and the case law that you eloquently pointed out tells the trial courts of their responsibilities. But I don't need to hear any testimony on that. It's not lost on the court of what incarceration, subjects people to. So I don't think it's relevant for purposes of my bond consideration.
The reason I'd like the court to consider it is as follows. It was not requested by Mr. Williams, but he's treated differently than a typical pretrial detainee, and it's said for his protection. That's what the sheriff has told me, and the sheriff is always nothing but professional. The problem with that is it is detrimental. It is punishment, and we don't punish pretrial, and that's the cases I gave to the court, and that's why I thought Dr. Norman was important, because having an ill effect on a gentleman who's presumed innocent, and if they can't make conditions for him, I've made those conditions. I tried to put together to this honorable court conditions that would satisfy this honorable court that Mr. Williams will be a good person.
I hadn't made that decision yet, Mr. Steele.
No, I know.
But with all due respect to you and Dr. Norman, that's not something that I need to consider at this point in time. I think it's fair to assume that, and I don't get involved in our good sheriff's business as well, but, he and his colleagues and teammates have a methodology of what they do for the inmates that are there, depending upon what stage they're in. And, that's independent of my determination of bond. So I certainly, in terms of the bond and the factors for granting bond, it's not something I need to hear about. I'm going to take it at word that being in jail is problematic for most folks, and that he is presumed innocent, and that the issues of being granted bond or bail, I will take into account. Okay.
And then, Your Honor, we have in your courtroom Gara, which is G-A-R-A, Dallam, D-A-L-L-A-M. Your Honor, he's a bonds person, representative of Free at Last.
I'm sorry, I was writing. So I'll take Dr. Norman. I will take what you were going to proffer about Dr. Norman. I will accept that, but I agree with the state. It is not relevant for the purposes of my making a bond determination. But okay, so what about, who's the bondsman you have here?
The gentleman who is seated right here, Your Honor, waving at you. His name is Gara, G-A-R-A, or Gara, excuse me, Dallam, D-A-L-L-A-M.
That one more time, D-A what?
D as in David, A-L-L-A-M.
Dallam, okay.
And he's a representative, Free at Last Bonding Company here in Fulton County.
Okay.
He would testify that an ankle monitor can be used, even if this court got rid of any electronic equipment in the house. It would have to go to a landline, and then that landline obviously could be just for the, not to make calls, it would just be for the ankle monitor alone. And that the insurance company is willing, they have already vetted Mr. Williams, his ties to the community and his risk of flight, and free at last bail bonding, and the insurance company are willing to stand behind Mr. Williams' bond if this honorable court grants bond. And under the case that I gave this honorable court earlier, that's for the significance of that case, whereby courts take into consideration the fact that there's another layer of protection with a bonding company on a bond. If I said anything wrong, Mr. Down, you need to correct me.
No, sir, you're correct.
Okay.
And then, Your Honor, we have Counselor Michael, Michael, who should be here. And he's raising his hand to this honorable court. He is actually the preferred person that Your Honorable Court, Fulton County, many counties, but use for all the drug programs in the counties. We had the pleasure of using him. Judge Adams wanted, in Judge Adams of DeKalb County, DeKalb County Superior Court Judge. And when Mr. Williams was on bond for that case, Judge Adams wanted Mr. Williams to be drug tested. And even during the pandemic, Counselor Michael would meet with Mr. Williams, give him drug counseling and drug testing personally. And these are all filed in the court in DeKalb County, and I could give a copy to the court if you want it, from November 26, 2018 until the Honorable Judge Adams said, this is ridiculous. He's proven that he's not on drugs. Goes up to January 28, 2022. Mr. Williams was not using any type of codeine or lean is what they call it, or other drugs, Your Honor. That's 3.5 years. It's approximately 3.5 years, Your Honor. And that's why we will be fighting the open warrants here from the search warrant on the May 9th arrest of Mr. Williams, the search warrant of the guns and the drugs. Mr. Williams is not using those drugs and not with the guns, and other people actually live in that house more often than Mr. Williams. He will testify that he would continue, he's actually pursuant to our request, continuing, we need an order from the court, but continuing counseling with Mr. Williams one time a week for himself, one time a week with his partner. And when he's been at Mr. Williams' home, there are no drugs in sight, and Mr. Williams tests negative. That would be Counselor Michael.
All right, Chair, I accept the proffer.
Is that true what I said, Counselor?
That is true.
Your Honor, there are some videos that we have, and I could proffer one from Colson Baker, Colsombaker. He's a performer known as MGK. It's in Exhibit S. I've already submitted it to this honorable court. It's in a Dropbox link. You could look at it yourself if you want. And he talks about Mr. Williams assisting the community. There's also other videos that we've already given to this honorable court, talk about Mr. Williams appearing when there's tragedies like hurricanes or tornadoes. He is constantly going to other states, as well as when there's tragedies here in Georgia, and performing for free. All the monies go to Target to restore the neighborhoods. Mr. Williams has employed thousands of people had studios put up in the Cleveland Avenue area, so children don't have to think that it's all about selling drugs and running the streets and being in gangs, that they can go and have places to be with sports, dance, reading, tutors, and the like. Your Honor, I have Mr. Williams' passport. We'd ask that if this honorable court grants bond, the passport be surrendered. I could either hold it personally and I would not release it without order of this court, or we can give it to the court or the sheriff or whoever the court designates. Your Honor, there's also a gentleman, Mr. Cohen. He is the worldwide person who does all of Google Music, all of YouTube Music. He's on a video that you already have. It's in Division or Exhibit S. And he stands behind Mr. Williams, bond, all four factors of Ayala, and he puts his reputation next to Mr. Williams as well. Your Honor, I, along with the Honorable Avis Hornsby, as well as the Honorable Keith Adams, we will be ready for our trial. We understand the enormity. I've only had 2 cases with this type of discovery that I'm being told 5 terabytes would fill up the entire hallway on the 8th floor of the Fulton County Courthouse or more. You can't get through that discovery. So what we did in other cases, we have a search engine company that we already spoke with. I asked Mr. Geary, he's been telling me he will get it to me. There's no problem. He's an honorable person always. And we are going to go through the discovery. It's like searching Lexus. We're not going to be able to read everything. No one's going to be able to read all that. But we do our search terms, and we are with the court on the 9th day of January 2023. If that gets bumped, because I understand that there's a lot of people here, the court may say, I don't want to sever, or some people may ask for continuance that's granted. That's why I filed the demand for speed trial, understanding that I'll file it again once it's good with Judge Brasher's order. But I wanted to be upfront with everybody and give everyone notice that that is our intent. Your Honor, Mr. Williams has family in your courtroom. His father is here, Jeffrey Williams Sr. His mother is here, Bertha, B-E-R-T-H-A, Greer, G-R-I-E-R. He has brothers. They're not all here, Your Honor, but that's not for, that's for reasons of violence. But it's Oscar Greer is his brother. Quinton, Oscar is typical spelling, Greer, same spelling. Quinton, Q-U-I-N-T-E-N, Greer. It's his brother, Letitia, L-A-T-I-S-H, Greer. His other sister, Angela Greer. His brother, Gregory King. His other sister, Wyshena, W-Y-S-H-E-E-N-A, Greer. His other sister, Alexis, A-L-E-X-I-S, Greer. His other sister, Catherine, C-A-T-H-E-R-I-N-E, Greer. His other sister, Dorothea, she goes by Dora Greer. And Mr. Greer is the second, Mr. Williams is the second to youngest. All these people are in the Atlanta area. They're all here. They all would testify that they would swear to the Ayala factors. Jeffrey Williams' children, Your Honor, he has 6 children. They're all here. They live with him. Most of them live with him. Kyvion, K-Y-V-I-O-N Jackson is a 14-year-old son. Jacob, J-A-C-O-B Ragland, R-A-G-L-A-N-D, 12-year-old son. Haiti, H-A-I-T-I Rice, 11-year-old girl. Amari, A-M-A-R-I Steele, S-T-E-E-L-E, 10-year-old girl. Hayden, H-A-Y-D-E-N Rice, 7-year-old girl. Jameer, J-A-M-I-R Ragland, R-A-G-L-A-N-D, 7-year-old son. They're all here in this area, Your Honor. Your Honor, the way I understand the law is that the issue is flight risk. This is how I've always understood it, and that's why I gave you the Coleman case. It came out in November 2021. The preeminent issue is Mr. Williams going to come back to court? If the answer to that is yes, then conditions have to be met, if they can be made, for all the other factors, which is intimidating a witness, danger to the community, property and community, obstruction of justice, risk of commit a crime. And that's why I brought Mr. Middlestat, and I want to thank him. I want to thank everyone, but I want to thank Mr. Middlestat, especially, Your Honor. What we have developed, I hope, is anticipating every potential that could go wrong. And we have Mr. Williams now with sworn law enforcement officers 24 hours a day, 7 days a week. He is confined to his house and under Brown, BROWN, versus state case, Your Honor, I gave this honorable court, which is the 2012 case. Our court realized that our legislature is using things like electronic monitoring, house arrest, rather than the in custody treatment that Mr. Williams is currently undergoing. Your Honor, based upon this record, I will ask this honorable court to permit me to answer any questions that you have. In addition to that, we filed on at exactly midnight on Sunday, May 22, 2022, going into Monday, May 23, 2022, our brief in support of pretrial release and pretrial bond. It has several attachments. I know this honorable court well, and that you've read it and digested it, but there are multiple attachments there about other people who know Mr. Williams, who all vouch for the fact that he will come back to court. Your Honor, on behalf of Mr. Adams, Ms. Hornsby, I wish to thank Mr. Williams for allowing me to stand with him. We will be ready. I, of course, want to thank this honorable court for everything it does for everyone at all times. Mr. Williams will be objecting, as I know the state's aware of this, to any dealings where they're proffering that Mr. Williams' lyrics mean something or he's on a video. We want to challenge that evidence. We are not accepting it, and we rely on the case law that he is presumed innocent of any type of criminal activity. Thank you.
Okay. Mr. Gary, before you get started, I'm a person of a certain age, and I've been sitting here a while. I need to use the facilities, and I think many of you probably need to do so as well. So we will be in recess for about 15 minutes.
Even the Gambinos, one of the big crime families, the crime boss, they had charities. They ran legitimate businesses. They did that as well because they want what Mr. Williams wants. He wants the appearance in the community. That's what he put up. He put up the appearance in the community, and he put up people that are financially dependent upon him. And quite frankly, I objected for relevancy, and that's not relevant to the facts of bond. The fact that he can pay $1 million a year is not relevant. Your Honor, Mr. Steele stated to the court that guilt is not a factor and innocence not a factor. I wholeheartedly agree. But the nature of the offenses charged, guilt or innocence, is at a time later. And that's the reason is why if someone's charged with a misdemeanor, they automatically get a bond. Felony, they've got to come before a judge and ask for a bond and be judged on the Ayala factors 1761. And that's why that's that way. And for the court's knowledge also is, and it was talked about, and I don't know the court's intent, so I'm going to address it one way and the court can inform me otherwise, is we have two things here. We have the indictment charged that I understand they're seeking a bond on, and then we have a separate case. That separate case is 22 CP 208957. That is the arrest of Mr. Williams on May 9th, 2022. And that is the one where in his house, there are drugs all over the house. There are weapons all over the house. One of the weapons has been modified to be a fully automatic weapon. Mr. Williams is talking about how important his children are. To my belief, Judge, one of his children was there present in the house. And these guns aren't locked up. They're out. I do not believe a cruelty to children charge was filed, but I believe the evidence certainly would have supported it, Judge. Judge, there was a sawed-off shotgun or a sawed-off illegal dangerous weapon. There was an automatic weapon. The court was already informed by Mr. Steele about how much marijuana was there. When the police arrived, one of the individuals tried to flee the house. It was obvious what was in the house and what was about to happen, so one of them decided to run. And I'll be fair, that was not Mr. Williams. Mr. Williams did not attempt to run. Judge, I want to say, and I told Mr. Steele I would do it this way. Since the last time I was in front of the court, we have evidence and information of even more threats to our witnesses. But I want to be clear, I have no evidence directly that Mr. Williams made a threat or directed anybody to make a threat. But our witnesses in this case are being threatened with violence, serious violence, and death. Again, I have no direct evidence that Mr. Williams has done this or was involved in that. What I can tell the court is Mr. Williams is the head of YSL, and the S doesn't stand for stoner, it stands for slime. It's young slime life. Judge, this gang, and I call it that because that's what it is by definition under Georgia law, this criminal street gang pre-existed the label record. So as a spinoff, he used YSL again and substituted one of the words. I believe he does have a clothing line. Like I said, I believe many of the crime families get into legitimate businesses, and I believe Mr. Williams has done no different. Judge, I want to say this too, contrary to what Mr. Steele said. He has always appeared. No, he hasn't. When he was arrested, he had an FTA. Now, I will say and be honest to the court, I believe it was for a traffic offense. But then the logic is if he's willing to blow off a traffic offense with no recourse, I think he'd surely think about blowing this one off if he's looking like things aren't going well. So he did have an FTA, and it was current on his arrest, which was 9 May of this year.
When was the FTA from?
When was it from?
Yes, sir.
Your Honor, I can't answer that question. I apologize.
Okay.
Now, Mr. Steele put up that there's no evidence he's done drugs. You know, he's had these drug testing. Everyone knows we listen to jail calls. We've got a call from Mr. Williams at Cobb County that he needs help for his drugs and he needs to detox. He needs drug help. That's on a jail call. So that's directly from Mr. Williams. So that's not accurate. I know Mr. Steele says he's got his visa. Mr. Williams now.
Passport?
I'm pardon, Judge?
Yeah, passport, you said visa.
Well, passport, I'm sorry. Yes, sir.
Okay, all right. Okay,
yes,
I just want to make sure.
Yes, sir, Judge. I'm just used to one of those red things that I know the court knows, and that's what I've always traveled on. Judge, he's got access to a private jet. Now, I don't know if he owns it or if he leases it. I know he continuously flies on a private jet out of PDK into DeKalb County. Again, I'm not speaking for or against the officers that are on this list. I don't know any of them. That list has not been provided to us. We've already been contacted by 2 police agencies who want to know, because if their officers are on that, they will not permit that to happen. So there might be some pushback on that list. I take the investigator's word that he's cleared all that. I don't know. I don't know who's on the list, Judge. Judge, I will also say that we have taken proffers from fellow gang members from Mr. Williams. Some are on this indictment, some are not. They have stated uniformly that Mr. Williams is dangerous. They are afraid of him, that if they cross him, he will kill them and their family. And they were very clear about that. Your Honor, when I said the other case, I want to also go back to that 22 CP case. A bond hearing was held on that. I have a copy of the results from the court. I believe Magistrate Judge Robert Wolf on the 11th day of May, 2022, denied bond on the charges based on the arrest. And as it stands now, it is no bond. Now, what I understand from the order, and I'm going to provide this copy to the court in a second, it was denied for a flight risk and risk to commit additional felonies. May I approach, Your Honor?
You may, sir.
Can I see that one more time? Do you mind?
Yes, sir. May I approach, Judge?
You may, sir. Thank you.
So respectfully, Judge, if you're not considering that today with the indictment, as I understand the motion, then he's already on a no bond for 2 of the Ayala factors. Your Honor, count 1 alleges racketeering, and it basically alleges that the enterprise, if you will, for the racketeering is a criminal street gang as defined by Georgia law. That criminal street gang is a gang called YSL. That's Young Slime Life. Young Slime Life has a reputation, if you will, both inside and outside the court system. Your Honor, I'm going to go through some of the things in the indictment just to let the court know. Mr. Williams, in Act 4, which is from 9/9/13, had a stolen firearm on him. Now, I will say I believe his counsel was, in fact, Mr. Steele, and that act was to a pretrial. So it is not a conviction, but it is still a predicate act under Georgia law. He did possess a stolen weapon. I will say there's a Act 9 on 4/20/14. It is a song. The name is EWW. And in it, basically, the defendant says, all I ever wanted was the money. Basically, if you mess with me, you go into a wheelchair. That's what that one says. Your Honor, we have other, and I'll leave some of the social media. I'll handle that generically for the most part, but we have numerous social media posts where the defendant is in what I would call gang colors, flashing gang signs with his fellow gang members, some of which are his co-defendants on this indictment. And on those, they are, on the videos, they are replete with gang statements, gang hand signs, threats, etc. Judge, and again, they're listed in the indictment. Judge, the murder of Donovan Thomas that we've spoken a few times, that's basically Act 16, 17, 18, 19, and 20. In that series of acts, in Act 16, the state can prove that, or I will say this, it's the state's contention that the car used in that murder was a car rented personally by Mr. Williams just days before. And evidence will come in concerning the beef between Mr. Williams and Mr. Donovan Thomas that involves another well-known rapper and how that gentleman's career was going to go. And Mr. Thomas and Mr. Williams had a serious disagreement about that, which led to Mr. Thomas's untimely death. Your Honor, on Act 25 from January 25th, 15, we have a conversation. A conversation is an electronic digital form where the defendant states sacrifices must be made, soldiers must fall in order for battle to be won. And then it goes on to talk about everyone has to line up between all the sex, money, murder, which is a subset of blood, which basically YSL comes under, that they must all line up under one of 5 leaders, and they must do so immediately. And that is again from Mr. Williams. Your Honor, on 126.
Is that you said that's in a digital?
That's
format?
in a digital format, yes, Judge.
Is it a conversation? Tell me the context.
Yes, Judge.
Okay. It's a conversation?
It is, I believe it's in the form of a group chat where Mr. Williams is putting this out to many, but to his crew.
And when did this occur?
This occurred on 125-15, Judge.
Okay.
Okay. Now the next day, 126-15. Remember, now let me take you back again already. On 110-15 was the murder of Donovan Thomas here in Atlanta, Fulton County. Okay. So approximately 16 days later, Mr. Williams releases a video, and he's basically stating, or doesn't basically state, I should be quoting, is that he basically says, if anybody goes into a courtroom and tells the God's honest truth, and pardon my language, they need to get fucking killed. And again, that's only 16 days after the murder of Donovan Thomas. And that was a threat that still is being talked about by some of his own gang members and some of our witnesses as to what will happen to them if they continue to cooperate. Your Honor, on 7/7/15 in DeKalb County, Mr. Williams made a threat when he threatened a head of security from Perimeter Mall. And I will tell you that DeKalb County dismissed the case. They thought the threat to be conditional. I don't have that requirement as a predicate in a RICO count. So the terroristic threat resolved or formed from Mr. Williams and his associates entering the mall on those 2-wheel hoverboards, and the mall told them they weren't allowed to have them. They informed mall security that to F off, they could do whatever they wanted to do. You can't tell them what to do. Mall security followed them out to the vehicle to inform them that they now have a trespass warning and they have to leave. As the officer, who is now a certified police officer, told Mr. Williams that they can't come back in, Mr. Williams, identified by this now officer, told the officer, if you don't back off, I'm going to shoot you in the face. At that time, the officer or the security guard then did back off. They have pictures on the scene of Mr. Williams and of the car. Your Honor, on
hang tight. Ms. Amana? It may be a situation, if everybody concerned, we booked the Zoom for the day, and the day ends at 5, so that's probably why it probably cut off. So let me just see if we can fix that. We may have to send out another link. So just bear with us a second.
Yes, Judge.
Still working. To all concerned, we're just going to recess in place. That's exactly what happened, was our Zoom timed out. So we're going to need to set up another link. So just give me a minute, okay? We're just going to recess in place.
2417, Act 68, I believe 69, 70, 71, and 72, Your Honor. This is a act out of Brookhaven Police Department that Mr. Steele spoke of, where Mr. Kitchens and Mr. Williams were stopped in a car based on a traffic violation, and a stolen weapon was found in the vehicle, and methamphetamine with intent to distribute, hydrocodone with intent to distribute, marijuana with intent to distribute, and a criminal street gang charge arose from that. And the interesting thing on that was when the officer asked Mr. Williams' name, the response from Mr. Williams was, I'm a superstar, can't take me to jail. The officer did. I think Mr. Williams discovered there that that didn't work. Your Honor, on Act 73 on 12/30/17, Mr. Williams appeared in a video. It was called Original Slime Shit, with lyrics, murder gang shit, YSL 2, you're dead and pale. Act 74 is a music video on 4/12/18 where Mr. Williams states or sings, I never killed anybody, but I got something to do with that body. That would be our position, is that as the leader of this criminal street gang, Mr. Williams probably has never killed anybody. I don't know that to be true or not, but he probably has others do it for him as we understand the evidence, Judge.
When was that Act 74 music video?
Which one, Judge? I'm sorry.
Act 74, you said.
Act 74
The one you
was
just told us.
4/12/18, Judge.
Okay.
And again, the way, as we addressed it in our evidence, Judge, we essentially addressed that as a confession by a party opponent. In Act 75, Judge, which is another traffic event in DeKalb County, it's on 5/18/18. In prior songs, the defendant sings that he travels with snipers, he travels with a dangerous gang, you can't mess with his people. In this, it was a traffic stop, two vehicles speeding down the road. Officer stopped them for speeding. Mr. Williams was driving the lead car in a Porsche. I do not believe any weapons or any drugs were found in that car. Mr. Williams indicated to the officer that the people behind him worked for him. The people behind him stated that they worked for Mr. Williams. In that car were four individuals, some prior felons, and they were armed to the teeth to include a fully loaded 30-round mag with an AK-47. I do not believe Mr. Williams got any charge other than a traffic ticket at that time. Again, no weapons were found on him and no drugs were found on him. Your Honor, on Act 78 from 1/15/19, it's a video called Bad Boy. Now, understand at a point, Mr. Williams got into a beef, if you will, with another rapper by the name of Rayshawn Bennett, also known as YFN Lucci. At some point, Lucci's mother was shot at, and the song comes out with Bad Boy that says, let's see, you better watch the way you breathe around me, for that breath be your last, boy. Smith & Wesson 45 put a hole in his heart, better not play with me. Killers stay with me. I shot at his mommy, now he no longer mentioned me. Again, we believe that Mr. Williams doesn't sing about random theoretical acts. He sings about gang acts that he's a part of or his gang participates in. Following that, Your Honor, in the same year, Act 96 on 8/8/19, Mr. Williams posted on Instagram a post, if you will. It said, IFN or YFN, if ain't like what you do for your mother and your kids, I would have killed you. And that was tagging YFN Lucci. Now, I'll go back and I'll get to that later. But this year, a YSL member attempted to kill Mr. Rayshawn Bennett, AKA YFN Lucci, at the Fulton County Jail. That's on video as well. And we can tie that to the gang, and I'll get to that later. Your Honor, on Act 97 from 9/16/19, Mr. Williams posted a video called Just How It Is. There were lyrics in that one as well.
What number is that, sir?
97, I'm sorry.
No, I'm sorry.
And it said, last N-word tried me, almost got popped at Lennox. Asked the cops, asked the detectives, they know all the business. Asked the cops and the detective all the jurisdictions. Gave the lawyer close to $2 million. He handles all the killings. Mob business. We know to kill the biggest cats of all the kittens. Also, it should be noted that it's alleged that Mr. Donovan Thomas was the head of the Inglewood family criminal street gang at the time. And irrespective of his position that he might have had in a gang or not in a gang, Mr. Thomas didn't deserve to get gunned down on the road in Atlanta. Position our Act 102 judge from 3/12/20. Mr. Jeffrey Williams is in a conversation with Mr. Huey, also a defendant in this indictment. Now, let me set this up, Judge. And you heard part of this last time, that there was the theft of a car by someone in the gang, Mr. Huey, and it belonged to I believe, a manager of Mr. Williams. Mr. Williams was upset to find out that it was, and he basically texted his folks to say, give it back. Okay. Now, in that, he responds to Mr. Huey, says, if he don't take it back, he gonna die. Followed that, Mr. Huey basically was begging for his life in the conversation. It's very clear that he believed that statement by Mr. Williams. In Act 127, Your Honor, from 2/4/21, Mr. Williams is in a conversation with other defendants listed on the indictment, where he stated, YSL rule the world, kid. 24 million on an N-word's head. Y'all just start bringing me the money. Man, y'all stop playing with me. That was in reference to gang activity and basically evidence that he is in charge and all the money goes to and flows through Mr. Williams. On Act 130 from 4/16/21, Judge, there's a social media post titled Slatty, SLATTY, lyrics stating, I killed this man in front of his mama, I guess sister and his cousin. I shoot out, kill him, not leave a trace. It says, you think you a gangster, you got a pistol, look at my trigger start itching. YSL, we going overboard. And again, YSL is a direct reference to Young Slime Life, the criminal street gang. On Act 131 on 4/16/21, there's a video released called Ski, SKI, with lyrics stating, I fuck with slats, slacks being basic slang, life's forever. We come to eat rats. I came with some piranhas. I tote an FN, a reference to a handgun. And in that one, which is interesting, Judge, which you'll hear in the evidence of this case, is this is a hybrid gang. This gang isn't pure bloods. There are rolling 60s in it, Crips. There are 30 Deep. It is a combination of many different gangs to form this gang. In Act 132 from 5/13/21, Judge, a conversation where Williams asks the others in the conversation, y'all ain't beat him up or shot him yet? Y'all N-word getting soft. And I believe that's directing the activity of the gang to stand up for the reputation of the gang and not be disrespected. Your Honor, in Act 139, I'll miss 139, Judge. In Acts 150, Mr. Huey, which I spoke of earlier, had gotten out of jail. He had communicated with Mr. Williams, basically stating, and this is Mr. Huey, you know I'm ready to handle the business and go sit down if I got to about any one of y'all on my mama. Sit down is a reference by the gang, is I'm willing to go to prison for you. I'm willing to do time for you. In Act 155 from 12/31/2021.
What date is that? I'm sorry, one more time.
I apologize, Judge.
What date and
12/31/21, Judge.
and that's predicate act, right?
It's an overt act, Judge. There was a photo released by Mr. Williams with him wearing a YSL pendant with basically with taking his finger under his nose like this, Judge, which is a gang sign from YSL. That's one of their signs. When we watch the videos, you'll see that a lot, Judge. Judge, in Act 156 from 1/16/22, defendant released a video, and why we think this is important, Judge, is because the gang signs mostly done by Mr. Williams are YSL gang signs, Young Slime Life. They may argue that it's Young Stoner Life, but in this video, Mr. Williams flashed a Bloods sign, not a video, not a YSL sign, a Bloods gang sign. He's also got a photograph where he's got a red B right about here on his chest, Judge, which is a common Bloods tattoo. On 3/9/22 in Act 172, Williams posed for a photograph with the caption, "Slat Business YSL 4L for Life." Judge, we have proffers that from gang members, and some on the indictment, some not, that Mr. Williams is the leader of the gang. He directs the gang activity. This gang, as you can see through the indictment, there are numerous murders, there are numerous armed robberies, there are numerous attempted murders, shootings. Just like, again, I spoke about the Gaudis, about the criminal gang mafia families out of New York. The bosses themselves never got their hands dirty. The position here is, Judge, is Mr. Williams directs and has directed all of these individuals, Judge. And he recruits people continuously, Judge. We have a proffer, Judge, even from the mother of one of the defendants in this indictment, who told us that Mr. Williams does the community events in order to recruit more people, that her son was recruited by money, shoes, clothes, because they didn't have anything. And now her son's, by her statement, is in jail for the rest of his life. And that's that's the mother from one of the defendants on this case. Judge, Mr. Williams essentially is YSL. Everybody else is a follower. There are leaders. We said Mr. Kitchens, Mr. Greer, they are also leaders. But the leader, the top dog, the most dangerous man here is Jeffrey Williams. because he doesn't have to get his hands dirty. He has others to do his business. Judge, in an analogy, you found the others danger to the community, danger to commit additional felonies. And I would say, of the least of them, you found them dangerous. This is the most of them. This is the one that you see the shadow in the back of the room. He's the one directing traffic. He is the one they're all afraid of. He's the one that's king slime. He's pulling the shots. He is the most dangerous of the 28, Judge. And I implore you not to grant him a bond. He is dangerous. The setup they've given to you is actually going to be less control, not more. If he gets a burner, Judge, and the court may know this, a lot of the communications that Mr. Williams is on FaceTime because it's not traceable, it's not trackable. And we know that to be their MO. He gets a burner, he gets in there, he runs his gang from inside, and he won't get that, and no one's going to throw his cell. I know what the investigator said, with all due respect. That's not the jail. That's their job. It's not the job of 24 officers being paid by Mr. Williams. That's not their job. The job is the sheriff of Fulton County or any other sheriff where our sheriff decides to put Mr. Williams. That's their job. He is dangerous. And I normally don't do this, but I don't hesitate in this case. Respectfully, Judge, I believe if you give him a bond, we're going to have more witnesses in danger or going to be missing. I believe he's that dangerous, Judge. Thank you.
Court's permission, if I may offer rebuttal, just a few closing statements to.
All right, Mr. Adams.
Thank you, Judge. Thank you, Your Honor. There's a lot that I want to say to the court. I'm going to finish my argument by referring to exactly what we're supposed to be doing here, which is talking about the law briefly. And I won't take too long because I know Mr. Steele has done an excellent job thus far of presenting what the court needs to have in front of it in terms of considering suitability of bond. But I want to start where the prosecution left off and talk to the court briefly about why it's so dangerous to have the state make a presentation in a manner that it did. This statement, and this is kind of emblematic of the entirety of the state's argument. If you give Mr. Williams a bond, that I'm afraid there are going to be more witnesses who are in danger or more witnesses who are threatened or something to that nature, right? And the thing that's so disingenuous about that statement is that just about 10 minutes or 15 minutes into in the prior argument, Mr. Gary conceded that there is no evidence, there is zero evidence that there are any threats being made that can be tied in any form or fashion to Mr. Williams.
Well, I think that's not the statement. I think he said as well that there are proffers from other gang members that he's the leader of the gang, he's dangerous, you cross him and he'll kill them or kill their family. So there is something the court has heard thus far.
If we're breaking it down, Judge, what Mr. Gary was talking about in that regard is what I presume he believes will be evidence in the case. Now, in talking about the bond, in talking about whether or not there is any evidence before the court, right? And there was this discussion earlier.
Well, that's a problem. I mean, I take you all in your word for it, Mr. Adams. I mean, it's a proffer. I mean, it goes to the state's contention of whether or not he's a danger to the community. One of the things I have to look at in the one factor. So whether or not I take it as its value certainly is dependent upon what I in terms of weighting the situation, weighting what's been proffered thus far.
And I understand that. What I would ask the court to pay close attention to and to keep in mind is that
allegations put forth by the state in regards to what they say is evidence that is going to be forthcoming are exactly that, allegations that have not been vetted, that may or may not be accurate, that will come before this court, presumably during the course of a trial. But for purposes of the bond, and for purposes of whether or not Mr. Williams, if given a bond, is going to return to court to face process of the court, to face these charges, whether or not there's evidence that goes to his guilt or innocence, whether he is guilty or not guilty of these charges, is not what is before the court. So
You're absolutely right.
Yes, sir.
You don't have to waste your breath on that.
Right.
I'm very familiar with Mr. Williams and the other co-accused, presumption of innocence, and the court deems them as being innocent of these charges. I'm asked to pass on bond, and the bond is predicated on, on the issues that the appellate case law tells me I need to kind of consider. So
let me then address some specific things that Mr. Gary said, that the state said in their argument.
All right.
The state started their argument by saying that this is all about money. And to be quite honest, that's a little bit of, that's a little insulting, because the inference is that if Mr. Williams has means or has resources, that that is a bad thing, that he is trying, in their words, to, quote, I can buy a bond, is what the state said. They said he wants to, quote, pay his way out of jail, is what they said.
Well, I think that they're saying, it's a fact, is resources of the accused in this particular circumstance, but it has to be taken into context with other things. So I'm not saying that. I understand their assertion in that regard, but it's more so the court's going to consider it from an issue of its context of other things.
Yes, sir. And one of the things
and wealth being able to, you can make bond. I mean, I understand that.
And that's precisely the point. The fact that Mr. Williams may have means or may have resources by which that can be brought to bear. Those resources are being brought to bear for purposes of assuring the court of his reappearance. Because the other way, of course, to look at it, as you've heard from some of the witnesses, is that there's a lot at stake. That if he does not reappear in court, that there are financial resources, there are people's well-being that are put at financial stake because of that. And that is certainly something the court can consider in regards to whether or not he would reappear. Now, what I also think is an inappropriate argument is that the witnesses who took their time to come in here and testify about their knowledge of Mr. Williams, about his background, about what he's done, about his ties to the community, about his investments in the community and so forth, and his employment, his financial status, his jobs. They took their time and came in and testified. I would submit to the court honestly about their knowledge to you about Mr. Williams. I do not believe that there's anything to suggest that anyone who came in here and testified came in because of a financial motive, that they have something to gain or something to lose financially by coming in here and speaking honestly to the court about their knowledge of Mr. Williams, which is what the court needs to make its decision.
I'm taking it from the standpoint of he has significant ties to the community.
And that is, thank you, Judge. And that is exactly what I would suggest that information was. That is what was presented to you, that he has strong ties to the community that weighs in to his benefit if he, as the court considers, bond. Now, one of the things that the state referenced, that the state asked you to consider, was whether or not he is a flight risk. And I want to roll this into a discussion of the bond hearing that was held before Magistrate Judge Wolf some weeks ago.
Yeah, I'm going to mark that as Court 2 for purpose of the motion. That was done on the 11th of May and filed into our e-file system, or Odyssey, I should say. So I'll make that part of the record.
Yes, sir. That was on a Wednesday. I was present for that bond hearing. I was there, and I can tell the court that that would have been 2 days after Mr. Williams was originally arrested. He came for a first appearance. I'll tell you that the court, Magistrate Judge Wolf, heard argument from both sides as to the suitability of bond. And I will tell you as an officer of the court that Magistrate Judge Wolf was concerned about the fact that the indicted case was already assigned to you, that there was someone that Mr. Williams was already assigned to on a separate case, a separate but related case. And there were discussions about whether or not, because he had resources, he was a flight risk. Because he had money, he had the ability and the wherewithal to leave. And Judge Wolf, I will tell you, in denying the bond, which he did, essentially indicated that he asked me very many questions about whether or not there was a bond hearing scheduled in front of Your Honor, and whether or not you'd be considering the issue of bond on the indicted case, and that he would defer, that he was going to deny bond at the time, but he was going to defer to Your Honor because the other case was in front of you and because that case was related. And so it is my impression from the hearing on that day and the denial of bond that the court anticipated that you would be making the larger decision as regards whether or not Mr. Williams receives bond on both matters or not. And of course, both matters are in front of you now. Now, there is, in regards to flight risk, whether or not he's a flight risk and some of what the state has said, there is no indication that he's a flight risk. Mr. Gary referenced a failure to appear, and yet conceded that he doesn't know anything about that failure to appear.
It's for a traffic offense. It's of diminished value to the court, but I'm more interested in the access to the private jet.
Yeah, well,
at PDK in DeKalb.
And so that's the thing, because our suggestion to the court is that he be placed on house arrest, that he have an ankle monitor, that there are post-certified law enforcement officers who are responsible for making sure he complies with the court's conditions. There is no suggestion on our part that he be allowed to fly by way of private jet, commercial jet, helicopter, or anything of that nature. And so the argument that because he has resources, he has in the past has had access to a private jet, that is something the court should be concerned about. We would suggest to you that is not something for you to consider, because we're not asking that he be allowed to have that access. You heard from Mr. Middlestat, who indicated that what would happen essentially is if the court were to graciously grant bond for Mr. Williams, he would be released from where he is now. He will be transported by law enforcement officers to the location that the court has indicated, and he will stay there. And if he is to leave to come to court, for the only reason, that he would do so under supervision and under guard of law enforcement officers. And when Mr. Middlestat testified, I think he was clear and he was deferential to the court in regards to what the requirements would be. These are going to be post-certified law enforcement officers who are sworn to uphold the law. We did not suggest that private security, just any individual off of the street, serve as the people who would guard the house where Mr. Williams would be confined. As a matter of fact, the list of those individuals was provided to the court. They can be vetted. We have indicated and we have suggested to the court that the DA's office can vet them if they want to. They can go to the home. And quite frankly, circling back around to this private jet issue, let me tell you, Mr. Williams doesn't own a jet, has never owned a private plane or a private jet, and he would not even have access to that because we're suggesting that the court not allow that. It is of some particular note that at the time that Mr. Williams was arrested, when the police came to the house, there were SWAT team officials and plainclothes officers who came to the house. We've seen the video. There were individuals approaching the house from different locations with guns, and the state made a reference to the fact that one of the individuals tried to run. It wasn't Mr. Williams. Mr. Williams never tried to leave. He never tried to run. He didn't abscond. He didn't try to fight the officers. He went with them. And so there's no indication that he was a danger to flee. In fact, he had just gotten back into town the day before. And you have heard that the only other time when there was a warrant that was issued for Mr. Williams's arrest he left a tour, left Las Vegas, left those resources, came right back to the cab, turned himself into custody. And so everything that you've heard, all of the evidence, the facts that you heard would speak against him being a flight risk. He is not, and there is no, they've not presented any evidence that he's a flight risk. An argument in and of itself that he is not sufficient for the court. Is there any danger that he would threaten or intimidate witnesses? We've discussed that a bit. There was some discussion in another bond hearing previously, and I'm wary about trying to make comparisons or make reference to bond hearings regarding any other individuals, because Mr. Williams deserves to have his bond considered simply based upon the factors involving him, characteristics involving him, his suitability for bond, not anybody else. But this talk that we heard previously about people with phones in jails, or people making phone calls, or there are witnesses who are terrified right now, other than the state purporting to have other quote unquote, what they say are gang members, or someone's mother who's saying that there are threats being made, that there has been no evidence other than that assertion, that allegation presented to the court. He has been locked up since the 9th. They have access to his phone calls. They're recorded. They have access to, I mean, he's locked up 22 hours out of the day, sometimes 23. But you've not heard any indication here that, well, he made a recorded phone call and there was something that he said in that phone call that we perceive as a threat, or he's contacted someone and he has asked them to do something that we believe is commensurate with intimidating a witness or trying to influence a witness. You've not heard any evidence of that. And so there's simply no evidence to substantiate their allegation that he would be a threat to intimidate witnesses. Now, moving specifically to the indictment. And I heard you say it before, and I accept when the court says, Mr. Adams, I know that guilt or innocence is not the province of a bond hearing. And thank you for that. But they spent a good bit of time going through the indictment. But what they actually did is they simply read their allegations. These are their allegations, right? These are what they say Mr. Williams did, or what they believe Mr. Williams, offenses they believe he's committed. They have to prove that. And there is nothing to suggest that simply because they have sat down and drafted up an 88-page indictment that the allegations in this indictment are accurate or are true. I've been doing this for a long time. And there have been times, many times, when the allegations put forth by the state have simply not been borne out at trial. So the state can stand up here and sound as certain as they want to that, hey, we think the evidence is going to, or we know that the evidence is going to show X, Y, Z. And then when months later, after the court has considered that in regards to whether he gets a bond, when we're actually standing up in a courtroom, they don't prove it, or it turns out not to be true, or a witness that they say is going to say something, says something different, or is impeached, or someone is proven to not be telling the truth. And so to stand here and say, well, there's a song lyric that we believe is relevant in the case, and they're talking about a particular incident, is trying to convince the court that their allegations are true, trying to convince the court that their allegations are factual, and there's nothing to say that that is the case at this point. In Ms. Gary, the prosecutor, asked the court to look at several acts in the indictment. Started with Act 9. And the prosecutor, I noticed, read or paraphrased some words in Act 9. All I ever wanted was the money. And then moved on to put him in a wheelchair, taking it totally out of context. This is a song. And the dangerous thing about where we are with them believing that they can pick and choose song lyrics or portions of song lyrics is that they don't know what they're talking about, but they're putting it in here as though it's fact. They could not tell you, I guarantee, who wrote the song, who was actually singing a particular lyric in this song, or what the song is referencing. And that's what's dangerous. And I know at some point we're going to be arguing about whether these song lyrics go to anything specific in the indictment. But Judge, I would just ask you to take a look at what's been proffered or what's been presented to you. Act 9. Read just like Elmo, but I never effing giggle. Well, what does that mean? And what does the next line mean? What is that? Is that referencing something specific, a specific count of the indictment? They can't tell you that. And it's taken out of context. Last week when we had a bond hearing, Bob Rubin represented one of the other individuals, said something that I thought, as a 56-year-old person who grew up in Brooklyn with rap music and all of that, thought was particularly insightful. He said, Judge, it seems kind of bizarre, some 50-something-year-old white guy is trying to tell you what, someone who's a rapper means in a particular song. And I don't mean to suggest that that some people have greater sensibilities about rap music than others, right? But what I am suggesting is that it is somewhat disingenuous to simply quote portions of song lyrics when you don't really know what they are, and to take them out of context, and to not know who wrote the song or who's actually singing the song. Because I can tell you, I've poured through this indictment, and I know for a fact that there are some of these lyrics that are quoted or attributed to Jeffrey Williams that were not written by him, and that were not sung by him. But when do we find that out? In the middle of trial? After they've stood up here and try to convince you that you ought to use these lyrics as incendiary as they sound to deny him bond, and then 8, 9, 10 months later, oh, that wasn't Jeffrey Williams. And that's why it's so dangerous to have the state. I'm not going to go through each and every one of them. I was going to, but I'm not going to because I'm mindful of the time. But I think the court gets my point that to quote song lyrics and Instagram posts or group chats or group texts that we, by the way, contest in several of them is not Jeffrey Williams, and that he did not say that and did not say those things. And there's no greater force to them standing up here and saying that he said those things than us saying he didn't. It's on equal footing, and it shouldn't be considered because it's just something that has to be proven later on. I thought this was funny. Act 74, I think it is, the state reference. Act 74. Now that one I thought was particularly interesting and is, I think, symptomatic of what is flawed about the state's argument as to why you should consider everything they've read to you or presented to you in the indictment. Act 74 references Jeffrey Williams releasing a video. They said it was released on 4/12/18. I'm going to suggest that at some point in the future, they'll go back and they'll correct that, and they'll recognize that this was a song, Anybody, that was written by Jeffrey Williams, Nicki Minaj, and a third writer. And that some of the lyrics that are in here are actually lyrics that are sung by Nicki Minaj. But they don't know that. They don't know that, but they stand up here and say this with the force of authority, thinking that that's going to be, and they made that essential part of their argument. What did they say? They said, the song lyrics say, I never killed anybody, but I got something to do with that body. And that, Judge, is exactly where we're telling you that Jeffrey Williams, no, he may not have ever killed anybody that we know of, but he's the man in control. He's King Slime. He's the one who's running everything, and he's confessing it by saying that in this song. I told them to shoot 100 rounds. They left out the other line that comes after that. Like they're trying to movie a body, like they shoot a movie. I mean, it's laughable, but it's an issue for later on down the road. Judge, in regards to the court's consideration, 4 things. Maybe 5. If you have everything in front of you, Judge, that the court needs to make a determination about whether Mr. Williams is suitable for bond. I would contend respectfully that he is. There are no greater set of assurances that any defendant can put in front of you that can give you some assurance that he will reappear for trial than we have done. We have given the court every possible option I would suggest to you, and we have offered up the ability to have the court have its say in everything in terms of which of his residences, what house he lives in. Right? The court and the DA can have access to video feed from the house, so they can see what's going on in the house while he's there. That these law enforcement officers who will be properly vetted, who have been properly vetted, who will be there and will be responsive not to Mr. Williams, not because it's being paid for by Mr. Williams, but because they're responsive to the court, and will have reports that are submitted to the court or to the DA's office. So we've put that in front of you, Judge. We're asking you to take that assurance and give it significant consideration, not because he's able to pay for it, but because it's going to accomplish what you need for it to accomplish to assure you that he'll show back up. We have suggested and we have put before you the option of he needs to work, but having a studio built at his residence where and inspected by law enforcement to ensure that there's nothing untoward going on there, so he can do what he does. That's his job. We have suggested to the court that, not suggested, we're happy to surrender his passport, even though it's not an issue. He's not leaving the house, but we'll surrender it anyway. We have suggested that his calls can be monitored, and so any device that's used to make any phone calls can be monitored. And so whoever he talks to, whatever he says to them, will be known. Anyone who comes to the house has to be cleared and will be known. By the court would have to approve a list of individuals who can come to the house. There is, in short, nothing more that we or any defendant can give to the court to satisfy what the court would have in front of it to ensure that he returns to court. Mr. Williams has not been convicted of anything before, and he stands before this court with some very serious allegations, but we're ready. We're going to be ready. We'll be ready to address them at the appropriate time, but we ask that you consider respectfully granting him a bond that allows him to be free from that custody, yet still confined under the court's order, to allow us an opportunity to properly prepare for this trial. We think it's appropriate, Judge. A bond is appropriate. Whatever you believe is an appropriate amount of bond with all of the conditions that we've put in place, or we've suggested to the court, or whatever else the court wants to add. But we believe that we have done everything that any defendant could possibly do to show the court that bond is appropriate. Thank you.
All right, Mr. Adams, thank you. I'm going to defer ruling for just a second. You want to take care of Mr. Sharp, and I can, at this point in time.
Whatever you want to do.
Okay, all right. Mr. Sharp, you want to go ahead and present your issues as to bond, sir?
Excuse me, Your Honor. May I use the restroom, or I need to be here? I've been holding it for a long time.
It's not funny. Y'all be at ease. Yes, sir. In fact, I'll just take 5 minutes and you can go ahead. Everybody can. You come back, okay? All right.
Yes, ma'am.
I'm going to recess in place just for a minute. Okay?
This not a joke. This not a joke. There's a father and a CEO. Yo, they exposed so much game I brought up today. Like God is good, man. They exposed so much things that I brought up today. Think about some of the things that we argued today with Mrs. B and what I talked about. I said, as I was here, I pray, I believe in God. I said, God gave me a bombshell. I said, YSL, I said, Jeffrey is not the sole owner of YSL. Jeffrey is not the sole owner of YSL. You know who else co-owns YSL? Kevin Lyles, who testified today. Well, who I've been talking about all day, I've been talking about Lyle Cohen. And I put Lyle Cohen's information in the chat. I put Lyle Cohen's information in the chat. Did y'all know that Lyle Cohen is the head of YouTube and Google Music? I told you that. But then it came up in court. It came up in court. Lyle Cohen, the platform we're on right now, after he left, he created 300. Lyle Cohen and Kevin Lyles created 300. Also, co-owners of 300 are Kevin Lyles and Lyle Cohen, the head of Google Music. I thought it was YouTube Music. They said he's now the head of Google Music because Google owns YouTube. This case is connected to one of the largest companies in the globe. This black woman just stepped in shit. How can you charge YSL with a RICO case when Lyle Cohen is the owner of 300? If 300 is a gang, then you have to charge Kevin Lyles and Lyle Cohen. If 300 is a gang, then you have to charge. If 300 is a gang, then you have to charge Kevin Lyles and Lyle Cohen because they are co-owners of YSL. If YSL is a gang, then Extension 300 is a gang because 300 gave him the bag. 300 is the plug. 300 is owned by Lyle Cohen and Kevin Lyles. Kevin Lyles testified today because he's co-owner of YSL. He said, I'm on trial. Why did Kevin Lyles hear? Because Kevin Lyles recognizes and he's going to put it on the court. You cannot just charge him. I also own YSL. I own YSL too. So why am I not being indicted? Why is Jack Harlow not being indicted? Why is Lyle Cohen not being indicted? How can you justify the argument that YSL is a gang? Like I said in the comments, they have not proved that YSL is a gang. They have not proved that Young Thug is a gang member. They have not proved that Young Thug is a gang leader. And now they just blew up the fact that the rap lyrics were not even written by Young Thug. There is no case. Now you know why the federals have not come in. The feds are not coming into this bullshit. It's convoluted. It's very messy. There is no trial. There is no case. There will be no federal indictment. There will be no federal indictment because the FBI goes after big fish. If the FBI comes in, that means the FBI is going after Google and YouTube. And nobody is going after Google and YouTube. Do y'all hear me? We can't even really talk about this shit. You're not even really supposed to say Lyle Cohen's name like that. He don't even like that shit. These is big boys. They don't play like that. They don't play like that. This case brings his name in court. You think Lyle Cohen is happy right now? Remember what happened with Donald Trump lawyer? When Donald Trump lawyers start getting brought up in court, he ended up being indicted and going to jail. That was a famous lawyer. Remember Donald Trump lawyer who paid off Stormy Daniels? When he started coming up in court cases, when his name started being discussed, people started investigating him, he ended up in jail. You think Lyle Cohen wants to be discussed in a criminal RICO case? You think Kevin Lyles wants to be testifying in a criminal RICO case? Are y'all really paying attention? God dang. Young Thug is like Puffy with Revolt. Puffy doesn't even really run Revolt. Remember when Puffy wrote the article with Byron Allen and he said, me, Magic Johnson, Oprah Winfrey had to sell on. Oprah Winfrey had to sell on. She was a co-owner of OWN. Puffy is a co-owner of Revolt. Magic Johnson was a co-owner of Aspire. That's what the Byron Allen lawsuit was about, that you have no black cable channels 100% owned by black people. And Byron Allen's lawsuit is we don't own our own voice. Young Thug is a beginner in the music industry. He's not in a position to own his own record label solely. He has to have help from a 300, from a Lyle Cohen, from a Kevin Liles. How can you propagate Young Thug, YSL is a gang, and Young Thug is a gang member and the leader because he's the owner of YSL when he is not the sole owner of YSL? And how can you say lyrics associate him with crime and violence when he did not write or even record the lyrics? This case has been blown up in the bond hearing. There's no case in the bond hearing.
All right, folks, before I go ahead and get started, whatever the decision is today, this is a forum, a public forum where all are welcome. However, if you feel that you cannot govern your behavior or have acceptable conduct, please, you can exit the courtroom and nobody will be the wiser. If you make any outbursts or statements or anything that the law enforcement professionals in this courtroom deem to be inappropriate, you will be removed from the courtroom and maybe subject to other actions. So I just tell you that up front because my deputies are charged with the responsibility of good order and discipline. So whatever my decision is, like it or not, I'll give you an explanation for it, but outbursts were not acceptable, okay? All right, so with that, counsels, I've gone ahead and based upon what has been proffered and the appellate, the case law, I should say, that's been provided to the court, I'll summarize a couple of different things already that you as counsel for the state as well as for the defense, I'm sure aware of. I'm looking at Coleman versus the state, and that's already been cited. That's 361 Georgia Appeals 901. And I'll quote from that decision, which is which comes from our court of appeals, Judge Miller, Miller being presiding judge in that particular case. Excessive bail is prohibited by the Georgia Constitution, Article 1, Section 1, Paragraph 17, and the Eighth Amendment to the United States Constitution. And for the Eighth Amendment analysis, as you all are aware, that Eighth Amendment violation would be excessive bail or no bail, or fixing an amount that is excessive under the circumstances. When fixing, for the purposes of the Eighth Amendment, the excessive bail is defined as bail set at an amount higher than an amount reasonably calculated to ensure the presence of the defendant. When fixing bail in Georgia, trial judges' foremost consideration is the probability the accused, if freed, will appear at trial. And then the court in Coleman goes on to quote that lesser factors or lesser extent or considerations are the accused's ability to pay, the seriousness of the offense, the accused's character and reputation. I have heard a lot of evidence today about those particular factors in regards to Mr. Williams and his ability to pay and the seriousness of the offenses and his character and reputation from as presented by Mr. Steele, Ms. Hornsby, as well as Mr. Adams. So I have considered those particular issues. Now, also, Coleman goes on to say that A defendant who seeks release on bail has the burden of showing roots in the community. The defendant does not pose a significant risk of fleeing, threatening the community, committing another crime, or intimidating witnesses. And along with this particular case, the court also has considered the seminal case of Ayala versus the state at 262 Georgia 704. And Ayala gives us the framework in Georgia for the purpose of a pretrial bond is to prevent punishment before conviction and secure the appearance of a person for trial, quoting Roberts versus the state, 32 Georgia Appeals 339. And it goes on to say that a trial court may release a person on bail if the court finds the following. So I have to look at the first thing that Coleman directs me to look at is consideration of whether or not the foremost consideration is will he, if free, appear at trial, and then the lesser factors, and these are a court may release a person on bail if the court finds one, poses no significant risk of fleeing from the jurisdiction or failing to appear in the court when required. Two, poses no significant threat or danger to any person, to the community, or property in the community. Three, poses no significant risk of committing any felony pending trial, and poses no significant risk of intimidating witnesses or otherwise obstructing the administration of justice. And I'm required to explain any reasons if I deny bond to assist the appellate court in its review, and that the granting or denial of bond will not be set aside unless there's a manifest and flagrant abuse of discretion. That's Jernigan versus the state, 111 Georgia 307, pinpoint 308, very old case from 1903. Now, in regards to considering bond for Mr. Williams, I have considered the first consideration is if free, will he appear at trial, and to a lesser extent, the other factors. And based upon the court's consideration of the proffer, the two things that the court has significant concerns about are him being a danger to the community and flight. And I'll state for the purposes of the record and purposes of my decision that I realize that Mr. Williams is presumed innocent. I realize that he has the presumption of innocence stays with him until the state, by sufficient evidence, is able to prove to a jury's satisfaction beyond a reasonable doubt, I should say, that he is guilty of the offense or offenses charged. But however, in this particular circumstance, there has been significant proffers about Mr. Williams' being a danger to the community. In particular, the state's proffer that they have taken proffers from other gang members and people who are in this particular indictment and they're not in this indictment, that he is the leader of the gang, he is dangerous, and if he crosses them, he'll kill them or their families. And the predicate or the review of the state, the concerns that I have are some of the statements that he's made about the threats and to others, and that have been chronicled in particular in some of the predicate acts that have been stated for the court's consideration. Whether or not those acts, as Mr. Adams has pointed out, or because they have to be proven at trial, is a discussion for another day. But at this point in time, in the aggregate, those particular discussions, in particular, the proffer from the people that the state has talked to already, the group chat that from 2015 starting, anybody goes into a courtroom and tells God honest truth, they'll be fucking killed, pardon me for the language. And this threat is still being talked about. So that is of a concern to the court, in regards to the danger to or threats to persons in the community. So and factors, quotes, there's no significant arrest of intimidating witnesses or otherwise obstructing the administration of justice. That is the court's concern. The two major concerns that this court has is danger to persons and threats to intimidate other witnesses and obstruct the administration of justice. So I have some concerns about the flight that I share with Judge Wolf also indicated, but and I'm not going to hold it against him that he is very successful and has significant means, but those two factors in particular, threats to persons in the community or poses significant risk of intimidation of witnesses and otherwise obstructing administration of justice. The court has considered a number of the predicate statements, and for those reasons in the aggregate, I'm going to deny bond at this time. But Mr. Adams, Ms. Hornsby, and Mr. Steele, certainly if you should file any other additional motions or things change, I certainly will reconsider the court's position on bond. It is not lost on me that I have not given your client a bond, but you know, that is my decision based upon what I have heard, and I certainly appreciate your advocacy on behalf of your client and all of the lawyers thus far who have advocated very well for their clients in this particular position. And I will do my level best to make sure that this case gets tried as expeditiously as possible. And if I can get it on the calendar before the 9th of January, I will endeavor to do so. So anything else at this point in time?
One thing, Judge.
Yes.
I'm sorry, I know the court file sent an email to, I think, the Public Defender's Office concerning getting defendants who are presently unrepresented representation. We wanted to kind of weigh in on that. We filed a motion today requesting the court to respectfully get them so we can get everybody arraigned and get it moved. I want to just give the court.
Mr. Gary, you must think that I have a lot of power. I really don't. Yeah, I mean, but in all seriousness, I've heard from Ms. Bernard, Gina Bernard, and she right now is working on getting people assigned.
I just want the court tells me to bring copies. I'm trying to provide copies.
Yeah, we certainly, have you given copies to
They've been served. Yes.
Okay, all right.
Electronically.
Okay, if you'll give those to Mr. Kearns right here, so I think Mr. Chamberlain's gone. But we are the court is inherently sensitive as to that issue. And as soon as those attorneys can be appointed, and I have some correspondence from Ms. Bernard saying that they are working on that issue right now, and that we will certainly get those people brought over as soon as possible. But and if you all have any other information in regards to that, please let us know. But we're tracking that issue, and I will continue to talk and dialogue with Mr. Chamberlain about that. Okay.
Yes, sir. Thank you, sir.
Anything else, folks?
No, sir.
No, sir.
Okay, all right. Thank you for your patience today, folks. Unless you have anything else, we'll be in recess for the time being. Okay? All right, thank you.
January 9. January 9. He said, I will try to get the trial to start before January 9. January 9. January 9 is not till 2023. He said, if you listen all day, there have been people waiting for 2 years because of COVID. They just now getting, and they refused bail. There was a gentleman in jail for 2 years for arson. He's just now going to trial. Just like the guy who committed suicide in New York, he was on Rikers Island for 3 years waiting for trial. There's a guy today who went to court today who's been waiting 2 years to go to trial. This is the MO in Atlanta. The same thing they do in New York. You're not supposed to be able to keep people in prison. This is, and you know what I was thinking about when they were talking about the monitor and the pager? I was thinking about Meek Mill and Jay-Z. Where is Meek Mill and Jay-Z? Kevin Lyles is there, so I know Kevin can call Jay-Z. Where's Meek Mill and Jay-Z? Because Meek Mill and Jay-Z have a multi-million-dollar prison reform, and it's about a crime bill on the Senate floor about getting rid of prison. The whole goal going forward, we can't afford prison. You know, like gas is $7 a gallon. And it's going to be hot. The energy grid in Texas doesn't work. We can't afford prisons anymore. We can't afford to house black men in prison anymore. America can't afford it, right? So they're coming up with new laws going forward. And one of the new laws that they have going forward is what Jay-Z has even invested into the company. Remember, people were mad at Jay-Z because he invested into the company with the pagers and the ankle monitors. That's part of that whole thing that Meek Mill is with the billionaires and the football players. It's them preparing for the next level of slavery. It's them preparing for the next level of captivity. Black men will never be free. Black men will never be free. And these are the new house niggas, and black men will never be free. But we can't afford to put you in prison anymore. So they're going to have AI, robots, chips, you know what I'm saying? Things where you can't go. We want to go to a museum for the baby's birthday. You can't go to the museum if you don't have all the things that they want you to have. We already live in this time right now. We already live in this time right now. Make this go viral, Mrs. B. So we got the answer. No bond. No matter everything we discussed today, young Jeffrey did not receive a bond. That means Gunna is not going to receive a bond. This is very sad. My question today had not been answered. He said he's worried about other people being hurt. If you're on the jury and you hear everything that's been said and you believe everything that's been said, and now this black man with these dreadlocks in the orange jumpsuit, why would you say he's not guilty? Why would you let him out? The judge wouldn't give him bail. The judge wouldn't give him bail. The judge thought he was too dangerous to let him out. Why would I, as a jury, I'm a regular person, I got a daughter. You want me to believe you? I don't believe you. You in jail. You in the orange jumpsuit. Black men are King Kong. Black men are violent. I believe you in the gang. I believe everything they tell me. And even if you're not in the gang, it's safer for me to keep you in jail. That's the 93 crime bill. Check this out. Young Thug is in the orange jumpsuit. I'm on the jury. Even if I don't believe that you in the gang, it's safer for me and my kids to keep all 28 of y'all in prison. Even if the state is lying, I'm not a criminal. I'm not in the gang. My kids are not in the gang. Maybe you did it. Maybe you didn't. I don't know. But I'm thinking about my family, so I'm not going to let you out of jail. You're already in jail. You're already in the orange jumpsuit. Why would a jury now let him out of jail? If the state can scare the jury and say he is dangerous, if you let him out, your daughter is in danger, why let him out? The state don't really have to prove the case. They already won. Kevin, the one thing I said is, how can Jeffrey be a gang leader because he's the CEO of YSL Records when he is not the sole owner of YSL Records? YSL Records was a gift to Jeffrey from his daddy, Liar Cohen. YSL Records was a gift to Jeffrey from his daddy, Lyle Cohen. Lyle Cohen started 300 Records with Kevin Lyles. I remember the video. After Jeffrey wore the dress, when Kevin Lyles brought him into the 300 offices. 300 created Migos. 300 created QC. I remember when Lyle Cohen brought him into the 300 offices and gave him his own office, gave him the YSL label. Kevin Lyle said we have 2 deals with Jeffrey, one as an artist, one as a record label. I remember the video. You can go find it. It was on World Star, where he brought Jeffrey in because everybody was like, you wore a dress, you did all this stuff. And remember, everybody was teasing him, and Lyle Cohen brought him in. This is before Gunna. This was almost 10 years ago. This was before all of this, when everybody was thinking Young Gunna was suspect, when they was thinking Young Thug was suspect. I remember Lyle Cohen bringing him into the office and giving him his own offices, YSL as a record label. This person right here is the head of Google Music. This person right here is the head of YouTube Music. Lyle Cohen is co-owner of YSL. He created YSL. He created 300 with Kevin Liles. His name came up in court today. How can Jeffrey be a gang member and a member of a gang when he is an employee of Lyle Cohen and YSL is a subsidiary of 300 Records? What does this say right here? It says in September 2012, Cohen resigned from Warner and started his own independent label, 300 Entertainment. Okay? Is everybody paying attention now? There it is right there. 300 from the Migos, right? 300 from the Migos, right? You guys remember the Migos. Hannah Montana, Hannah Montana, Hannah Montana. Y'all remember 300, right? Who was the other one? Grizzly. 300, right? 300, right? That's Lyle Cohen created 300, right? Well, 300 is where Young Thug is signed to. And 300 is what gave the label YSL to Young Thug. So is YSL really a record label? YSL is like a paper stamp. The record label is still 300. Is anybody listening? Is anybody listening? The record company is still 300. The record company is still 300. The record company is 300. YSL is a paper rubber stamp. That's all YSL is. YSL, because nobody don't like 300 no more. So we're going to push all 300 artists through the YSL rubber stamp. YSL is just a face for 300. The record label is 300. Who owns 300? Look at who owns 300. Do y'all understand how the music industry works? Do you understand how the music industry works? Young Thug don't own a record company. Young Thug is a music artist. YSL is a rubber stamp that they push 300 artists through. Y'all remember they would say Drake was signed to Cash Money. Drake was never really signed to Cash Money. Drake was signed to Universal. Remember he talked about Sylvia? He got his checks direct from Universal. Drake just signed how much? Like 400 million, right? He got a basketball contract because he re-signed with Universal. But we always thought Drake was with Cash Money. Cash Money was the rubber stamp. Cash Money is rubber stamped by Universal. Universal is the real company. Universal it's not Cash Money. YSL is going to be the next Cash Money. And you know what Universal would do with all their black artists? This is the racist part. You know what Universal would do with all of their black artists? Send them through Cash Money. You know what 300 would do with all of their black artists? Send them through YSL. Do y'all understand this? This is not new. This is how it's worked. This is how it's worked for a long time. We sell black people through black people. These black people don't really own these things, but we make you think you own them. And this is how we sell you and market you. Universal is a mega company. So black people might not buy a product from Universal. So I'm gonna put a black face, Cash Money Records. And I'll sell you black people products via Cash Money Records. 300 started to get a bad name. So I'm gonna sell you artists like Jack Harlow. Why is Jack Harlow associated with YSL and not 300, because it benefits 300 and everybody in the relationship to push Jack Harlow via the YSL platform, via the YSL vehicle. Pushin' P was going to be the Grammy-nominated Song of the Year. It makes sense for Jack Harlow to be around Gunna, around YSL. It's the newest, hottest label. Pushin' P and Gunna was going to be in Grammy talks. If you go to the barbershop with LeBron James, one of the biggest episodes this year was when Gunna was on the barbershop with LeBron James talking about Pushin' P. And they talked about how influential the song was. Pushin' P puts Gunna in Grammy talks. If Gunna isn't arrested and YSL isn't indicted, Gunna is in Grammy talks for Song of the Year. Do y'all hear what I'm saying? If Gunna is not indicted, Pushin' P, I thought I blocked. How did this person keep coming back if you block him? Everybody want to be my friend today. Everybody want to be my friend today. Yoni and Dad channel, Judge needs 3 million. Facts. Everybody want to be my friend today. Well, I'm going to get up out of here. We've been on live. This is my job, man. Hey, y'all hit the cash app. Me and Ms. V was talking about this earlier. So I'm going to politely say, Pushin' P song was too fire. The song got them locked up. Now, I don't think the song got them locked up. I'm bringing up Pushin' P because how the influence of the label and the fact that Young Gunna career has been changed and his trajectory in his life has been changed forever. And if he wasn't indicted, Pushin' P would be in Grammy talks. I want people to understand the truth about corporations and black people. We talked about a movie the other day on the Roger Report about black banking, right? And the movie was about Samuel Jackson and black men who wanted to own a bank so they could lend money to black people to buy houses. But in order to do it, they had to have a white man pose as the front of the bank. Did y'all see that movie? Guess what happened with that movie? And I never knew this. Guess why you might not have heard of the movie? Well, the movie came out, but Apple TV bought the movie, and then Apple TV scrapped the movie because they heard one of the people in the movie, right? The little brother in the movie, there were allegations about him. Me Too style allegations. Unproven, never charged by police, but it was enough for Apple to scrap the movie. I said Apple lied. I say Apple always wanted to scrap the movie because they don't want black people to own banks. They don't want young black men to aspire to own banks. They don't want black people to recognize that they won't let you own a bank. They'll kill you before they let you own a bank. Just like they won't let you own a cable television station, just like they won't let you own a record label. How can Young Thug be the head of a gang when he is not the sole owner of YSL? We're on YouTube. This is Lyra Cohen. This is Lyra Cohen. On September 28, 2016, Cohen was named YouTube's global head of music. He was named YouTube's global head of music. 2012, he created 300. 2016, he was named Google's head of music. Just to give some context, just to give you some context, I want to give you guys some context of what's going on here. That's what's going on here, just in case you didn't know. And now this young man, now one more thing I'm gonna add before I go. He was at home with his kids who just lost their mom who got murdered at the bowling alley. So now their mom and dad are gone. Their mom got murdered at the bowling alley, and their father is indicted for RICO charges. Who's going to take care of the kids? Who's going to pay the rent? Who's going to run the corporation? Who's going to run the record label? What happens to Young Gunna's album? Pushin' P was a hot song. What happens to the videos? What happens to Gunna's album? This was his biggest album. That was his biggest single. Pushin' P featured Future. He would have been nominated for a Grammy. What happens to the record label? Who pays the rent? Who feeds the kids? The mother was murdered at a bowling alley. They still grieving the mom's murder. Hold on. The mother was murdered at a bowling alley. He was at home with the kids. He was at home grieving her death. Who was going to take care of the children? Who's going to pay the rent? Who's going to take care of the babies? That's my question. Who's going to take care of the babies? She was murdered at a bowling alley. She was murdered at a bowling alley. These two guys both of these guys, multi-millionaires. Both of these guys, multi-millionaires. And look where it's got. YFN Lucci is indicted for murder. YFN Lucci was arrested because he was caught in a car doing a drive-by. YFN Lucci, a multi-millionaire, did a drive-by, and one of the people in the car, he did it in the $100,000 Mercedes-Benz, number one. The guy in the car who was shooting, there was a girl in the car, and the guy in the car who was shooting got shot. So guess what YFN Lucci did? He kicked him out the car. That's how YFN Lucci got arrested, because they found the guy who was shooting in the car that he had kicked out the car, who turned out to be like his cousin and best friend. He died. He died. And that's how they got proof that YFN Lucci, this is at the height of his career as a superstar, did a drive-by. He's in jail for murder. After that, Young Thug's mother of his children is at a bowling alley birthday party, and she's murdered by one of the members of YFN. This right here is why you got the RICO. When they killed this woman right here, this is why you got the RICO. This is why you got the RICO. This is why you got the RICO right here. Soon as they killed this woman, this is why you got the RICO. So again, politely, subscribe and donate. Thank you, Ms. V. Politely, subscribe. My name is Perfect. It's the Perfect Timing Podcast. Subscribe and donate to the Cash App. The Cash App is $Big D Rants to support the show. You can also use the playlist to help me get my watch hours up. So thank you so much to all of the new viewers, the new subscribers, the new watchers. Thank you to everyone who's donated. I think this is the first time I've seen Yoni in the Dad channel. Thank you for coming through. Chase White, thank you for coming through. It's the first time I've seen you. I really appreciate it. Make sure you guys subscribe. Make sure you guys subscribe. We will be following this case. We follow a lot of court cases. Miss V, what's up, Miss V? Miss V got something else to say? You want to come up before I get out of here? You know I've been on this thing a long time, Miss V. I need to go stretch my legs. What's up? Miss V said, yo. Miss V said, yo. Sad truth, this happens every single day in courtrooms throughout this country. You would have to indict every single rapper that ever rapped about gang culture. Facts. And you would have to indict all the owners. And she didn't indict Jack Harlow. She did. I said if you would have raided Jack Harlow's house, just because he white don't mean he don't smoke weed or have a gun. I bet dollars to donuts that if you would have raided Jack Harlow's house, that he would have had weed and guns in the house. And weed is illegal in Atlanta. If Jack Harlow was not in California, if you would have raided his house, you would have found weed, pills, and guns. He is a rapper. Just because he's white don't mean he don't do the same thing we do. We American. It's an American hip hop culture. If she would have raided Jack Harlow's house, she would have found weed, guns, and pills. Just like if you would have raided Lyle Cohen's assets and finances, you would find some. If you would have raided Kevin Lyle, you would find some. That's why the feds ain't came in. That's why the feds ain't came in, because the feds don't want to go and fight with Lyle Cohen. The feds know they got to be prepared for that type of fight. Do we want to arrest Lyle Cohen? And why would we? The feds don't. The feds be playing the game. Unless there's something that they want from Lyle Cohen, they're not going to bring a case against him. In a federal RICO case, you would have to bring in Lyle Cohen. You would have to. That's why the feds are not charging the RICO. Kevin Lyles volunteered to testify because he knows what this is. This is a RICO case. And I own YSL. I gave it to him. Why Kevin Lyles flew there from out of state? This man worth $100 million. You know why? This is a RICO case. I own YSL. That's why he flew there. You know why he there? Lyle Cohen told his bitch ass, go to the court case. You know who on the phone right now? Lyle Cohen. This shit ain't over. This shit ain't over. Thank you for coming through. Pink, blue, pink water. I don't know what's going on today. I don't know what's going on today. This is what it is, I guess. Mrs. Perfect Timing, your husband is a YouTuber. Hey, Mrs. Perfect Timing, did you know your husband was a celebrity YouTuber? I love you. Hey, I'm going to pray for everybody in the chat. I pray a covering over everybody in the chat. Hey, I pray that you have a blessed day. Hey, can we say a prayer for Jeffrey's children? You know, they lost their mother. They lost their father. Everyone who's lost their lives in this case, I pray for the families in Atlanta. This is all Black people. It's Black Hollywood, Black utopia. Black mayor, Black judge, Black district attorney, Black principals, Black teachers. You know, I think we could do better as Black people. We're producing the Young Thugs. We're producing the YFN Lucci's. And we have to fix our own problems, just like every other community and culture. And throwing them in the white man's jail is not fixing the problem. It's not dealing with single mothers. It's not dealing with welfare. It's not dealing with WIC and all of these mothers who don't have formula. 80% of the formula is low income and paid for by the government. You got these Similac babies. You got to talk about breastfeeding. You got to talk about families. You got to talk about fathers, or you're going to get another young thug. That's just the facts. If we don't deal with Black women in the Black family, if we don't encourage Black women to be married, to be committed, to breastfeed, to be healthy eaters, to be in shape, because what you eat, it dictates your behavior, because what you eat, you feed your kids. And this is how they behave. You're not even breastfeeding your children, right? I think we got to be hard on Black women. Black women been running these houses and running the show, and every time I bring it up, black women say, well, what about black men? Well, black men not in charge. Black men haven't been in charge for 50 years. This problem has been created by black women, and it's time for black men to call them to the carpet and be hard on black women about the decisions that they made and the mess that they created. And now that we have this problem with deadbeat moms, what you want to do is throw away your kids. That happened to me. In 1993, the crime bill, my mama was on crack. My mama created, just like every other mother, she wasn't a parent. So she created these children like Kyle Rittenhouse, who needed to look for their own masculinity, but didn't have fathers. Kyle Rittenhouse was walking around 2 o'clock in the morning with a machine gun, just like every other black boy. Kyle Rittenhouse is free. Kyle Rittenhouse said I was protecting my community. Well, guess what a gang member is doing? A gang member is protecting his community. My $1 million spot. I got to protect this because this is how I pay my rent and I buy my food. Kyle Rittenhouse was allowed to protect this community, but young black men who are walking around with a machine gun at 2 o'clock in the morning who might kill 2 people, they go to jail. Jeffrey is on RICO. And it's a black woman who's doing it. It's a black woman who's doing it. It's a black woman, a black mother who's saying, the way I fix this problem is I kill my son. Roe versus Wade, it's a black mother saying, the way I fix this problem is I just get rid of it. Hit the Cash App, please. Subscribe, please. Thank you. I love you. Good night. God bless you. I see you tomorrow.